How are you? All right. Did you have a good weekend? Good. Mr. Bate, your monitor's not working, not your personal, but that one in front of you?
That's correct, sir.
Okay. All right, now is it on?
Yes, sir.
All right, look at that. All right. Are you ready for Mr. Hall to come on out? My thought is we'll bring him out in a second and get on the record. My thought is we'll get on the record that we're waiting for Juror 5, and we can talk more about the question of immunity hearing testimony and its admissibility during the trial, and then anything else we need to have come up. So if you're ready, let's get Mr. Hall out here, please. After all that, no more Mr. Hiles? Did you sit through jury selection?
Yeah.
Okay.
The moment. Interesting set of circumstances.
Is he all right?
He's fine.
Okay. Something's going on in 1C, this I know. So he's not right, is he?
No, Shannon Jackson was yeah.
Okay. All right, let's get on the record in State versus Hall. It's 22 SC 184215. It is Monday, December 11th, a little after 9 o'clock, and we are set to begin the evidentiary phase of Mr. Hall's trial. Mr. Hall is here with his lawyers. Good morning, Mr. Hall. I'm all right. Ms. Feely, could you move the microphone? You can leave it off if you want, but let's just have it bent towards you all so that when you do turn it on, everyone will be able to hear that. And we have Mr. Abate and Mr. Rao here for the state. We are missing one juror, at least as of a few minutes ago, juror number 5 from our list. We have been trying to call him. We'll keep trying. We have a few things we need to cover, so we're not stuck waiting just on him. I asked the lawyers for both sides to share with me their thoughts based on case law, statutes, whatnot, concerning the admissibility of Mr. Hall's testimony from his immunity hearing. And I got an email from Ms. Feely to get it started. And then Mr. Abate sent something later on Friday. I did a little homework and pushed some cases back to the lawyers. Ms. Feely, I'm going to let you get on the record. Anything you want to beyond what it's not in the record, the email you sent, it's in my personal record, but it's not in the record for the case. But anything you want to get on the record concerning the admissibility or not of testimony. And this is, to frame it correctly, first, just the threshold question: does anything Mr. Hall said during his immunity hearing come in as evidence in this case? And if so, when would that be? I appreciate that there are individual parts that might be 403, or it was going to be 404B and you didn't get notice. Set that aside. This is writ large. Would any of it come in? Let's say he said during the immunity hearing, I shot him and I meant to, and it was not self-defense. State wants to get that in. Do they get to get it in? And if not, why not?
Sure. So I understand the court's position. I just want to place on the record what was in my email, which is it's our position that it would not come in under 84 because Mr. Hall at this point is not available. The state won't know that until he gets an opportunity to decide whether to testify or not. We also are positioned that it would come in under 87. We weren't taking this. That requires notice.
Okay. So on the 804 piece, how is this different from if your client, if Mr. Hall had sat down with the police and given a statement, no Miranda issues, he was Mirandized or he wasn't in custody, but set aside that constitutional, Fifth Amendment concern. How is this different? Because routinely, the state admits through the detective who did the interview what a defendant says, because, and it's not hearsay for several reasons. It's the statement of a party opponent, and maybe it's a statement against interest, but in particular, the state can't call the defendant, and they don't need to wait to see if the defendant testifies. It's not the case that we wait till the defense rests, and only then can the state say, all right, now I'm gonna call the lead detective. Did you interview? Did you Mirandize him? Yep. Is this the waiver? He signed it. Now we're gonna play it. It always comes in the case in chief, and you've never objected to that. And it's never been ineffective that you didn't object to it. How is this different from that?
I think that was the bulk of what when we get on record on that.
Okay.
In terms of it being a sworn statement, but given for purposes that we're not trying.
Okay, understood. Mr. Bate, question for you. Is there any harm, because we are in, let me take a step back. Helpful submissions from both sides. I did some homework of my own. There is controlling case law from all the way up from the US Supreme Court that if a defendant testifies in a motion to suppress in order to establish standing, et cetera, that cannot be used against him in his trial unless he testifies, and then he can be impeached with it, et cetera. But that seems to be the one exception to, and it's not because of hearsay. It wasn't, the Supreme Court didn't say, oh, and 804 or 807, the magic language was a defendant shouldn't be forced to sacrifice one constitutional right to protect another, fourth and fifth. If there was an unreasonable search or seizure, he ought to be able to take the stand to attack that unreasonable search or seizure without running the risk of having waived his Fifth Amendment right to not incriminate himself. Outside that narrow circumstance of testifying in support of a motion to suppress, I didn't find any case law that says a defendant who testifies or gives a statement to law enforcement has some protection against that being admitted, and really only opens the door if he testifies for purposes of impeachment. It was only the Simmons case, 390 U.S. 377, that says in the context of a suppression hearing, defendant can testify, and that testimony can only be used if later on he testifies in a hearing or at a trial, and then he can be impeached with it. But testimony from a bond hearing, testimony from a probation revocation hearing, and then obviously statements that are given to law enforcement if they're constitutionally obtained. Those are all things the state can use in its case in chief, not hearsay, because they are either statements against interest, a party opponent, they're non-hearsay. And our Supreme Court, Georgia Supreme Court, has routinely affirmed the use of defendant statements. They're not excluded by hearsay. And just the Williams case at 313 Georgia 325 from just last year is the most recent of an almost infinitely long list of cases that say that it's not hearsay. It's 801 D2A because it's an admission offered against the party that made it. So the only thing that makes me struggle a little bit, and I want you to address it, please, Mr. Abate, is that this was an immunity hearing, and in some instances, really the only way a defendant can mount an immunity hearing is to testify. I don't know, you have a constitutional right to have a judge assess your immunity motion, but if you're stuck with this dilemma that Simmons says a defendant shouldn't be stuck with, I want to seek to suppress this, so I have to testify. You can do that and not get beat up at your trial unless you testify. And so I think you can see how this has shades of that, but I couldn't find any case that says immunity hearing testimony is akin to suppression hearing testimony in the Simmons area, and so it can only be used if a defendant testifies.
So I would start with the analysis that Your Honor started with when you began talking about this issue today and on Friday, that the main difference is that this doesn't involve a constitutional right, one. Two, what I would say to the court is, in order for a defendant to assert immunity and to present evidence is not only through the defendant's testimony. There are other avenues in which, in many circumstances, in which the defendant can assert that claim through other witnesses, through physical evidence, through officers.
Hold on one second. Hey, are you coming back? Do we have a sense of what's going on? Okay. Thank you. Sorry.
Through officers and other witnesses who are on scene, here a video as well. So that would be my assertion, or I guess my answer to your question about the assertion that this would be a quasi situation like the one you described as it relates to a constitutional right, and the testimony that would come out during that hearing would not be, I guess, allowed. What I would submit to the court is an immunity motion is unlike a motion to suppress. It's almost what I would describe as a mini trial. And if the defendant's statement was not allowed to be, sworn statement was not allowed to be used against a defendant after they assert the right to immunity or their claim to immunity, and would say in this, like in this situation, it's not granted, then every defendant in every courtroom and every courthouse in the United States would assert the right or the claim to immunity and have a free shot at lying to the judge or coming up with some sort of story. And if that doesn't work, wouldn't be used against him or her, and they'd be able to concoct some other story. So that would be my answer to the questions Your Honor has posed.
Okay, well, you basically rewrote the dissent in Simmons. Simmons was not a unanimous U.S. Supreme Court, and that was the dissent. Is this a ridiculous rule? Because then you can come in and tell one story, see if it works, and if it doesn't, try something else later on. That's not what I'm concerned about here. I suspect that if Mr. Hall were to testify in his trial, his testimony would be very consistent with what he said in the immunity hearing, but that's also not the question that's before me. The objection that was raised last week and that was amplified in the email and then perfected today by Ms. Feely is a hearsay objection, 804, and I'm going to overrule that. That does, though, mean we need to navigate if there are parts of Mr. Hall's testimony from his immunity hearing that the state's going to use. And what you shared with us last week, Mr. Abate, is that your plan wasn't to either tender the transcript or have some role playing where people read, question, answer, but to actually play the video so that the jurors could hear specifically from Mr. Hall what he had to say about the questions that were asked. Ms. Feely, were there, I know one concern you raised beyond the threshold of 804, which we've cleared now, was that there were some prior difficulties. And if I'm remembering correctly, these would be difficulties between Mr. Hall and the woman with whom he was living, not with Mr. Blunt. Am I misremembering? Or it's that we received testimony about the fact that, I'm not remembering her name. What's the last name? Miss Stuckey, that Mr. Hall and Miss Stuckey didn't always have a super quiet, peaceful relationship, which explained why Mr. Blunt was coming upstairs and maybe was a little concerned about having the little girl stay with Miss Stuckey, depending on how Miss Stuckey and Mr. Hall were doing that evening. Were there other areas beyond that that you were concerned about?
I don't think so, and that includes, there was a mention of him being arrested in Puerto Rico, which is a case that was never prosecuted to my knowledge, and just all of that is so incredibly character and prejudicial. I also wanted to go back and just put a couple more things on the record about the 804.
Sure. Is your microphone on? If you could get it on.
Thank you.
Thank you.
But it's our position that this is much more akin to a suppression hearing than it is to a bond hearing or probation hearing. And we're going to ask if the court would grant a continuing objection, so we don't have to object
Sure.
over and over again to that.
You don't?
And as well, we request that it be mentioned as a prior hearing and not a failed immunity hearing or anything like that.
Right.
But in terms of we very strongly object to the state actually using the YouTube video where Mr. Hall is in his Fulton County Jail outfit, as well as what the court already noted about the prior difficulties.
Okay. I hadn't thought about attire. Certainly references to the testimony would be testimony at a prior hearing. And it's not relevant what that was. We think number 5 showed up? He's here. Great. Excellent. Thank you. Mr. Abate, what are your thoughts about using the audio but not the video? I have a concern too. I hadn't thought about Mr. Hall's dressed nicely now. I sort of assume that's how he's always dressed, and he's not. He would have been in the orange or blue or whatever.
And if I could interrupt just briefly, we also have another option. Ms. Rivers got us the transcript over the weekend, so that could be used instead.
No, I understood that there was a transcript option, and the state, I think, articulated last week why they didn't want to use it. I don't think I can compel, well, I'm not going to compel them to use one over the other unless the only way they could figure out how to do, I'm gonna call it the live version, would be to show the video of Mr. Hall on the stand. And I'm not gonna allow the jury to see Mr. Hall in the jail clothes, because that's just not a relevant piece of his testimony. What's relevant would be the things he said and not how he, I mean, arguably it could be how he looked from the shoulders up when he was saying those things, but that's not a piece they'll be able to get unless they have magical technical abilities that would basically just show from the throat up. And I'm guessing that's not how it's going to play out. So if it's not going to be the video part, your preference would still be the audio over reenacting the testimony.
Yes, Your Honor. I would, I guess, submit to the court that it's not going to be a secret the defendant was arrested for the crimes in which he committed. When the actual prior hearing was, the jury will, the jury would need to know. But the reason I bring that up to the court is that at times during the prior hearing, the defendant acts things out. He goes through photographs and points to things and things of that nature. I understand that may be less important, that the audio is the more important part. But I would submit to the court that the defendant's character, being incidentally put into the trial is something that the courts have allowed time and time again. But I don't disagree with the court that the audio is better than nothing.
a number of the defense concerns are mitigated or made moot if Mr. Hall testifies in this trial. If I make a ruling that you will be able to play the relevant non-403 violative portions of the immunity hearing to the jury before the evidence is closed. In other words, I let you reopen your evidence if Mr. Hall, the trick box you're in, and the reason why I'm not finding he is available, because you cannot call him. I disagree that Mr. Hall is available. He is unavailable constitutionally, which is why defendant statements, if constitutionally obtained, come in all the time in criminal proceedings. And the public defender's appellate section knows that. But I understand what Ms. Feely is doing. But one of the concerns that comes up in the line of cases, and that one of the things Ms. Feely had flagged is, if Mr. Hall testifies, then a lot of the how could it be hearsay, and or it is hearsay, or it's introducing things that otherwise aren't relevant, all that goes away if Mr. Hall testifies, because then it's impeachment. And then I'm less concerned about what he's wearing, because we talk about long ago he testified at a hearing. Don't worry about that. If what I decide is that you will be able to play it, but let's just save it until the defense rests or until Mr. Hall's on the stand. I mean, in theory, you could play some of it while he's testifying if you wanted to. Does that fundamentally affect the way in which you were hoping to present the evidence? In other words, yes, you can play it. Let's set aside the ruling on whether you can put in a question about were you ever arrested in Puerto Rico. If I just ask you to wait until the defense rests to do that, how does that sit? Well, I guess I need to be clear. Either the defense rests, meaning they put up nothing, or if Mr. Hall testifies, obviously you could use it during his testimony. And then if the only thing the state puts up is Mr. Hall's testimony, it would again be after they rest. You'd say, great, we're going to now call in whoever would lay the foundation for that testimony, and then you'd play the parts that you think are relevant.
I think.
Why don't you think about it? Because I'm not precluding you in your opening from talking about the fact that however you were going to weave it into your opening, that Mr. Hall has previously told us X and Y and Z. You can talk about that because his statement's coming in. His testimony is coming in. Now we're talking about format, video, audio, transcript only, and then timing. End of trial after we see whether he testified or not, which would remove some of the objections that I've overruled, but would make them doubly moot, versus actually it's the third thing you hope to do today.
Okay. Let me mull it over, I guess.
Okay.
And then I can,
we'll talk about it during the first break. As long as it wasn't going to be something that was going to happen before the first break,
no.
Then ponder that.
I don't think it'll be something that happens today. I think this will be more of a tomorrow issue.
Okay. Then we'll be sure to talk about it again. Now that Ms. Feely, you know it's coming in, if you could make a list of the Puerto Rico arrest, the prior difficulties, the things that you think ought not to come in despite my ruling. So yes, judge, over defense objection, it's coming in. But here are some categories that wouldn't come in, even if this were the routine down at the station house, waived his Miranda rights, and is giving a statement. Because things are often redacted because they stray into irrelevant or unduly prejudicial areas.
Yes.
Okay, great. Did you have anything else, Ms. Feely, you wanted to work through before we bring the jury out?
Do we need to talk about the ballistics report?
Yes,
Situation?
we do. Anything else?
I believe that was it.
Okay. Well, let me start with you on the ballistics piece. Let me pull up Mr. Abate's last email. So Mr. Abate, proposed a stipulation in section 3 of his email. And why don't I do this? So it's on the big screen now as well. And it is, it's this. I can't draw very well because there's something blocking my, but I think you see it. What was your reaction to that, Ms. Feely? That to me accurately summarized the salient parts of Mr. Jarvis's report. It steered away from the area that I was struggling with, which is, oh, and there's another gun and I didn't test it because we don't have testimony about that. We don't know what he would say about that. It limits itself to this is a distillation of the report.
Yes, we are fine with that stipulation.
Okay. Mr. Abate, did you want to, we don't need it for this morning, turn that into an actual document that would be admitted as the stipulation of the parties?
Yes.
Okay.
I will put that in a Word document and bring, or send it to the court as well and counsel, and I'll have it printed by lunch. Okay. Plenty of time. Anything else then? I don't think you are precluded, Ms. Feely, from doing what you often do and often do effectively, which is, did this happen? Did this happen? And someone other than Mr. Jarvis will need to answer those questions. You don't get to ask them of Mr. Jarvis, obviously, and he doesn't get to explain why something didn't happen because he's not here. But that's the balance we're striking so that we know we're going forward with the trial. And we're also getting in the fairly incontrovertible evidence that he would have presented. So I don't view you as being precluded from asking other witnesses, well, what did you do? Apparently there's another gun recovered. And what did you do with that? What did you not do with that? And they're going to say what they have to say. And you're free to argue it didn't get tested because it didn't get tested. And the state, through whatever witnesses they can come up with, are going to try to push back on that argument. Not that it didn't get tested, because it didn't, but why that's unremarkable. Okay. Do you have any other concerns about we'll call it the Jarvis report?
No.
Okay, then we'll get this stipulation typed up, get everyone to sign it if it remains something mutually agreeable. And if not, bring it to my attention and we'll work through it. Anything else from the defense?
No.
Mr. Abate, anything else from the state at this time?
Just briefly, Your Honor, as it relates to the issue, I would do an oral motion and eliminate to preclude any mention of what happened to the apartment that Ms. Stuckey owned after the incident occurred, well after the time the defendant had actually fled from the apartment, and the evidence would show never came back. I would submit to the court that it's not relevant under 401, and it's also not, I would say that it's also not admissible under 403 when doing the balancing test required by 403 as it relates to its admissibility, any mention of it and its admissibility.
And refresh my recollection to what happened to Ms. Stuckey's apartment after you say Mr. Hall was in another state.
It was vandalized, spray painted by who we believe to be members of the victim's friends and family due to their reaction to, their immediate reaction to the loss of a loved one and a close friend.
And timeline, if Mr. Blunt was shot and killed on day 1, I'm remembering Mr. Hall was gone from the state, maybe by day 2, day 3, you'll tell me when that was. How many days later was the supposed vandalism of Ms. Stuckey's apartment?
So it would be, day 1 is April 30th. So this incident, the shooting occurs a little after 10 o'clock on April 30th. Police arrive and begin their investigation into the May 1st. After the police have, I guess, discharged the scene and left, cleared the scene and left, it's later that day on May 1st, when nobody is home, that the apartment is vandalized.
And what is the evidence you're gonna have that Mr. Hall was far, far away? I don't mean that he was in Cobb County, but that he was in Cuyahoga County in Ohio by that time.
Well, his own testimony said that he, I believe during the immunity motion, indicated that it was day 2. So it would have been later on into, I guess, May 2nd when he had arrived in Ohio. So I would submit to the court that while all of this is occurring, he never comes back to the apartment, and there's no evidence that he knew about it until Ms. Stuckey spoke to him over the phone.
Okay, so I guess that's the bridge. Let me turn to you, Ms. Feely. I understand you may not oppose the motion, but if you do, how do you make it relevant? If Mr. Hall doesn't learn about what happened to Ms. Stuckey's apartment until he's already in Ohio, am I right about the state? Is it Ohio, that he's in Ohio? Then how is that relevant? Because he's already left.
Sure. So I think the state makes it relevant because they want to argue that Mr. Hall leaving the state was because of consciousness of guilt, which I'm sure they're going to argue. But the real reason was because he was afraid. And this shows why he should have been afraid.
Well, should have been, but if he left because he was afraid, and this happened after he left, it's sort of bias confirmation, but it wouldn't be a reason for him to have left. I don't know the timeline, and maybe Ms. Stuckey is going to be able to talk about that. I guess my direction is in your opening, don't mention that the apartment was vandalized. If Ms. Stuckey testifies during your cross-examination of her, we may reach a point where we need to take a break because you then want to go there, and we'll see what's been established about where Mr. Hall was or wasn't by that point, because the timeline is a lot tighter than I thought initially from the way Mr. Abate presented it, that Mr. Hall may not have been in Ohio when Ms. Stuckey said, this just happened to our place, not just her place, our place.
Right. And I think vandalized is one word for it. It was ransacked. The people obviously were not coming there to chit chat. So I think it was very intimidating. And
I'm not minimizing the impact it would have on someone, and people can pick their words. It wasn't shot up because that's what I was worried I was going to hear. And that's more problematic and certainly more frightening if it was riddled with bullets, but this is still something that could be disconcerting, certainly to Ms. Stuckey and perhaps to Mr. Hall as well. Okay, so I'm going to put that on my list of not quite resolved yet either, but let's not dive into it in openings. Anything else, Mr. Bate?
No, Your Honor.
Okay, how are we doing with that? It's on, great, okay, thank you. We'll reach out if it stops being on. Are there cords anyone's going to trip over? No? We're good. Okay, all our jurors are ready? Can you, Mr. Hall, can you help him with his collar? It's a button down. If he buttons the collar down, it'll work a lot. I just want you to look. No, you're fine. Just he needs to button. One of you can help. It's a button down collar, and if you, there. Great. Thank you. Last thing before we bring the jurors in, I want to say good morning to folks in the gallery. Again, you are welcome to be here. Today is not jury selection. Today, the presentation of evidence will start. If at any point during these proceedings you think you need to take a break, that is fine. Just quietly leave the courtroom. But folks need to maintain composure in court, not direct any feelings, good, bad, or ugly, towards anyone, whether that's hall or jury or whatever. So again, you are welcome to be here, but I'm going to ask you to be monitoring how you're feeling and to step outside if you need to do that. Thank you. Let's bring the jurors in, please. Everybody's out there. With the exception of Cunningham. Cunningham doing business. I know, I'm just saying. But everybody else out there, that's what I'm saying. Gotham said it's gonna tell you, so there's a kind of workaround. We got people listening to this. Said you may want to the judge.
Who said that?
Probably not his character, but we'll be able to get out that he had one and what it was.
All right, so jury. Jury President of the County Court.
Thank you, Deputy Gordon. You all can be seated. Good morning, ladies and gentlemen. Good to see your faces back. It's been a little bit. I appreciate most of you being on time, but we're all here now, and I'm sure tomorrow morning, folks who had trouble making it by 9 will figure out how to get here a little bit earlier. The good news is we weren't stuck waiting on you. You waited on us a little bit because we had a few legal matters that we started tackling at 9 when everyone here was ready to go. But a cardinal rule is that we cannot do anything without all 14 of you. So if someone is stuck running late, call my chambers to say, here's the situation, so we don't panic, and we can let those who were here on time know, hey, it's gonna be 10 more minutes, juror X is running a little late, and when he or she comes in, you can give them the razzmatazz so that they're there on time next time. But I hope you all had a good 3-day break and a good weekend. We are set to start the trial. Before we can do that, I need to give you a little bit of logistical information, give you the juror oath. You took an oath on Thursday for potential jurors. This is the real deal since you are real jurors now. And then I need to give you a little bit of legal instruction. Most of what I'm going to share with you about the law comes at the end of the trial when I give you the elements of the charges, etc. But I do need to give you a little legal orientation. And then I'll be quiet and the lawyers will start their presentations. First, about logistics. Your new home away from home is that jury room. That is your space.
No one else is going to be in there. The refrigerator should have bottled water. That's for you. There's one of those cake cuppy machines. That's for you. If you don't like our selection of government purchased K-Cups, bring your own. You're welcome to bring water out here. Don't bring anything out here, which if you spill would, this carpet is a bizarre color. Probably nothing would show up other than like whiteout on there, but you bring water out. Don't bring spaghetti sauce out here. You can use that fridge for your own stuff if you choose to bring your own food. And I don't know if they're there yet. There'll be this nice little Goldilocks white basket with snacks. That's for you, not for me. So have at them. And if you're running low on anything, let someone from my team know. And if we've got more, we'll restock that. So that's just to make it as comfortable as can be. When we're on break, you'll be in that jury room, which has 2 bathrooms. So you should have all your needs met in that way. But you also can use that long hallway back there. That's the chambers hallway. So don't go down there and play the tuba because it's judges' offices. And if you're loud, they'll figure out whose jurors they were and then they come yell at me. But it's fine to walk all the way down there and you want to take a phone call and see some actual daylight. Feel free to spread out in the hallway. But ultimately, make sure you're back in the jury room so we can get you in here when breaks are over. We're going to run from 9 to 5-ish each day. And I say ish because we can't start till you're all here. 5 is not a hard stop. There's not a light that goes on and then you get pushed out of here. But it's close to a hard stop because you've got other things you need to do. And so what I'll do when we're getting close to 5 is ask whichever lawyer is asking questions of whichever witness is at the witness stand. Hey, how much more do you have? And if the person says, I only have 15 more minutes, and that's a credible, these lawyers are very credible. Where you will find they are optimistic is their estimates of time. Just be very brief, Judge. You're going to hear this from these lawyers very briefly. 30 minutes later, we're still being brief. But if we think it really is only 15 more minutes and it's 4:55, I'll say, you know what, we're going to just finish this witness. So she can go home, doesn't need to come back the next day. But otherwise, I am protective of your schedule. And so we will stop as close to 5 as we can. The flip side is it may be that at 4:50, when I say how much more time do you have, and the lawyer says it's 2 hours, I'll say we're at a natural break point and we end a little early. You go home a little early or leave here a little early. Most days will be 9 to 5. I will remind you on Tuesday when we wrap up, Wednesday is an exception to that. We cannot start until 1 on Wednesday. I mentioned, I'm not requiring you to remember, but I'm one of the drug court judges. And so I have drug court Wednesday morning. You can come, you can watch, but it won't be this case. I'll be working with a bunch of clients in drug court. We're usually done by noon, 12:30, but we'll start 1. You will not get a lunch break that day. You should have already had your lunch, be here by 1. Ideally, we'll go till 6, but I'm telling you now so you can check your schedules. And your commitment was 9 to 5. So if you've got childcare, dog care, husband or wife care, and cannot stay till 6, then that day will just be 1 to 5. But ideally, we'd run at 1 to 6 to try to catch up a little bit for the time we're losing Wednesday morning. None of this changes that estimate I shared with you last week that the lawyers think that you'll probably get the case, meaning all the evidence will be in and you'll have heard the law from me and you'll be able to begin your deliberations maybe late Wednesday, sometime on Thursday. So this Wednesday half day has already been factored in. We will take breaks, planned dish breaks, 1 in the morning, 1 in the afternoon, and a lunch break of about an hour. Tomorrow's lunch break will be a little bit longer. Those are the regular breaks. We'll also take a break whenever one of you needs it. If we've been gone for a while and you need to use the restroom, or it's just like I'm having trouble focusing because it's difficult to process or it's tedious, let me know. Raise your hand. Deputy Gordon will see you. Raise your hand. And if we just need to quickie 2 minutes, I want to walk up the hallway and back, we'll do that. You need to be dialed in throughout this. And so if you feel yourself dialing out and a break would help, raise your hand or signal the deputy and we'll take that break. Usually the big morning and big afternoon breaks are enough, but things come up. So let me know. All right. Last thing before I give you the oath. You are our jurors now. The only way you will be interacting with the lawyers in this case until the trial is over is when we're all in court, and I'm here to mediate all that. So When you're on your lunch break and you're walking out of the building and you're not quite sure, do I go left to the restaurant or right? And you bump into Ms. Feely or Mr. Rao, and they treat you like you've got the plague. They're doing what they're supposed to do, which is to not interact with you. You can imagine how it would look to a lawyer from the other side if three of you are talking it up with one of the lawyers and they're wondering, wait, why is this lawyer talking to these jurors? They need to leave you alone. Other than here in court, they're going to get plenty of time to talk to you during court. So don't hold it against the lawyers for either side if they kind of move away from you, if they encounter you in a hallway. It's perfectly natural for you to be in the same space, but they need to not interact. Even if it's just an innocent question like, hey, where's the bathroom? Ask the deputies, ask someone from my staff. If you bump into me, I can interact with you. I'm not an advocate in this case, but they're advocates. And so when they are talking to you, the other side needs to hear what it is they are saying to you. So they can say, that's not right. The bathroom's in the other direction. Not guilty, whatever it is they want to argue. So please know that they just need to give you your distance until the trial is over. All right. If you don't mind standing and raising your right hand, I'm going to give you your official juror oath. All right. Do you swear or affirm that you shall fairly try this case between the state of Georgia and Jason Hall, who is charged with murder, felony murder, aggravated assault, and a firearms offense, and base your verdict solely on the evidence? Does everyone so swear or affirm?
Yes.
Does anyone not so swear or affirm? All right. Thank you. You are officially jurors. And I'm going to now give you a few legal and procedural instructions. Not many of you, if any of you, have been jurors before. So what you know about jury service is based on what you've seen on TV. And that's not what really happens in court. This is the real deal. They're going to be real people at the witness stand. We've got real lawyers. And it's not going to be that someone bursts through the door in the middle of trial and says, I did it. I can solve the crime for you. It's going to be these witnesses who testify, and you're going to struggle with things that are less clear than you want them to be. And as a group, figure out, has the state met its burden of proving the defendant's guilt beyond a reasonable doubt? First thing, note taking. You are free to take notes. That's why we gave you the notepad. So you can write down anything you want. Caution, don't try to write everything down. You can't. It's not humanly possible, and you will miss out on important things. One of your roles is to determine the credibility or believability of witnesses. And one way humans do that is by watching other people talk and react. And you will miss that witness X, when receiving questions from one side, is open and chummy and looking at you guys and making eye contact. And when getting questions from the other side, suddenly starts sweating and won't make eye contact with anyone and is fidgety. Maybe that means nothing at all, but maybe it means a whole lot to you. And guess what you don't notice if you're trying to write down, okay, what did he say? What did he say? Don't try to write everything down. Don't write anything down if you don't want to. Note taking is not required, but it is authorized. So you can write what you write. Some folks listen better if they're sketching. You can sketch what you sketch. Your notes are private. I mean that in two ways. Until you begin your deliberations, don't share with anyone else in your group what you wrote down. Two, once you're deliberating, you can share it with everyone. But when the trial is over, we will shred the notes. They're not made part of the record. I won't post them on my website. Like, hey, someone drew this bad picture of the judge. That won't happen. They will literally be destroyed. And you may, proof of that, some of you may have a notepad, like this pad doesn't have all its pages. If we had a juror who only used 2 sheets in the notepad, we tear those out and we reuse the notepad so that we don't have an infinite budget for notepads. So keep them private till you deliberate, and then don't worry, we will shred them when they're done. Your notes are not evidence. They are memory aids. So because someone wrote down, hey, I wrote down that the guy said there were 4 people at the crime scene, and you remember, no, man, Jones, and there were 2 people at the crime scene. It's good that someone wrote that down, but don't be persuaded just because you can choose to be persuaded, but notes don't trump your independent recollection. The defendant, Mr. Hall, is charged in this indictment with 4 crimes. Crimes are violations of the law of Georgia. I'm going to read to you this indictment right now, the literal charging language. Don't panic if there's some legalese in it. This document will go back with you during your deliberations. This will be one of the things you can read over if you want to read over it. and I want to remind you before I dive into this, these are merely allegations. This is the way the state brings charges against someone. And Mr. Hall has pled not guilty to these charges. By lodging that plea of not guilty, he has placed the burden squarely on the state's shoulders to prove his guilt, if they can, beyond a reasonable doubt. Count 1 charges Mr. Hall with murder, and the allegation is that here in Fulton County, on April 30th, 2022, Mr. Hall did unlawfully and with malice aforethought cause the death of Corey Blunt Jr., a human being, by shooting him with a firearm. Count 2 charges Mr. Hall with felony murder, and the allegation is that here in Fulton County, on April 30th, 2022, Mr. Hall did unlawfully, during the commission of a felony, that felony being aggravated assault with a deadly weapon, Mr. Hall caused the death of Corey Blunt Jr. by shooting him with a firearm. Count 3 charges Mr. Hall with aggravated assault with a deadly weapon. The allegation is that here in Fulton, on that same day, April 30th, 2022, Mr. Hall did unlawfully commit an assault upon the person of Corey Blunt Jr. by shooting him with a firearm, that being a deadly weapon. And finally, count 4 charges Mr. Hall with possession of a firearm during the commission of a felony. And the allegation is that here in Fulton, on April 30, 2022, Mr. Hall did unlawfully have on and within arm's reach of his person a firearm during the commission of at least one of the following felonies involving the person of another: murder, felony murder, and aggravated assault with a deadly weapon. As I've mentioned, these charges are not evidence of anything. It's how we frame the issue. Mr. Hall has entered a plea of not guilty. His plea of not guilty is not evidence of anything. It's how the issue is joined. And Mr. Hall sits before you with the presumption of innocence in his favor. And it stays with him unless and until the state has proven beyond a reasonable doubt each element of one or more of the crimes charged. And the defendant should not be convicted of any crime until those elements are proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt stays with the state throughout the trial. This does not mean, however, that the state is required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. It simply is to prove the defendant's guilt beyond a reasonable doubt, which means sort of what it says. It's a doubt that's based upon common sense and reason. It's not a vague or arbitrary or speculative doubt. It's a doubt for which a reason can be given. It's a reason that arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. The defendant has no burden of proof whatsoever. There's not a point in the trial where I say, all right, you've heard enough from the state. The defendant now needs to do something. That will never happen. He need not do anything. In fact, as I may have said on Thursday, Ms. Feely may not stand up at all during this trial and say anything. I bet she will, but she's not required to. She doesn't need to give an opening statement or a closing argument or ask any questions of the witnesses, because that would be putting a burden on the defendant, and he doesn't have one. But of course, he's got an absolute right to make a defense and have a lawyer and have that lawyer question witnesses. And that's typically what you see, is that both sides will ask questions of witnesses who are called. If, after giving careful consideration to all the evidence you receive in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit the defendant. But if no reasonable doubt exists in your mind about the defendant's guilt, you'd be authorized to convict. The basic structure of a trial is that in just a few moments, both sides will have the opportunity to give what's called an opening statement. This is a preview or an outline of what the lawyers think the evidence will be. Keep in mind that nothing at all that the lawyers say to you is evidence. They are advocates or proponents of a perspective. Evidence is going to come to you in one of, I think, 3 forms in this trial. Number 1, and the main one, is witness testimony, what someone says under oath. Not the question, isn't it true, A, B, C, D, D? The answer is evidence. Yes, no, whatever the witness says. Number 1. Number 2 is physical evidence, a photograph, a gun, whatever it might be. And then there may be stipulations in this case where the two sides agree that certain facts were proven, and that's the way the facts are shown, through a stipulation. That's the evidence, not what the lawyers say, nothing I say. I give you the law. I don't give you any evidence. But the lawyers are given a chance to give this opening where they say, well, you're going to hear this or you're not going to hear this. The evidence is strong. The evidence is weak. It's not so much argument as it is a forecast of what you'll hear. When opening statements are done, and I use plural because the defendant has a right to have his lawyer give one. She may not. That's their call. When the opening statements are done, then I'll ask Mr. Abate to call his first witness. He's going to call Fred Smith. Fred Smith comes up here. He'll be sworn in to tell the truth and nothing but the truth. Mr. Abate will ask his first question. And that first word out of Fred Smith's mouth, that's when evidence starts. That's when you start receiving evidence, when the witness starts testifying. At some point, when I ask Mr. Abate or Mr. Rao to call your next witness, they'll say, Judge, the state rests. And then the state's case in chief is complete. We'll need to take a break because there are certain legal things that typically happen after the state rests. But then I'll turn to the defense and I'll ask Ms. Feely, do you have any evidence to present? She may say no, no burden on the defense. She may say yes, and she may start calling witnesses, but she's not obligated to do anything at all. At some point, both sides will have rested, and then the lawyers get a chance to get back up and then really engage in this advocacy. That's when they give what's called a closing argument or a summation. And they're going to argue, not with you, but to you. They're going to say, here's what the evidence has shown. Here's why you should find guilty, find not guilty. Here's what the evidence didn't show. Here are problems with the state's case. There's problems with the defense argument, whatever it is. They go back and forth. They're not up at the same time. It's not a debate like that, but both sides will be given a chance to argue to you what they think the evidence has shown or failed to show. Again, not evidence. It's an effort to persuade, and that's okay, but you decide what the evidence is. When these closing arguments are done, I'll give you the law that you must apply to this case. I'll tell you what the elements of murder are and of felony murder, a little bit more about reasonable doubt, venue, things like that. And then you'll take that law that I give you, all the evidence you received, you'll go back into the jury room, and then you'll begin your deliberations. And you will decide whether the state met its burden of proof beyond a reasonable doubt. During the trial, lawyers have a right to object to the admission of evidence if they think that evidence coming in would violate some rule of evidence. This you've seen on TV before. Objection, this whole court is out of order. I don't think they'll say something quite like that, but you'll hear objection hearsay, objection relevance. I need to rule on those objections, and I'll either sustain the objection, which means put the brakes on, you need to go in a different direction, or I'll overrule the objection, which means I don't see it the way you do, lawyer who is objecting, and the lawyer who asked the question can go in the direction he or she was going. You must consider only the evidence that is admitted, which will mostly be everything, but every once in a while, a lawyer won't know because the question was fine. The lawyer hears the question from the other side, the question's fine, but a witness starts to go in a direction that is objectionable under the rules of evidence. And so a lawyer may say objection, hearsay, move to strike. And if I sustain it, I may tell you to disregard that evidence. And before you panic, it's like, how do I unring that bell? If it were fundamental to the outcome of the trial, you'll actually hear a lawyer say, Judge, I'm moving for a mistrial. Every once in a while, let it not happen in this case, something happens and you can't unring that bell. And it's not fair for me to assume if I say disregard that you could really disregard it. Then we have a different discussion outside your presence. But the run-of-the-mill move to strike is, it was very low-grade hearsay. Oh, someone told me it was raining that night. Objection, hearsay. We need to have someone who was there to say, no, I was there and it was raining. Not that Steve told me that it was raining. So I'll tell you to disregard that this witness said she heard someone say it was raining. If you wrote it down, cross it out, and we'll just move on. And you need to disregard it. And you need to police it back there in your group. If during deliberations, one of your group says, well, I wrote down that this person said he heard someone say it was raining. You say, remember, the judge said we're not supposed to rely on that. And I'll tell you what, if it was real important for you to know it was raining, someone's going to get another witness to come in and say, I was there, man, I got all wet. It messed up my hair. It was raining. And so you're not going to need to struggle with the, how do I unremember something that I heard? I mentioned motions as well. Lawyers have the right to make motions. That is much more substantive than an objection. An objection we resolve it in front of you. I may ask the lawyers, tell me a little bit more, but whatever they're saying is fine for you to hear. Every once in a while, these lawyers who pretty much know what the evidence is in this case can see a train wreck coming and they'll say, Judge, pause, I've got a motion. And I usually can see what's about to happen too. And motion is often code word for you get an extra break because they're going to need to talk about something that you can't hear because they're going to say, I think this witness is about to say these 4 things that you've already said the jury can't hear about. Obviously, they can't say that with you sitting here because then you've heard what you're not supposed to hear about. So we may need to take a break. We try to shove those into like the lunchtime or before you get here, but trials are very dynamic and something may veer in a direction where an astute lawyer realizes this is going to be a problem. Judge, we need to talk about it. And so I apologize in advance. Usually you're not sad that there are extra breaks, but there may be these unscheduled breaks. Throughout the trial, I need to rule on the objections and the motions. Nothing that I say in this trial should be viewed by you as me taking a side or showing an indication that, whoa, this is going a lot better for one side or the other, or that was a really believable witness. That is a lawyer who the evidence is all on his or her side. I am simply ruling based on the law. And so if I overrule an objection, it just means that wasn't a valid legal objection. If I sustain it, it means it was a valid legal objection. My role is simply to see that the case is fairly tried, consistent with the law. And nothing I say is meant to indicate that I have a leaning in any direction about credibility or strength of case or anything like that. You have an essential role as well. You are the fact finders. You will decide what happened on April 30th, 2022. That's your job. And you're going to make those decisions based on the evidence that you receive. In doing this, you will necessarily be deciding the credibility or believability of witnesses. And in deciding credibility, you are free to consider all the evidence you've already heard, the manner in which witnesses are testifying. Remember me telling you, don't get all caught up in your notes, but make sure you're watching these witnesses a little bit as well, so you get a feel for how she's presenting herself and how you process that. You're also free to consider the witness's interest or lack of interest in the outcome of the case. Does this witness have a stake in the outcome of the case? Because that may affect your sense of, well, how truthful is this person really being? As fact finders, you may from time to time have questions of your own. And the way that you get those questions answered will be in a moment. We're going to get some note cards out here for you. You're going to write them down. You don't raise your hand. You do not blurt the question out. But I promise you, at the end of every witness's testimony, you'll have a chance to write down questions you have on these little 3x5 note cards. We're going to have a big stack of them right there on that little shelf. And then I'll take those questions. I'll meet with the lawyers, because just like lawyers can ask legally improper or objectionable questions, jurors can too. Your question may be something that calls for hearsay. And if it does, I can't ask it of the witness. I'll accept all your questions. I'll talk about them with the lawyers. And those legally proper questions I'll ask of the witness. So you don't actually ask a witness anything, and we don't identify who asked what question. It's all anonymous. But if you couldn't understand what a witness said, she used complicated terminology, you keep saying res ipsa loquitur. What does that mean? Great question. The lawyers ought to say, ma'am, you keep saying res ipsa loquitur. What does that mean? But maybe the lawyers knew what it meant and you didn't. So you can write that down. Was it dark out? Whatever your question is, you write it down. And if it's a proper question, I'll ask it of the witnesses. You should draw no inferences or conclusions from the fact that your question didn't get asked, because questions aren't evidence. It may be a great question for you. It just may not be one that's legally proper. And so you shouldn't conclude, the judge didn't like my question, or I'm onto something with this question. It just means it was an improper question. Only what the witnesses say in response to your questions is evidence. And of course, I'm going to give the lawyers a chance to follow up, because oftentimes jurors have great questions. And the lawyer says, dang, I hadn't thought of that. And then the lawyers get a chance to follow up. You need to pay close attention to witness testimony. You will not get a transcript of their testimony. If one of your questions while you're deliberating is, hey, could we have Denise Jones's testimony? My answer is going to be, no, you can't. Because while Ms. Rivers is doing a phenomenal job of taking things down, the official transcript takes days to prepare, because she looks at what she's been typing and compares it to the recording to make sure it is an accurate transcription of what the witness has said. That won't be available for you during your deliberations. That's why you've got the notepads to write down the highlights of witness testimony. And that's why there are 14 of you, because collectively, you generally can remember what witnesses said. But it's important for you to stay focused. If you lose that focus and need a break, let me know and we'll take that break. Don't rely on a transcript that you're not going to get when the trial's over. It's also important that you view the evidence with an open mind. You may hear second witness from the state. Oh my gosh, I know what happened here. But you really don't, because first of all, you don't even know the law. You don't know what the state has to prove murder. So you may begin to form impressions, but it is important that you keep those internal. When you're on your first lunch break, it's okay if you guys have lunch together. You're not required to have lunch together, but if you go in groups of 3 or 4, don't talk about the case while you're having lunch and say, man, I've already decided what I think about this. You shouldn't decide that early. You haven't heard the whole story. And you shouldn't start solidifying whatever that is by talking with a colleague. You will have as much time as you need for your deliberations when we get to that point. So inside you may be thinking, but as a group, don't start working through the tricky parts until you've received everything, to include that law that I give you. That may resolve some of your questions, like how on earth, that's not even an element of murder. The state doesn't need to prove motive. So we don't need to worry why something happened, because that's not one of the things the state has to prove. This prohibition on talking about the case until you begin your deliberations is actually a 24/7 prohibition. When you go home tonight and your loved one or your not loved one or whoever you live with, your plant, your pet, like, hey, how was your day? You're welcome to say the day was great, but leave it at that. Well-meaning people are going to say, let me tell you when I had jury duty. Oh, did that happen to you? Let me tell you what that means. When the judge says this, it really means that. Or, oh, the state didn't give you that evidence. That's a bad sign for the state. It's not a sign of anything. That's what that person experienced in her trial, which is not your trial. So it may be a little difficult, although my guess is you're going to want to just think and talk about other things. But when you get home, don't engage with folks about what you saw and learned today. Obviously, don't do any outside research, which is something I'm going to tell you a billion times. Do not get online and look something up. That's why you can ask questions. If you don't understand the layout of the scene, then someone needs to get you a picture if they're pictures and ask, is there a picture of the couch if the couch is important? Don't go online to try to look up an address to see what did this really look like? Was the lighting like? No outside research. And that's that corollary of don't talk to other people about it, because they could inadvertently give you some outside research. Oh man, I've been there and there are no streetlights there. It's so dark there. Oh, I didn't know it was dark. And you're going to come back the next day and say, hey man, I learned it's really, really dark. So when that witness said she could see everything that was happening, I don't believe that so much anymore, because my friend told me that stretch of street, they haven't had streetlights for 10 years. And I'm making all this up, but that's the kind of thing that someone innocently and eagerly would want to share with you. When the trial is over, you can talk to anyone. You can write a book about this if you want to write a book about it. But between now and then, you need to be on an information embargo, other than when you're in this courtroom, so that the lawyers have a chance to object or rebut or challenge whatever it is you are hearing and seeing about the case. Okay? That's all I've got to share with you right now. I promise I have more later. But with that, I'm going to turn to Mr. Abate or Mr. Rao and invite the state to give an opening statement.
Thank you, Judge.
You're welcome.
Good morning. On August 30th, 2022, 537 Sunset Avenue, here in Atlanta, Georgia, not far from the courthouse. Very close to the area where Mercedes-Benz Stadium is. A little after 10 p.m., this defendant shot, killed, and murdered 21-year-old Corey Blunt. The evidence is gonna show that this incident, this murder, this shooting by this defendant, he made conscious decisions on April 30th, 2022. And those decisions led to the death because of senseless gun violence, ending the life of Corey Blunt, 21 years old. His life was just getting started. Now, ladies and gentlemen, during the trial of this case, you're going to hear from several different people. You're going to hear from members of the Atlanta Police Department. You're going to hear from all of the science people, Dr. Karen Sullivan, who is a medical examiner here in Fulton County. But you're going to hear all of this from this stand right here. You're going to hear from several lay witnesses. And I want to introduce you to some of the parties that you're going to be hearing from over the course of this trial. You're going to hear from Miss Nabia Stuckey. And Miss Stuckey, you're going to learn from the evidence, lived at 537 Sunset Avenue. And she lived there with her grandson. And she had been in a relationship with the defendant, Jason Hall, for roughly 6 years. You're also going to hear from Ms. Devona Scott, who is Ms. Stuckey's daughter. The evidence is going to show that Ms. Scott had been in a relationship with Mr. Corey or Mr. Blunt, and they had been living together. They lived together not far from this area that the incident occurred. But what the evidence is going to show is that Ms. Scott also has a young daughter. And on April 30th of 2022, what Ms. Scott is going to tell you is that her and Corey were driving her daughter over to see her grandmother, Ms. Stuckey. And Ms. Scott is going to tell you is that they were driving her over. It was a little after 9:30ish, and they were taking her there because Ms. Stuckey had planned to take both her grandson, who lived with her, and Ms. Scott's daughter, her granddaughter, or Ms. Stuckey's granddaughter, to the aquarium the next day. So she was going to spend the night there. And Ms. Scott brought Corey along for the ride as she was going to drop her daughter off to go to the aquarium. And what the evidence is going to show is that this is the area where the incident occurred. This is 537 Sunset Avenue. This is the small apartment complex. And if you right over there, there's the Coca-Cola building, which is adjacent to or not far from Mercedes Benz. And what Ms. Scott is going to tell you is that they drove to the location. When they arrived, she immediately texted her mom, "We're here." And what Ms. Scott and other people are going to tell you is that this is a small apartment building with a small parking lot, and that as she drove up and as they parked and she was texting her mom that they were here, she could hear very loud arguing. And this Ms. Scott's going to tell you is not an unfamiliar thing that she had heard. She had heard it in the past as the defendant and her mom, Ms. Stuckey, had dated for the last 6 years. And as she drove up and heard this loud arguing, she didn't feel comfortable. Ms. Scott's going to tell you that she didn't feel comfortable leaving her daughter there, that this arguing was very loud and sounded tumultuous. And so her mom came down and they began to talk, and Ms. Stuckey began to explain to Ms. Scott and Mr. Corey about what was going on in the apartment, about the fact that they were arguing. Ms. Scott's going to tell you that her mom was visibly upset when she came down to get her granddaughter, to take her up. And Ms. Scott's going to tell you ultimately that she just did not feel comfortable because of the volatility of this situation. She didn't believe that her granddaughter, her daughter, would be safe with her grandmother that night because of what she heard, and her gut feelings is what she would tell you. Now, Ms. Stuckey is going to explain to you, ladies and gentlemen, that she tried to reassure her daughter, letting her know she would never let anything happen to her granddaughter. But ultimately, Ms. Scott told Ms. Stuckey, you know, I'm not gonna leave, her here, but you should come with us. Let the situation cool off. Come with us. And, Corey encouraged. Both of them are encouraging. Ms. Stuckey should just come with them. Let the situation end, let it cool off. You can come back tomorrow. Ms. Stuckey ultimately told them, no, I'm gonna stay here. This is my apartment. I've got all my stuff here. You know, I'll be okay. I just need a few minutes to stand out here and cool off. Let the situation die down. Ms. Stuckey continued to talk to Corey and her daughter, Ms. Scott, about what was going on, about the relationship. Ms. Scott's going to tell you that her mom had explained to her that she was ending the relationship and that she was soon, in May, to move out from that apartment, to get away from him, to move on with her life, so to say. And as Ms. Scott and her mom, Ms. Stuckey, are talking and about her leaving and about the situation that was occurring that night, Corey is right there. He's listening, he's engaging, he's talking to her. They're both trying to calm her down and to make her feel comfortable. And ultimately, Ms. Stuckey said, you know, I'm gonna go back up. And what the evidence will show is that Corey said, well, do you want me to walk you up? I'm gonna walk you up to make sure that everything's okay, and that ultimately you get up there and you're safe, that the situation is cooled down, and you know, nothing would happen. Ms. Stuckey said, don't, you know, I'll be fine. Again, I'll just stay out here, let the situation cool off a little more. But Corey insisted. Ms. Scott will tell you that he wanted to make sure that she was safe, that he thought of her as a mother figure. And because of that, he wanted to escort her up to her apartment. And ladies and gentlemen, what the evidence would show is that he did just that. And the evidence would show that this red car was the car actually that Corey owned, that Corey and Ms. Scott and her daughter drove to 537 Sunset Avenue 2. And in the picture at the top, this is the side staircase in the middle of the building. And that is the staircase that Corey and Ms. Stuckey walked up after they had all been conversing and trying to calm her down at the area where the red car is. And as you can see, it is not a large parking lot, and the car is close. The cars are close to this staircase that leads to several of the apartments. The apartment where Ms. Stuckey lived with her grandson and where her significant other, the defendant, stayed with her often. And what the evidence will show is that Ms. Stuckey, followed by Mr. Corey, walked up those stairs. The door was open, and an argument ensued. Ms. Stuckey will tell you that when Corey walked in, the defendant said, "What's up?" Corey said, "What's up?" And things escalated. And things escalated to, they were both yelling at each other as the defendant was in the living room area, and as the victim, Corey, was in the threshold of the door in the kitchen area. And what Ms. Stuckey will tell you is that during the argument, it got very heated. And at that point, Corey, who was armed, raised his shirt and let the defendant know that he had a gun. And as the argument ensued, what Ms. Scott will tell you is that she was still down with her daughter near the red car, sitting in the car, and could hear what was going on. And as it took longer than she expected it would for Corey to come down, she went up because she had heard the argument. And what Ms. Scott and Ms. Stuckey will both tell you is that once Ms. Scott got up to the stairs, she grabbed Corey's hand. And Ms. Stuckey helped Corey out the threshold of her home. And Ms. Scott pulling Corey towards the stairs, and the door shuts. The door shuts. And what happens after the door shuts and Corey and Miss Scott have left and are on their way to head to the stairs? 8 shots. Not 1, not 2, not 3, 4, but 8 shots. 8 shots through the door of the apartment, the closed door of the apartment that Corey had just walked out of. 8 shots. And what the evidence will show is that the defendant used his firearm with the door closed, and with Corey and Miss Scott going down the stairs, and with Miss Stuckey still in the apartment, shoots 8 times through the door. And when he shoots 8 times through the door, he hits Corey twice. As Miss Scott is actually in the threshold of the stairwell, she starts to go down with Corey's hand in hers. He gets hit. And what the evidence will show is he's hit in his right temple and in the right, or on the right side of his chest. And as he's hit, their hands release. And Miss Scott will tell you she didn't understand. She could hear and she could feel the bullets fly by. And what Miss Scott will tell you, she was actually grazed in the leg, in the side of her head, by 2 of the bullets. And she turned around and she didn't understand. She kept yelling for Corey, she'll tell you. She was yelling for Corey. Let's go, Corey, let's go. And as she comes up, she hears her mom open the door. She hears her mom screaming. And then she sees Corey laying on the landing. Right in this area, bleeding from his head, from his body. And she immediately rushes to his side. She tries to render aid. She calls 911. She's doing everything she can to talk to Corey, to keep Corey alive, she'll tell you. Ultimately, the Atlanta Police Department arrived after Miss Scott called 911. And they take over the care and the aid of Corey. But ultimately, Corey dies. He dies on the top of the landing, that apartment complex, that apartment building. He dies in front of the door. The defendant shot 8 times through, hitting Corey twice. And what the evidence will show, he not only hit Corey when he shot 8 times through the door, but his bullets traveled into the apartment across. There were 4 bullet holes in the apartment number 6, across from Miss Stuckey's apartment. 4 bullet holes in that one, where bullets traversed into that apartment. And luckily, no one was home. You'll hear from Mr. Seals, who was the occupant, one of the occupants of that night, who had just left to go get some fast food. And he'll tell you that he heard the arguing, and that when he arrived back, police were everywhere. And that he ultimately allowed them into his apartment, where he then realized that bullets had entered. And ballistics evidence was collected from his apartment and from around the scene. And what the evidence will show, ladies and gentlemen, is that the only place where shell casings were found were inside of apartment number 2. The apartment of Miss Stuckey. After the initial response from the Atlanta Police Department happens and occurs, and life-saving measures are attempted for Corey, but failed due to the defendant hitting him in the right temple of his head. Atlanta homicide response. And what the evidence is going to show, and you're going to hear from, is that lead detective assigned to the case was Detective Savannah Berry. And you're going to hear from her. She talks about her process, how she's assigned as the lead detective, and some of the steps that she took in this case as she began to investigate what occurred on April 30th, 2022. And she will tell you about some of the steps that she took in canvassing to try to talk to the occupants of the apartment building where the shooting had occurred. She will tell you about how she was present and directed the crime scene techs or tech who arrived to take pictures and to collect evidence of what occurred that night. And what Detective Berry will be able to tell you is that one of the residents had a ring camera, and it was directly diagonal from Miss Stuckey's apartment. And she was able to talk to the owner of the apartment, or the occupant of the apartment, whose ring camera it belonged to, and that night was able to see the footage from the ring camera. Now, I'm sure many of you have ring cameras, and what Detective Berry will be able to explain, and what ultimately the occupant, Mr. Cunningham, will be able to explain, is that the ring camera is motion activated, that it's not constantly recording, it's not something that was nonstop, but only recorded when there was motion. And what Detective Berry and Mr. Cunningham will tell you is that they began to go through the footage together. And the footage that they were able to find, the only footage that existed of the incident, was as the shooting began and as Corey fell, the camera activated because he fell back. He fell back towards Mr. Cunningham's apartment number 8. And as he fell back, that's when motion was activated, and you can hear the shots, and you can hear and see Corey get shot and fall to the ground. And you can see and hear the terror, the pain of Miss Scott as she goes and screams and attempts to render aid and get 911, doing all these things at once to try to save Corey. And you will see parts of that clips on the ring camera. And like I said, both Detective Berry and Mr. Cunningham will explain that they looked through all of the footage, and what was captured, Detective Berry was able to ultimately collect from Mr. Cunningham. Now, as the investigation ensued, and as Detective Berry continued to speak to other witnesses, and including taking statements from both Ms. Scott and Ms. Stuckey, what Detective Berry will ultimately tell you is she then took warrants out for the arrest of the defendant for murder, aggravated assault, and possession of a firearm, felony. And what Detective Berry will ultimately be able to explain to you and tell you is that the defendant was then arrested later in June 22nd, 2022. Now, as I mentioned earlier, you will also hear from some other professional witnesses. You'll hear from Dr. Karen Sullivan, and you're going to be presented with evidence from an analysis done by a firearms examiner named Jay Jarvis. Now, you won't be hearing from Mr. Jarvis, and you will hear as the trial goes on as to why, but you will get to see the results of the steps that he took and the processes that he took in his analysis and how he came to his ultimate conclusion. And you'll hear from Dr. Sullivan, who will tell you about the cause and the manner of death after she was able to do all of procedures that she takes when doing an autopsy. And what Dr. Sullivan will ultimately testify and tell each and every one of you, ladies and gentlemen, that the cause of death was a gunshot wound to the head, the gunshot wound to the chest, and that the manner of death was homicide. What you'll hear as it relates to the conclusions of Jay Jarvis, the firearm examiner, is that he will testify, or his report will tell you that the evidence that was collected from the scene, the ballistic evidence, was collected from the scene and tested, ultimately all came back to being fired from the defendant's firearm, which was found hidden under the couch in Ms. Steffi's apartment 2. Now, as this trial goes on, and as the judge has mentioned, there won't be a transcript that we'd be able to give to each and every one of you. It won't be recorded on, YouTube or Netflix, whatever it may be, that you can take it back with you as you deliberate and rewind and fast forward and things of that nature. And I know during this trial, you're definitely going to want to fast forward a few times as we deal with the real lives of witnesses and detectives. So what I ask is that, as the judge talked about earlier, about taking notes, because ultimately your notes are going to be your transcript. As great as Ms. Rivers is at transcribing and taking down everything we say, it's just impossible for her to be able to get that transcript to you during deliberations. So I would ask that you pay careful attention and that you take careful notes and that you listen to the witnesses and that you take notice of how the witnesses testify, their demeanor, as they talk about what they heard and what they saw. Because that's important. It's very important. And as you're doing all of that, you remember it's not the witnesses and the victim who are on trial, it's the defendant. What at times you'll see, because this didn't happen yesterday, that this isn't a memory contest. There will be times where officers or detectives will need to use their report to refresh their recollection. And that's why a report is done, so they can do just that, so they can provide each and every one of you an accurate account of what happened on April 30th of 2022. But the evidence is going to show that there was no excuse or justification for the defendant's conduct after that door closed on April 30th of 2022. What it's going to show you is that he had no regard for human life, and he was only concerned with avoiding the responsibility of the 8 shots that he shot through that door. His decisions that he made on April 30th of 2022 are going to show you that he endangered many lives and murdered Corey with zero concern or hesitation. And afterwards, he attempted to avoid being held accountable. What will be clear through the evidence as it's presented the next couple of days before each and every one of you. And the evidence is going to show that on April 30th, 2022, the defendant caused death and destruction because he had a hurt ego. Because on that night, Corey walked Miss Stuckey up those stairs to her apartment to make sure that the defendant was treating her right, to make sure that she was safe. And he checked the defendant. And he didn't like that. He didn't like it. Because in his eyes, 21-year-old was telling him, a grown man, what to do and how to treat a woman. A lesson he should have learned way before this moment when Corey had to help teach him. And as a result of that lesson that Corey tried to get through to the defendant, after his lesson was complete and door shut, Miss Scott thought she was going home with Corey and her daughter, like always. But then 8 shots through that door led to her dropping Corey's hand. The defendant killed Corey over nothing. At the end of this, ladies and gentlemen, myself, my co-counsel have an opportunity to stand before you once again. Close of all of the evidence. We'll be asking that you return a verdict. The only verdict that speaks the truth, and that's the defendant is guilty of each and every count in the indictment. Thank you for your time.
Thank you, Mr. Abate. Ms. Feely, you're going to give an opening at this time?
Yes, sir, thank you.
All right.
I'm loaded. I don't have a PowerPoint, I'm just gonna talk to you this morning. So that I can clear up the rest of the story. You heard Mr. Hall was sitting in his house, not bothering anybody, minding his own business. Like many of you said in jury selection, just watching TV on his couch in his home. Mr. Blunt, unknown, unpredictable, and armed with a deadly weapon, came in his house. Mr. Hall didn't go to Mr. Blunt's house. This wasn't mutual territory. Mr. Blunt, unknown to Mr. Hall, maybe they knew each other in passing. They weren't friends. They weren't enemies. They didn't really know each other. Unknown, unpredictable, and armed with a deadly weapon came in his home. And the state said, not only did he come in his home, he came in and checked it to teach him a lesson with a firearm. The other rest of the story here is the state's witnesses. They told you that you're going to hear from several people, but they used the term witness very generously because almost all of those people did not witness what happened on April 30th. They're valuable, DNA, fingerprints, ballistics, medical, absolutely listen to them, take notes. But none of that shows what led up to this tragedy. And I'm gonna let you know right now, we agree that this was senseless and there is no one happy about what happened here. But that doesn't make it murder. So pictures, ballistics, medical, all of that does not show you what led up to this. You heard about Ms. Stuckey going down and people are trying to calm her down. You don't hear anything about Mr. Hall being upset, people trying to calm him down. It's her. I want to go ahead and prep you also for the video that the state mentions. If they show it to you one time, I bet you they showed it to you 5 times. I don't know if you take the over under on that, but pay attention to that video and how it's spliced, how it's cut, what you see and what you don't. If it's motion censored, what you will see is when Mr. Blunt is already on the plane. He had to get there somewhere. He wasn't parachuted in. Where's the video of him going up the stairs? I'm gonna go ahead and tell you too, it's excruciating. It's a horrible, awful video to watch. You have got to be able to sit with that while also understanding that there's so much more to it than that. The only footage that exists is what the state told you. The only footage that exists, they're gonna play for you. And it just happens to be the part that helps them. Doesn't show any of the data. Unbelievable. This was 2022. This wasn't like 1900s. Bring cam, we all know how it works. The only footage that exists is the second thing you will see that is just the most horrible, tragic part. If you want the rest of the video, I'm gonna go ahead and tell you that's reasonable. I'm gonna go ahead and tell you that's reasonable now. And I wanna also talk about the confirmation that was done instead of the investigation that you'll hear about from Detective Barry. She saw the little snippet of video and then just did everything she could to confirm that this was a murder when it wasn't. You're going to hear layers and layers of unnecessary evidence that does not fill the holes in the government's case. You're going to hear, and they're going to harp on, which they already did, that the door was shut. Somebody shut the door. But you're also going to hear that Mr. Blunt was standing there still armed and that the bullets came through the door. If the bullets can shoot out, they most certainly could have shot in. So this was not a threat that had gone away because the door was shut. We don't have to speculate, we know that. Unknown, unpredictable, armed with a firearm comes in Mr. Hall's home. And it's the state's burden, and I'll talk a lot more about this in closing, to prove beyond a reasonable doubt that this wasn't self-defense. That's the burden. Not that a shooting happened, but that it was not self-defense. So at the close of evidence, I will come back up here and ask that you come back with the only verdict that the evidence supports in this case, the actual evidence, not sympathy, not, because we all agree it's tragic. But convicting Mr. Hall is not justice for Mr. Blunt, because this was not a murder. We're going to ask that you return the only verdict the evidence supports, and that's not what the unlawful is. Thank you.
Thank you, Ms. Feely. Ladies and gentlemen, you've been out here for a little bit, not all that long, but we got a slightly late start. This is sort of when we'd have our morning break. I'm happy having the state call their first witness, but does anyone want a break before we do that? No? All right, let's have that first witness, please.
State call Sharon Lattner, Judge.
All right.
Raise your hand. Do you swear affirm that testimony you will give the truth, the whole truth, and nothing but truth, so help you God? The Lord has you state the spelling of the record.
Sharon Latners, SharonLatners.
Mr. Rao, I'm sorry, before you get started, do you have an exhibit list?
Yes, Judge, we do.
Okay,
I can send it to the court.
that'd be great. Thank you.
Good afternoon, good morning, Ms. Latners, how are you today?
Fine, and you?
Doing well, thank you. Ms. Latners, could you tell the jury where you're currently employed?
City of Atlanta Communication 911 Center,
How long have you been employed there?
33 years.
And what do you do for that organization?
I am custodian of records.
And custodian of records for what specific sort of records?
I handle all the 911 calls, the dispatch calls, all the CAD reports. I handle all the cases for the DA's office and all the court cases, and I come to court for the subpoenas.
And so if you haven't already fully, can you describe to the jury what a custodian of records does for that organization?
I pull all the 911 calls. I pull all the dispatch calls for the police department. I handle all the subpoenas calls for the Communication 911 Center. And I testify on all the cases.
So with respect to 911 calls, when a 911 call is made in the city of Atlanta, can you sort of describe the process from when the call is placed to when a dispatcher picks up and answers that call?
First of all, there's a difference between an operator, 911 operator, and dispatch. Operator handle 911 calls. Dispatcher handle calls from the police officers and the calls that was sent over from 911 to dispatch so she can dispatch the calls to the units. So when a call come into 911, the operator asks them, how can I help you? Do you need assistance for police, fire, or ambulance? From there, she get the information from the caller. Once she get all the information, the address, telephone number, what kind of call it is, she press F4 and send the call over to dispatch. From there, dispatch radio the unit for that area and advise them to handle this call.
Now, with respect to the case that you're currently testifying to, did you have an opportunity to review the 911 call for the Atlanta Police Department case number 221201870?
Yes.
And when did you provide a CAD report to the Fulton County District Attorney's Office?
Yes.
And CAD report, would you mind explaining to the jury what a CAD report is?
CAD report is computer aided dispatch. What's on that CAD report is the incident for that date, the date of the call, the location of the call, the information that the caller provides to the caller, what type of call she have. And then you'll see a couple of unit numbers on there, which will the dispatcher raise that unit and give him the call so they can be dispatched on that call.
And did you also provide the audio recording of that 911 call associated with that APD case number?
Yes.
Now, the CAD report and the calls, both in this case and in other cases in which a CAD report and 911 call is made and generated, are those calls and reports made and generated at or near the time of the call?
Yes.
And are they kept as a matter of regularly conducted business activity within your department?
Yes.
And is that a regular practice for your department to preserve those 911 calls and CAD reports?
Yes.
Your Honor, at this time, the state would seek to admit what has been identified as State's Exhibits 124, excuse me, I think there's a step back. So I'm going to approach you with what I have pre-marked identification purposes as States 124 and 125. Can you please take a look at those and let me know when you're done?
Okay.
With respect to State's Exhibit 124, is that a disc that I had an opportunity to review with you outside this courtroom?
Yes.
And is that a true and accurate copy of the 911 call placed with respect to APD case number 221201870?
Yes.
And with respect to State's Exhibits 125, did you have a chance to review that document?
Yes, I did.
And what is that document?
It's a copy of the CAD report for
Is that CAD report a true and correct copy of the CAD report that your department would have preserved with respect to that APD case number?
Yes,
Your Honor, at this time, the state would seek to admit states 124 and 125 into evidence under 803B6.
Ms. Feely, any objection to the admission of 124 and 125?
Yeah.
They're admitted.
My helper is left.
Has
out.
left. That's what,
All right, so it's
Yes.
just gonna be you and me, Ms. Latners, right now. So Ms. Latners, with respect to that APD case number, can you tell the jury what time the 911 call was placed, at the time the call was made?
and this is not a 911 call. Look like the officer pulled out on this call.
Okay.
The unit pulled out on here.
Draw your attention to.
I see the incident date.
Would that be around in the time, so next to that incident date, would that be the time that the 911 call was placed?
10-12 p.m. hours.
Okay, and below that, does it also indicate the time in which the scene would have been cleared by the Atlanta Police Department? As in the call ended?
The call was cleared at 03:30 a.m. hours.
Okay, and so the call that the Atlanta Police Department received, that would have taken place at 10:12 the night before on April 30th, 2022. Would that be correct?
Yes, sir.
And then the scene or the call would have ended the following morning at around 3 o'clock in the morning, May 1st. Is that correct?
That's the date officer advised he cleared the report.
Okay, gotcha. And that's generally what would be reflected in a CAD report, is when an officer would have advised that the scene had been cleared or the call had been ended. Is that correct?
Yes.
So, Your Honor, at this time, the state's going to seek to admit, publish State's Exhibit 125 into evidence.
okay. He needs your help.
Should have it up shortly, Judge.
What is the address?
They got a shot. Come to Sunset and hold on. I'm gonna see if I can see.
You said it was a person shot?
Somebody shot down.
Okay. Sunset and Meldon?
Meldon, yeah.
Okay, stay on the line. I'm connected with an ambulance. Do not hang up. Thank you.
Okay.
All right.
Get here from here. Calm down. I know.
Grady EMS, operator 933.
It's Atlanta. Call is advising the intersection of Sunset Avenue and Belgium Street.
Thank you. Call on the line. Call, are you on the line?
Hello?
Yes, sir. It's Grady EMS. You dialed 911. What's the location for me, please?
This is Sunset and Meldrum.
What's the phone number you're calling from today?
I don't know. It's a young lady. She gave me her phone. She started screaming that her boyfriend's been shot. He down.
Okay, give me 1 second. Don't hang up, okay? I'm going to get help already on the way to you, okay?
All right, I got.
All right, thank you so much, sir. Are you with the patient now?
Yeah, I'm right here.
Okay. How old is the person?
How old is he? 21.
Okay. Is he awake?
Yeah. Hold on. Keep up.
Is he awake?
Stay with him. Just let him now. Don't push him. Just let him lift his head.
Sir? Hey, sir, is he awake?
Nah, he's not awake.
Okay, is he breathing?
His heart is beating. Hold on, let me check his heart.
Is he breathing?
I feel his heart beating, yeah.
Is he breathing?
Stay with us. I don't feel him breathing.
Okay, give me 1 second. Don't hang up, okay? I need to give you some instructions, okay? Give me 1 moment.
Okay.
I'm getting this information updated for the paramedics, okay? Give me 1 moment. City of Atlanta. Requesting fire on a 27 Delta 1 Golf.
27 Delta 1 Golf, and he said he's not breathing?
Not conscious, not breathing.
Thank you.
I don't think so.
What's your operator?
7934, yourself.
I'm operator 933.
Thank
I'm going to start CPR. All right, sir, listen to me very carefully. Is the assailant still nearby?
Can y'all please come fast?
Yes, sir. We already have help on the way to help you, okay? But I need you to cooperate with me during this time. We're going to get him some help, okay?
His heart is still beating.
I understand. Is the assailant still nearby?
Is a what?
Is the attacker still nearby?
Yes. Come on.
Okay, we already have help on the way, okay? All right, give me 1 moment. Is there any serious bleeding?
Yes. Is there
okay. All right, very good. Just listen to me very carefully. I'm saying the paramedics to help you now. Stay on the line. I'll tell you exactly what to do next. This is what we need to do. Listen to me very carefully. I need you to, I'm going to tell you how to stop the bleeding. Listen carefully to make sure we do it right. Okay?
We can't. Where he got shot? He shot in his head.
All right, he got shot in his head. Okay, listen to me very carefully. We do need to go ahead and try and stop the bleeding, though. So can you listen to me carefully? I want you to get a clean, dry cloth or towel and tell me when you have it.
What you got? You got anything clean? Cloth? You need a cloth.
While we're doing that, because his heart is still beating, we need to go ahead and start CPR. So it's a
I don't even know if it's still. Hold on. Oh my God.
We have help already on the way. We have police, fire, and EMS on the way, okay? Don't hang up. But it's a 2-part process.
Thank you, Ms. Latners. I have no further questions for this witness.
Ms. Feely, do you have any questions for Ms. Latners? All right. Jurors, the note cards are there for you. If anyone has a question for Ms. Latners about her testimony, feel free to write down your question or questions. Please write on only one side of the card, and then Deputy Gordon will collect those cards.
Thank you, sir. Counsel? Ms. Latners, couple questions. Are you able to tell from your review of the CAD report, who it was who called 911? In other words, that voice we heard on the phone.
No, sir. She didn't put that information in the call.
Okay. And is that standard for, when we heard the exchange, is the operator supposed to try to get the name of the person who's calling, or is what's more important what the call is about?
First thing they should ask, what's your name?
Okay,
What's the location?
got it. But for whatever reason, that's not included in this information.
No.
Okay. You used a phrase or a word, clear. Clear the scene, clear, this is when the report ended, et cetera. Can you share with the jurors what that term clear means?
Clear means the officer advises dispatcher, I'm code 17, I'm clear this call. He's advising her he's available for the next call.
So it's the officer saying, you could assign me elsewhere, not necessarily saying everyone has left the scene. They may still be doing work at the scene, other law enforcement officers, or does it mean also this particular scene is clear?
The main officer who handled the call, who did the report, advises dispatcher, he's cleared this call. Everybody else shouldn't be going back into service.
Got it. Mr. Rao, do you have any follow-up questions for Ms. Latners? Ms. Feely? All right, thank you for your time. Next witness.
State call, Mr. Torrance Seals.
So I affirm that testimony you may give is the truth, the whole truth, nothing but truth, self God. Sir. Good Lord, you have a seat.
We just need you close to the microphone, so you can have the chair close, or you can move, but we hear you, and you can move, you don't have to bend, but you can make it go up and down. Just make sure that is close to where you're gonna end up talking, okay?
Okay.
Thank you.
Can you state the name for the record?
My name's Torrance Seals. That's TWORNSEALS.
Good morning, Mr. Seals.
Good morning.
Can you tell the jurors, I guess, how old you are and what you do for a living, sir?
I'm 22. I'm in school for cybersecurity. I go to GGC, and I also work at Amazon.
GGC?
Georgia Gwinnett College. Yes, sir.
And are you, can you tell the jurors, are you from Atlanta or I guess outside of Atlanta?
I'm from Atlanta, and my bad, I just turned 23. My bad.
All right.
Happy forgetting.
Happy birthday.
Yeah, appreciate you.
You're young to already be hiding your age, man.
Yeah.
And back in April of 2022, so last year, can you tell the jurors where were you living?
I was staying with my mom, but I was house sitting for my friend in Sunset Avenue. So I would stay over there periodically, watch his dog and stuff like that when he goes out of town.
Okay. And How often would you do that?
Pretty often. I'll probably say like at least like once or twice every other month or something.
Okay, and so if you did it once or twice every other month, how long, I guess, had you been doing it for? What was your friend's name?
Emil Moore.
Okay.
Yes,
And
sir.
how long, I guess, had you been house and dog sitting for your friend, Mr. Moore, once or twice every other month?
Probably that whole year.
That
He was,
whole year?
yeah, he was probably like transitioning, moving between LA.
Okay, and back on during the week of April 22nd, excuse me, of April 30th of 2022, were you house and dog sitting Mr. Moore's dog?
Yes, sir.
And what kind of dog did he have?
It was a Siberian Husky mixed with a Border Collie.
And can you tell the jurors, were you home that evening?
Yes, sir.
And while home, can you tell the jurors if you, I guess, heard or anything earlier in the, I guess, evening that you took notice of?
I kind of heard some arguing outside the door, two males arguing. But then shortly after that, I left to go get some food from a drive-thru.
Okay. And prior to hearing two males arguing, had you heard any other arguing that evening?
That evening, no, sir.
Okay. And at any point during that evening, did you hear arguing between a male and a female?
Not a male and female, only two males arguing.
Okay.
That day.
And were you, I guess, were you familiar with your neighbors, or the neighbors of your friend that you were there pretty often? Were you familiar with the neighbors, the surrounding people who lived in the apartments?
No, sir, I was not.
Okay. Now, you said you weren't, I guess, you heard arguing and then you went somewhere?
Yes, sir.
Okay, where did you go?
To a drive-thru. I can't remember like which one exactly, but I know it was on that strip on Northside Drive.
Okay. So I'm gonna have you look at a couple of exhibits.
Any luck on emailing me that exhibit list?
Probably will be most likely coming sometime after lunch.
Okay.
I want to show you what the marked states exhibits 2 through 10. And you'll take a minute and just kind of flip through those. And after you look at states 2 through 10, just look up. Do you recognize what's in states exhibits 2 through 10?
Yes, sir.
And how do you recognize states exhibits?
That's the apartment complex we were staying at.
Okay. And do states exhibits 2 through 10 fairly and accurately depict how the apartment complex, the apartment you were staying at that night at 537 Sunset Avenue looked on April 30th of 2022?
Yes, sir.
This time, the state would tender what's been marked as states exhibits 2 through 10 in evidence.
Ms. Feely, any objection?
No.
They're admitted.
All right, and the screen, hopefully in front of you, all around us. State Exhibit 2 should pop up. Do you see it?
Yes, sir.
What is that? There's a white window that's open there. What does that say?
It says mute or unmute.
So keep it on mute. Press whatever button says mute or stay mute.
Stay muted.
Yeah, that
Okay.
should go away. There you go.
Sure.
Now, could you kind of, I guess, orient the jurors a little bit? In State Exhibit 2, do you see the apartment building or 537 Sunset Apartments?
Yes, sir. Those two buildings to the left.
So there's a way, if you tap the screen once, there'll be a little pencil that appears in the lower left hand. Just tap the screen
Okay.
anywhere. See that little circle with a pencil?
Yeah,
Right in the-
just
in the lower left hand corner. See
okay.
that?
Yes, sir.
Tap that. Now, it should be, you can draw on the screen. So circle the building that you say is the apartment building. Is it making that?
Yes, sir.
Look at that. Nice work.
Sir.
Cybersecurity.
And I guess, can you explain to the jurors why we're looking at State Exhibit 2? Was the complex or the building where the apartment you were staying in, was it a large apartment complex?
No, not at all.
How many, if you had to estimate, or if you know, how many apartments do you think, I guess, were contained within the apartment building 537 Sunset?
It's probably 8 within those two buildings, like all together. So it's like 2 on the bottom, 2 on top, and vice versa.
Okay, and you hit the corner, I think it's the left corner, it'll clear,
Okay.
eraser that comes up.
Eraser. All right.
Now, in State's Exhibit, we'll go with State's Exhibit 3. That's the side of the building that we're looking at in State's Exhibit 3. Can you tell the jurors, would that be considered the front of the building, the back of the building? Do you know?
That's not my side of the building, so I guess that can be considered either or. Depends on which one you prefer to use. It's like the door you see right there with the stairs, only the people that stay on that upstairs have access to them stairways.
Okay, and is that side of the building, is that the side that runs, it's parallel with Sunset Avenue?
I'm not sure which street is Sunset Avenue exactly.
Okay. I guess, is it the same side of the street, or is the building on the same side of the street where, I guess, your only exit out of the apartment complex is?
Yes, so I would have that same one on my side too, though. So it's two exits. So those stairs are connected to the doors exactly of the apartment, and it's a front door and another side door. So one leads to those stairs that you see here, and another one leads to like a main group of stairs.
I asked a really poor question, so I apologize.
Okay.
So to drive in and out of the apartment building, can you see the only way to get in and out, the only entrance and exit for the apartment building that you were staying in?
Yes, but that's not the only exit. We park on the side. It's a parking lot on the side, and normally go up them stairs right there. Those are all shared stairs. But this, what you're showing me right now, is only for 2 units available to use that entrance.
But is the entrance to the parking lot where you park, can you see the entrance to the parking lot on this picture?
No, sir,
Nope.
not from right here.
Okay.
So if you will turn, I want to show you on 603, you see towards, I guess, the back middle of State Exhibit 3 right here, where you see kind of this past the green area. Yes.
The parking lot will be on the other side of this building.
And you see right here, the street that's in the middle of State Exhibit 3 that kind of runs parallel to the building? Yes. Okay. Is this the entrance in the middle of State Exhibit 3? Is that where you would enter and exit right past the greenery area? And then if you go beyond, there's like it's like concrete and then you kind of grassy area?
Yes.
Okay. That's how you would enter and exit?
Yes.
Was that the only way to enter and exit, I guess, by vehicle?
Yes.
There we go. I asked a real bad question, so I'm sorry.
It's okay. My bad if I didn't answer properly.
So I want to go to State's Exhibit 8.
Okay.
And in State's Exhibit 8, can you explain to the jurors kind of what they're looking at in regards to the Sunset Avenue building that you were staying at?
This would be the parking lot. This would be where all of us park our vehicles and get out.
And do you see kind of where the pavilion is? It's like a beige color
Yes, sir.
with the stairs.
Uh-huh.
Is that where you would enter and exit to get to your apartment?
Yes, sir.
Okay. And is that the only way that you could enter and exit to get into your apartment?
No, sir.
Okay. And then in State's Exhibit 10, is this kind of the opposite view that we were just looking at as it relates to how you would enter and exit the apartment that you were staying in?
Yes, sir.
And I should ask you first, what apartment or were you staying at that your friend lived in?
I was staying at apartment 6.
Apartment 6?
Yes, sir.
Okay. Now, I want to show you. State's Exhibits 100 through 117.
Right.
What was the range again?
100 through 117.
Cute.
All right. So after looking at State's Exhibits 100 through 117, do you recognize the photographs contained in each?
Yes, sir.
And can you tell the jurors in the court how you recognize those photographs?
That was the apartment I was living in.
Okay. And was that the same apartment you described to the jurors, apartment number 6, that you were house and dog sitting for your friend, Mr. Moore?
Yes, sir.
And do those photographs in State's Exhibit 100 through 117 fairly and accurately depict how the apartment you were staying in, apartment number 6, looked on April 30th of 2022?
Yes, sir.
This time after the statement tender was from March. That's State's Exhibits 100 through 117.
Ms. Feely, any objection to that range of photos?
No objection relevance. It sounds like this wasn't even the incident location. This witness wasn't home. He didn't witness the events.
Okay. What's the relevance of, I take it this is the inside of apartment number 6?
Yes.
What's the relevance of the inside of apartment 6, which I don't think is Miss Stuckey's apartment?
It's not. It is the apartment, though, that after the defendant fired through the Stuckey's apartment, apartment number 2, that several of the bullets went through the door into the apartment that Mr. Seals was staying at on that night.
And do these photos show what you contend is the state of apartment 6 after the gun was fired?
Yes, Your Honor.
Okay, I'll allow it in.
While we're there, I just want to show you one more. State's Exhibit number 11. Do you recognize State's 11?
Yes, sir.
And what is State's Exhibit number 11 a photograph of?
basically when it was declared a crime scene and everybody was like forced, like I wasn't allowed entry in my apartments and everything at this time. I had to stand outside with them.
Okay, and in States Exhibit 11, I guess what area of the apartment building does it show?
It shows like the main entrance that will connect all the apartments. Like,
okay, and does States Exhibit number 11 fairly and accurately depict that entrance that you've described, how it looked on April 30th of 2022?
Yes, sir.
This time you're under the state would tender as well, States number 11.
Any objection to 11?
No.
It's admitted. I've got a question, Mr. Seals.
Yes, sir.
So you went out to get some takeout
Yes, sir.
this night we're talking about. When you came back, did it look like that, as in things were roped off? Or had you made it back into the apartment and then they made you leave the apartment and wait outside?
When I got back, things were already looking like that. It was cars, like police cars and helicopters all around.
Okay, so whatever happened while you were getting your takeout?
Yes, sir.
Now, can you tell the jurors about what time, if you can recall, that you left that evening to go get takeout? I know it's been some time.
I can't recall exactly.
Okay, was it dark out?
Close to getting there, probably like sun setting as I'm about to leave, and by the time I get back, it's a little bit dark.
Okay.
Sure.
Now, neither me or Mr. Rao are very good at IT, so we'll just have to do it on our side for right now.
Okay.
In States Exhibit number 11, when you see the staircase that's in the middle of States Exhibit number 11, if we turn our head all.
Yes, sir. Yes, sir.
Okay. Now, tell the jurors, where does that staircase or what does that staircase lead up to?
All the apartments on the upper level.
Okay, and where was the apartment that you were staying in relation to, or in this photograph?
I was staying in the apartment in the building to the right.
Okay.
Sure.
So if we're looking at States Exhibit 11, you go up the stairs, is your apartment the very first one on the right? Yes, sir. States Exhibit 11.
Yes, sir.
Okay, and
So the stairway doesn't go all the way across the hallway, so I guess you can walk by it on the ground level, but is there a landing up top that connects the two buildings? So if I'm living in the building to the left, one that's up,
Yes, sir.
I can take those stairs and still I don't have to jump to my door. There's actually a landing that connects,
Yes, sir. It connects 4 of the upper level units. Yes, sir.
including yours.
Yes, sir.
and you said once you go up the stairs, the landing, there's your apartment. Is that what you? Is there apartment right across from you?
Yes, sir.
And then are there 2 additional apartments that are behind your apartment and the one that's across from you?
They're beside them. Yes, sir.
Okay.
Yes, sir.
So for a total, if you go up that landing, you have access to 4 separate apartments.
Yes, sir.
Now, when you left to go get food, can you tell the jurors, did you go through, or how did you, I guess, where was your car parked?
Like to leave,
Yes.
it was parked on. So you saw how it had that one staircase that I was telling you, that only connects to the top 2 units.
Mhm.
I was parked on this, like right there at the end of that staircase on the side of the building.
So in States Exhibit 10, is that the door that you're referring to?
Yes, sir.
So you remember at the beginning of your testimony, there was a photo of the other side of the building that looks similar with the same kind of awning, pavilion type of walkway.
Mhm.
Is that the same walkway on the other side, but only leads up to the other two, I guess, upstairs apartments?
Yes, sir.
Okay, so when you go up those stairs and you enter your apartment, is that the front door? Is there more than one way to access?
That's the only way you can get in from that side, but on the other side, that would be like, I guess none of them are really considered the front door. It really just depends on what you mainly use it for. I guess that was my front door. Like for the most part, I normally don't enter in through the other side. I normally go in through that side.
Okay.
But there are two doors then to each unit up top.
Yes, sir.
One you'd get through by going through this awning access, and the other would be that stairway we were just talking about
Sir.
that divides the two buildings.
Yes, sir. Those are the only two entrances for the upper unit.
Okay.
And in State Exhibit 10, if you go up, I guess up the stairs, through the doorway and up the second set of stairs, to get to your apartment, is it to the left or to the right?
Go up this way to the left.
Okay, and then is the only other apartment that can be accessed going up those stairs immediately to your right?
Yes, sir.
Okay, so in the apartment that's across from you, so you're in apartment 6, right?
Mhm.
And the apartment across from you is apartment 2, correct?
Yes, sir.
And would you be able to access apartment 2 from going up those stairs?
Not at all.
Okay. Now, are you able to access apartment 2 through the middle steps that we looked at in State Exhibit 11?
Yes, sir.
And then are you also able to access apartment 2 through States Exhibit 5 through a similar door that you just described, but on the opposite side where that runs parallel to the street?
Yes, sir.
Okay. All right. In States Exhibit 100. Can you describe to the jurors what we're looking at in States Exhibit 100?
That would be the front door of my apartment.
Okay.
So you just explained that there's not a front door versus a back door. Is this the door that you get to by walking up that stairway between the two, or walking up, I'm gonna call it the side stairway where you go underneath the awning and interior?
This is the main stairway that I said that you have access to the 4 upper apartments.
Okay.
So is this the same staircase you described that you'd walk up and you have access to your apartment, but you'd also have access to the one across with apartment number 2?
No, sir, this is not that one. This is the one that would be in the middle of both of the 2 apartments.
Right.
Yes, sir.
So if you went up the stairs, if you went right, you go to your apartment, right?
Yes, sir.
You turn left, you'd be able to get into number 2, the one that's directly across from you, right?
Yes, sir.
Okay. Now, when you left your house, or Mr. Moore's house, the house that you were staying at, was anyone inside the apartment?
Just a dog.
Just the dog?
Yes, sir.
What was the dog's name again?
Kiko.
Kiko.
Yes, sir.
So when you went to go get food, no one was in the house. There was just Kiko.
Yes, sir.
And when you left to go get food, were there any bullet holes in your door?
When I came back or before?
Before you left, were there any bullet holes in your door?
No, sir.
Okay. And how long would you say that you were gone to go get while you were going to get fast food?
probably 15 minutes.
Okay, and can you describe to the jurors when you returned, what you returned to or what the scene was like at the apartment you were staying at?
I returned back to a crime scene with a whole bunch of police cars surrounding the apartments, helicopters on top. That's it.
Okay.
Yes, sir.
And when you got back, were you able to immediately gain access to your apartment?
Not for a really long time.
Okay. And at some point before you went inside your apartment, did you allow officers and other members of the Atlanta Police Department to, I guess, kind of look around, look into the apartment?
Yes, sir.
Okay. And were you present during that?
I just unlocked the door and moved out the way that I wasn't allowed to enter the apartment.
Okay. And do you see in State Exhibit 106, you obviously see in the middle of the exhibit the white door, right?
Yes, sir.
So I'm gonna try to zoom in. Do you see through the open door, do you see the second door inside, like that's inside of, I guess, the middle of State Exhibit 106 if you enter the door?
Yes, sir.
And can you describe to the jurors, what is that, I guess, a door to?
That door would be to the, I guess you would call it private steps now. I guess that's what I'll use it for, yeah.
That's the same door you described that you typically would come in and out of and went out that evening?
Yes, sir.
Okay. And in State Exhibit 116, I guess we'll orient the jurors. I guess the apartment you were staying in, was it a pretty large apartment? Can you describe that for the jurors?
Not at all. It was not a large apartment. It's probably like 2 other rooms. And this is like the main area connected to the kitchen.
Okay. And when you left, I guess, were there bullets laying on the floor of apartment 6, the one you were staying in?
No, sir.
And when you got back, were you present, or did you allow the Atlanta Police Department to look through your apartment in which they found ballistics evidence or bullets?
Yes, sir.
And was Kiko okay when you arrived back?
Yes, sir. I left her in the cage, so thankfully nothing, like no way for her to get hit. Yes, sir.
I don't need further this time around.
Ms. Feely, do you have questions for Mr. Seals?
So, Mr. Seals, you mentioned that you were not home when the incident occurred, right?
Yes, ma'am.
But you did remember that the sun was kind of setting around the time you were leaving to get food.
Yes, ma'am.
And it was before then that you said you heard 2 males arguing.
Yes, ma'am.
You didn't see who that was, though.
No, ma'am.
And that would have been when it was still kind of daytime.
Yes.
And the only other question I had for you, I just wanted to clarify this State's Exhibit 106.
Mhm.
We can see a railing there. That fair to say there's a staircase right there, right?
Yes, ma'am.
When you were on the landing where you can access the 4 apartments, is that the staircase you would go down to leave?
One of them, yes.
And the other one you could only access by entering an apartment?
Yes,
So-
ma'am.
Okay, so on that landing, in order to not use that staircase to leave, you would have to go in an apartment through another door. Is that fair?
Yes.
Thank you.
Wait, time out.
Sure.
This railing right here?
Yes.
No, this is the main railing. So this would, so how I have this right here, this would be those stairs right here, what you're looking at on the screen.
Can you tell the jurors what number exhibit you were just holding up?
Exhibit 11.
Okay, if you'll show the jurors, that's okay.
And I gotta be honest, I was confused about this too, so I'm gonna call that exhibit, the external stairs, and then the other stairs you were talking about, the internal stairs, would that be
Yes,
accurate?
that'd be, yeah.
Thank you.
Yes, ma'am.
That's all I have.
if you were standing, Mr. Seals, outside the door that was on the screen that goes to the external landing and stairs, so we saw it was open and we could see inside the apartment. If you were just standing right in the doorway, is the door to apartment 2 directly across, or are they not aligned that way?
They're directly across from each other.
Okay, so if you walk out that external landing door, you would physically bump into the door of number 2.
Okay. Yes, sir. As soon as I open it, I'll see.
All right, jurors, do you have any questions for Mr. Seals? If you do, jot them down and pass them to Deputy Gordon, please. Thank you.
Counsel?
Mr. Seals, did you decide to go get dinner, the takeout that you got, in any way because of the argument you were hearing outside? Is that a reason you're like, I gotta go get food? There's so much noise out there.
No, sir. I wouldn't say that.
They weren't connected.
No, sir.
Okay. Do you have a sense of what time it was when the police asked you for permission to go into apartment 6?
Like off memory on hand, no, sir.
Okay. How about how much time between you leave to go get takeout and they ask to go in apartment 6? Is that 1 hour, 6 hours?
Definitely less than an hour.
Okay.
Like, definitely probably under 30 minutes. Yes, sir.
Okay. Mr. Abate, any follow-up for Mr. Seals? Ms. Feely?
Yeah.
All right. Thank you, sir, for your time.
Sir, I appreciate you guys.
Bet. So ladies and gentlemen, I talked with the lawyers while we were going through these questions, and we're going to do one more witness, 10 minutes or less, then we're going to break for lunch. People can hold out for that. I haven't forgotten you didn't get a break this morning. Are you good? Oh, we need break. Never mind. We're going to take a break now. Why don't we just break for, I don't think it makes sense to take a 5-minute break and bring you back for 10 minutes. So we will break for lunch now. The goal is to keep lunch at about an hour. This is your first lunch break, so you may be navigating hallways and whatnot to get to lunch. But let's aim to be back. This clock is a little off, but it's official court time. On that clock, we'll aim to be back here a little before 1, so like 12:55. That's about an hour, according to what I think is more real time. If for some reason you're stuck, call my chambers, but just don't go too far. If you walk 30 minutes away, you have to turn around right away to be back in 30 minutes. There are a couple of restaurants that are nearby. I think there's the Fuda thing, which is in the office complex. Just you walk over that bridge, but Deputy Gordon can help with that. And we used to put a piece of paper on the table that gave some suggestions of not endorsements, but just places where they actually serve food. Any logistical questions before we break for about an hour? Reminder, please don't talk about the case. It's fine for you to eat as a large group, or you may all disperse into 14 different groups. You can talk about anything you want other than the case.
Number two, no outside research. Here's how you ask your questions. So don't hop on your phone to say, wait a minute, internal staircase, external, what fast food restaurants are nearby? If it's important to know what fast food restaurants are nearby, the lawyers are going to figure out how to get you that info. You don't get it by Googling fast food near Sunset Drive, whatever this place is. Okay? If there are no questions, take your pads with you, leave them in the jury room, and we'll see you in about an hour.
All right, adjourned.
Mr. Abate, anything before we break for lunch? You've got witnesses to fill the afternoon? All right, Ms. Feely, anything? Two quick things. I know we need to take a break. One, I'm going to talk about the prior difficulties between Mr. Hall and Ms. Stuckey when we get back. I'm just going to get something on the record because there have been concerns about, is that admissible, whether it's through the immunity hearing or a witness. I'll get that on the record. And it sounds like you're going to stay away from the immunity hearing testimony for the rest of the day? Okay, great. And you'll get us an exhibit list. All right, thank you. No, I forgot. You need to let me know. You're no less important than the jurors. How are you? I'm well. Happy holiday season. Sure. Hold on one second. Let me.
Ms. Feely, can you make the camera pop back up from the podium machine? Yeah, oh, that's right. Deputy Gordon's on it. Look at that closing speed. Excellent. You know, if Mr. Abate's at his seat, it gets him most of all. I'll get it right back on the witness. I just don't like it on the witness when the jurors are coming in. And it needs to be on anyway. All right, Ms. Rivers, are you ready? Are you, I guess we'll just have someone come fix that? Yeah.
Ours is off again.
Same thing happened to Ms. Rivers. Let's see if I can add. All right, prosecution is back on. I don't know how to add yours. Does yours have a name in the system? Let's see. Court reporter, let's see. No, it won't let me mess with yours, which is a sign that something's not right. Do you want to try to join it now, or you just did and it was?
I'm gonna try to make sure I have the right.
Okay, you want me to write it down or you have it? Let me look. Yeah. So why don't you try that before we get going? It's just doing that same thing? Okay. I'll send them a little note to have IT come make it work. Okay. All right, well, let's get on the record. Our jurors are here. So we are back in State versus Hall. It is the end of our lunch break. Mr. Hall is here with his lawyers. We've got our prosecutors here. I received an exhibit list from the state. Thank you for that. I'll start keeping track of what's been admitted and what hasn't, if anything is excluded. I should have made clear on the record, every juror question that's submitted will be made part of the record, whether the question has been asked or not. They're batting 1,000. So far it's 4 for 4, but if a juror submits a question that we agree ought to be excluded, I'll still keep that in the collection of all questions that will be made court exhibit number 1. Ms. Feely, did you have anything come up over the lunch break that we need to talk about now?
It's not a new concern, but I think this next witness is where we're going to start getting into my concerns about the prior difficulties. So we wanted some clarity on that.
Okay.
Particularly if it wasn't that day. I think if somebody heard arguing that day, that is more relevant to what the jury does decide, but we think it's not relevant to any other things because, and if the state is trying to say it's for the deceased state of mind or something like that, we don't know what hearsay exception he got that information from, because to my knowledge, he's not present.
Got it. Okay. Anything else, or I'm prepared to talk about that. I did a little homework on that. That's it? Okay, Mr. Abate, anything other than the prior difficulty situation? Okay. Ms. Feely in her opening described Mr. Blunt as a stranger to, they may not have been her exact word, but that Mr. Blunt was a stranger to Mr. Hall. What do you think the evidence will be, Mr. Abate, from Ms. Stuckey or her daughter as to whether Mr. Blunt and Mr. Hall had ever met, interacted in connection with Mr. Blunt's relationship with the family?
The only information I would have is that they met at a barbecue, family barbecue, prior to this instance, and they had seen each other in passing, like the reference during his testimony. There wasn't some like tight, close-knit relationship between him and Mr. Hall.
Okay, and do you think the evidence is consistent with what Ms. Feely said, that Mr. Blunt never observed Mr. Hall and Ms. Stuckey having a disagreement, a fight, whatever term we want to use? In other words, he may be aware that was the nature of the relationship, but he never saw it actually play out that way.
I think that would be accurate, yes.
Okay.
I'm not 100% positive, but I'm pretty positive.
Okay. So what is your argument as to why testimony about prior difficulties between Ms. Stuckey and Mr. Hall should come in?
So my argument would be, as it relates to the state of mind of the victim that night, as to why he felt it necessary to make sure that Ms. Stuckey made it into her residence safe. It wasn't just the argument that he had heard that evening. As Ms. Stuckey and Ms. Scott explained during their interviews with Detective Berry after the incident, that that evening, actually, when Ms. Stuckey came down during, I guess, after the argument, and I guess it was the cooling off period or cooling off time, during while they all sat and talked by the vehicle, she explained how he had recently and in the past as well slid her tires and things of that nature, which is the reason for the concern of Mr. Blunt that evening, and why he felt it was necessary and he had to, make sure that the situation was safe for Ms. Stuckey to return, Your Honor.
I'm not remembering from the immunity hearing. What's Ms. Stuckey's daughter's last name?
Ms. Scott.
Ms. Scott. Did Ms. Scott testify at the immunity hearing?
She did.
Did she say that she, and presumably then Mr. Blunt, could hear an argument going on upstairs? I know there was the cooling off period. Ms. Stuckey came down to be with Ms. Scott and Mr. Blunt. I'm not remembering if the evidence is when Scott and Blunt rolled up, I could hear something was going on. And so maybe this isn't right for granddaughter to stay with grandmother because it's sounding tumultuous up in apartment 2.
That's exactly what the evidence will be from Ms. Scott.
Okay. Why then do you need to get in evidence of things that might have happened before that night? In other words, if Ms. Scott can testify, and I think she can, that Mr. Blunt and I were standing right there, and we are concerned. We're talking about it. We're concerned because we can hear my mother either getting fussed at or fussing back at that is loud and not sounding like a good environment for granddaughter to be. I think that does come in. I think that's intrinsic evidence. I think it explains the situation. It may not be great for Mr. Hall's character, but that is a collateral impact of the testimony. That's not the purpose of the testimony. And I would find that that easily clears a 403 hurdle. It gets more complicated if you're going to be asking people, Ms. Stuckey herself or Ms. Scott or others, well, hey, was Mr. Hall like that on other times? Because it seems like what matters is what was going on that night. And if I'm Mr. Blunt, I'm going up to make sure, I don't know this specific, I want to make sure no one's drunk. I want to make sure the apartment's not a wreck because they've been yelling at each other and there's broken glass on the floor. And, Ms. Scott's baby's not gonna go in an apartment that's in that state.
So I definitely understand Your Honor's point and concern. I would, I guess, counter with the fact that I think the testimony would be not only what occurred that evening was what made Mr. Blunt so concerned, but what Miss Stuckey continued to say about prior instances of their disagreements escalating.
Mm.
And I think the whole point of making sure that she got in the home safely was to make sure that it didn't escalate, at least as it relates to Miss Stuckey. And the reason for that would be not only that evening, but the things that he had been told by Miss Stuckey as it relates to the relationship between Miss Stuckey and the defendant. I'd also
Let me stop you for a sec, because I want to process this in real time. Ms. Stuckey and or Ms. Scott will say during the cooling off period on April 30th, 2022, Ms. Stuckey relayed to Mr. Blunt some of these other situations, or it was on some other day that Ms. Stuckey or Ms. Scott had told Mr. Blunt about tires getting slit and I'm making this up, Mr. Hall putting his hands on Ms. Stuckey or something like that. Was it that evening during cooling off or 2 weeks earlier?
It was that evening during the cooling off.
Okay. All right. And your response to a hearsay objection as opposed to a 404B or character objection, that you'd be getting in testimony of here are some things that even though it's Ms. Stuckey saying, I said this, it's an out of court statement. She said it to Mr. Blunt a year and a half ago.
And it goes to state of.
So I was saying, finally, there's an instance where effect on listener actually applies.
Okay. And that's the response, is that it's not for the truth of the matter asserted. This is why Mr. Blunt might have gone up the stairs in a certain posture and might have engaged with Mr. Hall in a certain way. Partly what he saw and heard that night, as in literally the goings on, but then what Ms. Stuckey told him about prior interactions she had with Mr. Hall.
Yes, Your Honor.
Okay.
Because I would agree with the court. Mr. Blunt had absolutely he didn't witness the slitting of the tires. He just knew based on what has been described to me as that was part of the reason why it was so, in his mind, necessary that he, make sure that Ms. Stuckey is safe and that the situation, as it relates to her at least, was contained.
Had Ms. Scott already decided based on what she saw and heard that evening that her daughter was not staying there, and so Mr. Blunt's mission was now purely, let's get Ms. Stuckey back in there safely? Or was it to also see, maybe it's okay to have granddaughter stay with grandmother?
The first that you described, that they had, Ms. Scott, she decided from the testimony from the immunity motion as well as her prior statements that when she heard the arguing going on when they first arrived, that this was not an environment she wanted to leave her daughter.
It was not going to work out that night.
Correct. And then during the immunity motion, she described her, going back up there with her mom because her mom asked her to, I'll keep, her daughter safe. You can come see. And upon what she described in the immunity motion, upon going up the first time, the defendant comes from, I guess, the back room she describes and immediately puts his finger in Miss Stuckey's face. And then that's when Miss Stuckey and Miss Scott return back to the car where Mr. Blunt is with Miss Scott's daughter. Okay. And it proceeds from there.
What other specific acts, you talked about slitting tires, what else will Miss Stuckey or Miss Scott say Mr. Hall did to Miss Stuckey other than verbal abuse? And abuse may even be the wrong term. Maybe they had verbal altercations, but other than words, is there anything besides slitting the tires?
The only other instance that I had relayed to the court as well as counsel was during the immunity motion where it was earlier in that month while they were in, they being the defendant and Miss Stuckey in Puerto Rico, where he had laid hands on her, which prevented him from coming home at the same time that she did. That's
right. You did talk about that. Why do you think Mr. Blunt knew about that? Or was that also discussed standing outside the car on April 30th?
That was not discussed standing outside the car. It was something that he had learned from Miss Scott close in time to when it occurred. When I say occurred, the actual putting hands in Puerto Rico.
Okay.
Which would have been earlier than the month of
Okay.
April.
Ms. Feely, I have a better feel now for the scope of what the state wants to explore. Is there anything more you want to get on the record in opposition to any of that coming in?
Yes, Your Honor. I could not more strenuously object to this.
I've seen you object more strenuously, but I know you're being strenuous.
Because now the state is using a backdoor around hearsay to improperly impeach his character. And we can't challenge those statements because it's hearsay and we don't have a witness through which to do it. And so on top of that, then it's also just on a face improper character evidence. We don't know what Mr. Blunt knew or didn't know about Mr. Hall when he in his apartment with a gun. And I don't think that the state should be allowed to use hearsay, potential hearsay statements that we can't cross-examine to get in this improper character. And secondly, I think it's inadmissible anyway. It's improper character. It's far more prejudicial and probative of what the jury is determining in this trial. So those are our objections.
Okay, what I'm going to do for now is allow in testimony from Ms. Stuckey and or Ms. Scott about what happened the evening of April 30th. And I mean that in two ways. One, they can talk about what they saw and heard, and thus whether Mr. Blunt would have heard that. But they can also talk about conversations they had of which Mr. Blunt was a part, if it related to things that would put Mr. Blunt in the frame of mind to be concerned about Ms. Stuckey's well-being when he escorted her back to the apartment. So the line I'm drawing is chronological. I don't think at this point the state should get into the Puerto Rico incident. That could change based on how Ms. Stuckey or Ms. Scott is cross-examined. It could change if Mr. Hall chooses to testify based on things he might say. But until we have another conversation about this, don't lead with that, meaning seek to admit it. We need to have another conversation about whether non-contemporaneous information that Mr. Blunt may have received about the nature of Mr. Hall's relationship with Ms. Stuckey comes in. I think it does come in. One, I don't think it's hearsay. Two, or it's an exception to hearsay. Two, I think if we're focusing on what happened on the 30th and what Mr. Blunt heard and was told, it's intrinsic to this incident. And I think it easily clears the 403 hurdle. It's not good evidence for Mr. Hall, but in theory, not much of what the state's witnesses say should be something that's not prejudicial to Mr. Hall. But I don't find that the prejudice of having Ms. Scott or Ms. Stuckey talk about what was going on that night, or what Ms. Stuckey told Mr. Hall about the nature of her relationship, told Mr. Blunt about the nature of her relationship with Mr. Hall that night before Mr. Blunt went upstairs. I find that is more, the probative value is not substantially outweighed by any unfair prejudice to Mr. Hall. So we're staying away from Puerto Rico, but otherwise what Ms. Scott and Ms. Stuckey may have said that night is relevant, and it comes in terms of informing the state of mind of this actor, this important actor. According to Mr. Hall, it's the aggressor, and there may well have been some aggressive steps that Mr. Blunt took. And I think the state is entitled to explain that conduct. So you're welcome to object again. You have a standing objection. You could object when that line of questioning begins, but you waive nothing in connection with any testimony from Ms. Scott or Ms. Stuckey, Ms. Feely, concerning any prior difficulties, although it's kind of current difficulties if it relates to that night. But it sounds like that Ms. Stuckey shared with Mr. Blunt some prior instances of conflict that she had with Mr. Hall. She shared with Mr. Blunt that night of the 30th, not Puerto Rico, but maybe damage to the tires. I think that can come in. You've objected and you've preserved that I'd ask you not to object to every single question. You wouldn't want to do that anyway, but if you want to refresh it, you should feel free to do that. But the record is clear that your objection persists and protects Mr. Hall to any testimony from either of those two about what was said and heard the night of the 30th. Okay?
Just specifically with this property damage alleged, that we don't have any evidence of, I want to more specifically object to that, as it's our position that's property damage and not, violence or threats of violence.
Okay. I hear you. I think it still goes to difficulties, and there are a couple cases, Shepherd versus State 267, Georgia 276, and more recently, Person versus State 340, Georgia Appeals 252, that explore the dynamic of prior difficulties between a defendant and a witness. This would be a very different conversation if the prior difficulties were between Hall and Blunt. Then almost all that's coming in. And this is a parallel analysis, and I've tried to follow what the courts in those two cases had to say about that situation, and I've made the ruling that I did. Anything else, Mr. Abate?
No, Your Honor.
Okay, let's bring the jurors in, please.
All right, jurors.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back, ladies and gentlemen. Success. Everyone find lunch somewhere? Anyone risk American Deli? American Deli is just fine. It's just one of the closer ones. There's a new-ish Thai restaurant up Mitchell a little ways that's kind of fancy but pretty tasty. But again, no endorsements, just suggestions. I forgot to mention this morning about seating arrangements. There are no assigned seats, and folks shouldn't get grabby about a seat. I think it's important that you rotate a little bit, and I see a few of you are on slightly different spots. You will physically have a very different perspective on this case. If you're always way down by where Deputy Gordon is right now, the witnesses are somewhat remote and you see the courtroom a little bit differently. If you are always right up against the monitor, the courtroom is a little bit different. So unless you need to be near the edge, because periodically you need to stand up to stretch, which is okay, rotate. Don't always be in the back row way where you think you can sleep and we won't notice, because we'll notice anyway. But be in a different spot. No one owns, other than the county collectively, any of those seats. We left off in the midst of the state's case. We had a little conversation about an issue after you got back from lunch, but we are ready to proceed. Mr. Abate or Mr. Rao, who is the next witness?
Say we call Mr. Cunningham, Your Honor.
Hello, Mr. Cunningham. All right, come on up, please.
Raise your right hand. Do you swear or affirm that testimony you will give will be true, the whole truth, and nothing but the truth, so you are? Good lawyer, have a seat. Can you state and spell your name for the record?
Naeem Cunningham, Naimcunningham.
Mr. Cunningham, if you would please sit, you can either move the chair or move your body, but we need you near the microphone so that folks way in the back of the courtroom can hear you as well. Thank you so much.
Good afternoon, Mr. Cunningham.
Good afternoon.
So you're gonna have to speak.
Good afternoon.
Okay. Can you tell the jurors how you're employed, sir?
I work for a company called Innovative.
Okay. And what do you do with Innovative or for a living?
I'm the facility manager.
Okay. And can you tell the jurors, are you from Atlanta or are you from somewhere else?
I was born in New York, but I'm been here all my life.
Okay. Did you been here in Atlanta all your life?
Yeah.
Okay. And back in April of 2022, can you tell the jurors where you were living?
I think it's 537 Sunset Avenue.
Okay. If you'll speak just a little bit more.
537 Sunset Avenue.
There we go. And how long did you live at 537 Sunset Avenue?
My 5-6 months.
Okay. And can you tell the jurors while you lived at 537 Sunset Avenue, what your apartment number was?
8.
8?
Yes.
And I want to show you State Exhibit 124. Do you recognize State Exhibit 124?
Yes.
And
I'm confused. 124 was one of Latner's exhibits. So we got a little overlap.
sorry, I'm at 24.
24, got it. 24 is a happy number.
And how do you recognize State Exhibit 24, sir?
I used to live there.
Okay, and does State Exhibit 24 fairly and accurately depict I guess that exterior of your apartment, apartment number 8?
Yes.
At this time around, the state would tender what's been marked as State Exhibit 24 into evidence.
Any objection to State's 24, Ms. Feely? Do you want to see it? Okay. It's admitted.
Now, Mr. Cunningham, could you kind of explain to the jurors the layout of, I guess, your apartment, or the apartments that were at 537 Sunset Avenue on the second floor?
What do you mean as far as the layout?
So was there, how many entrances were there into your specific
Into my apartment?
apartment? Yes.
2.
Okay. And apartment number 8, in relation to apartment number 2, is it diagonally situated? Let me show you a picture. I'm sorry. All right, in State's Exhibit 11, do you see it in the screen in front of you?
Yes.
So if you go up the stairs that are located in the middle
Hold on
of,
one sec. There's a little white box in the middle. What does it say?
The host has spotlighted your video for everyone. Would you like to unmute your microphone to speak?
No unmute. Whatever button says don't unmute, please tap that. Great.
so
I think you hit the wrong button. Hold on. Okay.
okay, so in State's Exhibit number 11, the middle staircase that you see in between the two buildings, you see that?
Yes.
So if you were to go up those stairs, can you describe to the jurors as you go up where your apartment is in relation to the stairs?
Last apartment on the right.
On the right?
Yes.
Okay. And if your apartment is on the right and you're the last apartment, it's 8. The apartment that is directly, I guess, next to the front of the building, is that 6?
I don't know the numbers.
So, in States Exhibit number 11, if you're looking at about the middle of States Exhibit 11, if you're looking on the left-hand side, you see this door right here?
Yes.
Okay, and is that apartment directly diagonal from your apartment, your apartment, apartment number 8?
Yes.
Okay, now, can you tell the jurors, did you have any sort of ring camera, ring doorbell device as it relates to your apartment?
Yes.
Okay, and I want to, can you describe to the jurors before I put it up, where was that ring camera or ring device located in relation to the exterior of your apartment, apartment number 8?
Top corner of the doorway.
And in States Exhibit 24. All right, would you circle, and it's real dark, so if you could circle in State Exhibit 24 where do you see what camera is?
Yes.
And which you can actually touch the screen. Would you circle it for the jurors so they can see where State Exhibit 24 it is?
It's not doing.
He may need to reactivate it, so if you get the little pencil thing going for him. Now, how long have you had the Ring camera device in your door?
I put them up when I moved in.
Okay, and can you describe for the jurors where, well, how does the Ring camera work?
Just picks up any motion in the hall.
Okay, so they're motion activated?
Yes.
And I guess the position that you had positioned the camera, was it looking kind of towards the stairs?
Yes.
And can you describe to the jurors prior to April 30th of 2022, had you had the opportunity to, I guess, view the Ring camera footage from your phone or your computer, something like that?
Yes.
Okay, and in your review of prior, I guess, footage that was captured by your Ring surveillance camera, can you explain to the jurors typically when you had watched it in the past, when your camera would start recording or when it was activated based on motion?
What do you mean by that?
So how close to your door, in your experience, would you have to get in order for the camera to activate?
Usually it picked up once you got close to the top of the steps.
Okay. And in your experience, were there times that it didn't do that?
Yes, I guess. I can't say if it didn't pick up, then it didn't record, so I wouldn't know.
So in your experience, if your camera picks up motion and it's activated, does it directly come to your phone or?
Yes.
Okay, and are you able to immediately review whatever the footage is from the motion?
It alerts you when it's motion.
Okay, and
does it give you then a way to watch it, or it just your phone says, hey, there's some motion, but you have to wait till you get home to watch it?
I can watch it from my phone.
Is that something you did often?
No, not really.
Okay. Were you home on April 30th of 2022?
Yes, yes.
Okay, and can you tell the jurors, did you have an opportunity to meet with or speak with officers and detectives while on scene at your apartment on Sunset Avenue?
Yes, I gave it to them as soon as they came.
Okay. And can you tell the jurors what you heard and or saw prior to police arriving?
Prior to police arriving, nothing. I mean, I heard some gunshots, but honestly, I heard some earlier that day, so I just heard some gunshots and I didn't really react until I heard screaming.
Okay. And once you heard screaming, can you tell the jurors what you did?
I looked out to see what was going on.
Okay. And when you say you looked out, did you look out on your mobile device using your Ring camera, or did you physically open your door?
I opened the door.
Okay. And describe to the jurors when you opened the door, what did you see?
It was a young man laying on the ground. There were two ladies, and one of my neighbors were outside.
And prior to this occasion, had you had several opportunities to, I guess, interact with your neighbors, or was it limited?
How you doing? That's it. No conversations with anyone.
Okay, so brief encounter.
Yes.
Okay, and when you opened the door and saw the young man on the ground, could you tell why?
Could I tell what happened to him?
When you opened the door, could you physically see? Were you able to determine why he was on the ground with your observations in your eyes?
Yes.
Okay, and was he shot?
Yes.
Okay, and at that point, what did you do next?
I called 911, but somebody was already on there. So I just walked down. I walked out to kind of see what was going on. And that was pretty much it. Kind of stood downstairs, walked up and down just to see when the police or the ambulance was going to get there.
And you said you saw your neighbors. Did you see anybody else? I guess on the landing or the balcony, and you were.
There was another guy, but I've never seen him before.
Okay. Do you remember? I guess what he looked like, what his hair looked like.
No, not really. Okay. Not really.
And you said you hadn't seen him before.
No.
I said no for the.
No.
Okay. And when you say your neighbors, who are you describing?
The couple that stayed in the apartment.
Okay. So a man and a woman?
Yes. And there was a young lady there too.
Okay. So you just want to make sure we're clear. You saw the woman who's a part of the couple, right?
Mm-hmm.
Yes.
Yes.
And you saw the couple. So did you see the man as well?
Yes.
Okay. Can you describe what the man looked like?
About my height, brown skin, had dreads.
Okay, and when you say had dreads, do you recall how long they were?
I guess down to his waist. I'm not really waist to mid back somewhere up in there. They were long.
And
when you're describing, how many apartments are you're on the top?
Yes.
How many apartments are up there?
4.
So this couple, they lived across from you, or they were in one of the 2 apartments down from you?
If I come out and I'm going towards the steps, it's to the right.
Okay.
First door to the right.
So not the people directly across. If you're going to the steps, it's that first door to the right.
Yeah.
Okay. So it's not your next door neighbor,
No.
like through the wall.
No.
Okay.
so if we're looking at 6 to the 24, if your apartment is close to where the circle is, if you're leaving down those stairs, it's the last apartment on the right, right?
Yes.
Okay. And can you tell the jurors when you came out of your apartment, were you armed?
Yes.
Okay. And tell them why.
I just didn't know if somebody was still shooting. I didn't know what the situation was.
Okay. And after you initially came out, you said you were able to speak with detectives with the Atlanta Police Department.
Yes.
And while they were on scene, did you inform them or let them know that your Ring camera had captured some of the event?
I told them I had cameras. I didn't know how much it had picked up, but yes, I did tell them.
Okay. And after you told them that, did you review, I guess, the footage from your cell phone of anything, if anything, that had been captured and recorded?
Yes. The first officer that I spoke with, he asked me to come to the side so they could get it on their body, I guess the body cam, and I guess took me in front of the car, and I showed them that way.
Okay. And as the night progressed, did you also show a female detective, Detective Barry, the same footage?
The little short lady? Yes.
And did you provide the little short lady detective all of the footage that you were able to find as it relates to anything with this incident?
Yes.
Okay. And can you describe to the jurors when you initially told the police that you had Ring cameras and then you went to review the footage, did you review everything before, during, and after?
Yes. Before, it was just me coming in the house, and then it had the gunshots on it.
Anything that you saw that wasn't you and related to the couple or the young man on the ground, you provided to the Atlanta Police Department, specifically Detective Barry?
Yes.
I want to show you what's been marked. States Exhibit 123. So let's take a look at that. You recognize States Exhibit 123, sir?
Yes.
And can you tell the jurors how you recognize it?
It's a copy of the videos that I sent to the detective.
Okay. And does it have your signature on it?
Yes.
And have you had an opportunity prior to today and today to review the content of the disc, States Exhibit 123?
I mean, I seen it, but I wouldn't say I reviewed it.
You saw it?
Yes.
And what you saw, was it a fair and accurate depiction of everything that you were able to turn over to Detective Barry back in April of 2022?
Yes.
This time out of the state would turn over what's been marked as States Exhibit 123 in evidence.
Ms. Feely, any objection to 123?
We specifically object to the second clip as not being relevant.
Okay. We can talk about that at some point. I'm going to admit 123, and then we'll figure out if we need to get 123A that omits the second clip. I'm going to introduce what Mr. Cunningham has said. This is the entire universe of what I shared with the Atlanta Police Department. And if we need to pare that down, we can. But I'm not sure I'm familiar with what your concern is, but we'll figure out a time to talk about it before it gets played. All right.
Thank you, Judge. And lastly, Mr. Cunningham, in what we turned over to Detective Barry was it for pretty shorter clips that your Ring camera or your surveillance camera had captured of the incident that evening?
Yes, the camera, I think, only picks up for like 15 seconds or something like that.
I don't have any further at this time, Your Honor.
Ms. Feely, do you have any questions for Mr. Cunningham?
Yes, Your Honor, thank you. And that we were just looking at the photo that was up.
Sorry.
It shows your Ring camera, right?
Yes.
And then it showed the railing that is outside the door.
Yes.
Fair to say that is not an exit, right?
No, it's not.
You go back all the way down the stairs.
There's another door on the inside that goes to the other side of the building.
So without entering an apartment, you would go down those stairs.
There's only one way off the landing if you can't go into an apartment.
Yes.
And you mentioned that your Ring camera is typically 15-second clips.
Yes.
In this case, not 15 seconds.
I'm not exactly sure how long that, but I know it's, between 15, 20 seconds, something like that. It's not long.
I'm not trying to trip you up, I'm just trying to.
Understandable.
Now, you also said that it typically you would pick up when you were approaching the top of the stairs, is that right?
Yes.
So it could catch people coming and going?
Yes.
You mentioned that you called 911.
Yes.
Did you get through to 911?
No.
Before this day, you had not seen Mr. Blunt.
Who?
The man on the ground, you'd never seen him before?
No, ma'am.
Any redirect?
One question, Your Honor. Ms. Feely asked you about your surveillance cameras catching people coming in up and down the stairs. You remember that?
Yes.
Did that evening your cameras catch anyone but yourself coming up the stairs?
No.
If it had, would you have turned that over to the Atlanta Police Department?
Yes.
Nothing further.
All right. Any questions from the jurors for Mr. Cunningham? No? All right. Thank you, sir, for your time. Appreciate it. Oh, we do. I'm sorry. I wasn't rushing anyone. I didn't see the movement. Thank you. Counsel. Sir, you mentioned that you tried to call 911, but then you noticed someone else was calling. Tell the jurors how because it was busy or you could see someone?
I was calling and I came out. In one of the clips, you can see me on the phone. I saw another guy on the phone, so I hung mine up.
Okay. And what made you think that other person was on?
I can hear what he's saying.
Okay. So it was a 911 type conversation.
Yes.
Got it. Okay. And was that someone else, someone you knew?
The guy I had never seen. I don't know where he came from.
Okay. Not part of you mentioned there's a couple that lived in that unit, not the man from that unit.
No.
Some other guy.
Yeah.
Okay. Any follow-up, Mr. Abate?
No follow-up.
Ms. Feely? All right. Now you really can go. Thank you. Appreciate it. Next witness?
State calls Officer Coffin.
So we put a call in, Karen, for Zoom. We'll see if someone shows up or tries to do it remotely. Hoffman or Coffin?
Coffin.
Coffin? Okay.
Right. This will affirm the testimony you will give is the truth, and nothing but truth and God.
I do.
Come on in, have a seat. State and spell your name for the record.
Name is Matthew Coffin, Matthew. Coffin is Coffin.
It's investigator Coffin, is that correct?
Correct.
Investigator Coffin, can you tell the jurors where you're currently employed with this audience?
City of Atlanta Police Department.
How long have you been with APD?
Over like 15 and a half years.
And where are you currently assigned now?
To our domestic violence unit.
How long have you been there?
About a year and a half.
Prior to transitioning to the domestic violence unit, where were you assigned to?
To Mobile, Zone 5, which is the downtown area.
And how long have you been assigned to Zone 5 prior to moving to domestic violence?
Like 13 years.
And in those 13 years, would you mind describing to the jury what were some of your job duties as an officer patrolling Zone 5?
No, patrol my assigned areas, traffic enforcement, respond to 911 calls, make arrests, write tickets.
So I'd like to turn your attention to April 30th, approximately 10:15 a.m. Did you receive a signal 50 call at that point in time?
PM, I did.
PM, I'm sorry. Would you mind telling the jurors what a signal 50 is?
It's a person shot.
And do you remember did you respond to 537 Sunset Avenue Northwest, which is the area where I guess you were supposed to respond to?
Yes.
And that was as a result of receiving a 911 dispatch to that location, is that correct?
Correct.
And when you arrive at that location, is that within the limits of the city of Atlanta?
Yes.
Would that be within the jurisdiction of Fulton County?
Yes.
So when responding to that location, can you tell the jurors what that location was?
It's a small apartment complex.
And when arriving at that apartment complex, were you the first officer from Zone 5 responding to the scene?
Yes.
And as the first responding officer, can you tell the jurors what you remember doing when arriving on the scene?
I arrived on scene. There's a small parking lot. I parked my patrol car there. I was directed to the second floor landing of the stairwell to where everybody was involved. I got up there where I saw a male on the ground, bleeding. Appeared to me that he was dead. There was also 2 females there who were very upset.
I'd like to break that down just a little bit for you. So you indicated you responded to the scene and went up the steps. I'm going to show you what's already been admitted to evidence in State's Exhibit 11. So would this be the parking area that you stopped your vehicle at?
Yes.
And you indicated to the jurors that you went up the steps. So I think the screen is interactive. If you press the bottom right portion of the
You just have to touch the screen anywhere, and then there's a little pencil icon in the lower left. Once you tap that, that activates the screen.
So on this screen, would you mind circling to the jurors the steps that you took to get up to the second floor lane?
Those steps.
So when going up the steps, you indicated you would observe some things. Would you mind? You indicated you observed the body. Is that correct?
Correct.
What position was the body in at the time that you arrived and observed?
He was laying on the ground.
And was he face up or face down or something else?
I don't remember.
I'm going to show you what's already been admitted to evidence of State's Exhibit 24. Would that be an accurate depiction of how the victim's body was lying at the time of your arrival on the scene?
I believe so.
When arriving on scene, you also indicated that there were 2 other individuals, 2 females. Is that correct?
Correct.
Would you mind, based on your observations and perceptions of those 2 individuals, would you mind describing to the jury how they were, what their emotional state was?
Do you need the picture up for that?
No.
Okay.
And I would also do relevance. The emotional state of parties that are not.
Are you going to be trying to get into evidence, anything they relayed to law enforcement at that time?
No, Judge.
Okay.
Just based on the officer's observations, arriving on the scene, what he observed.
Okay. I guess at a high level, if they were upset or not upset, you can ask that. But if we're not going to then get into things that they said, then I don't know that it's relevant beyond that high level.
Yes, Judge. And that's all I'm trying to get at.
Okay.
So based on your observations, what did you observe from them?
They were very frantic, very upset.
Now, as a responding officer, are you assigned essentially as an investigator later on to investigate the scenes that you respond to?
Initially or after?
After.
No.
And so when you're there, as a responding officer, you're there to be the initial response, so to speak, to the scene. Would that be an accurate statement?
Correct.
And as the initial officer on scene, how long did it take for other officers to arrive on scene to assist you in your response?
Very shortly, within like a minute or so.
And at the time that you responded, was a suspected shooter on the scene?
No.
And at the time that you responded, did you have an opportunity to take into custody an item of evidence?
Yes.
What was that item of evidence?
A firearm.
What sort of firearm was that?
Black pistol.
I'm going to show you what we have pre-marked for identification purposes. State's Exhibit 164. Your Honor, this is a firearm that has been cleared.
All right, Deputy Gordon says it's okay.
No, but you would, for pre-marked identification purposes, State's Exhibit 164 will just be the pistol that you received.
It looks like it.
And who did you receive the pistol from?
From one of the females.
Officer Investigator Coffin, I'm sorry. At the time that you were working Zone 5 on April 30th, were you working evening watch?
Yes.
And what is the time frame that you worked that shift for during evening?
It's 3 p.m. to 11 p.m.
And you responded to the scene at around 10 to 10:15 a.m. Would that be an accurate statement?
p.m.
Yeah, I'm sorry, I'm saying a.m. I apologize. How long did you stay on scene when you arrived there?
I think I was on scene for somewhere in there about an hour and a half to 2 hours.
Did you leave around midnight?
Somewhere around midnight.
And in the time that you were there for about an hour and a half, what was your main function as a responding officer?
Secure the scene.
By securing the scene, what do you mean by that?
Make the scene safe. Try to identify any witnesses for investigators to follow up with. Render aid if possible to the victim. And then cordon off the area with police tape and just make sure that the scene isn't, nobody trespass on the scene.
Other than receiving the item of evidence, the firearm, did you collect any other pieces of evidence in the case?
No.
Did you actually, other than observing the two females on the landing, did you actually make any contact with any potential witnesses in the case?
No.
Other than assisting with the things that you previously mentioned, such as setting up crime scene tape and things of that nature, did you do anything else on that case?
I don't remember doing anything else.
Would that be consistent with a responding officer who's there to maintain security over the scene?
Yes.
And would any other investigation that would have been done, would that have been turned over to other units in the case?
Yes.
To your knowledge, was that done in this case?
Yes.
I have no further questions for Officer Coffin. Thank you.
Ms. Feely, do you have any questions for Investigator Coffin? All right.
You mentioned you were the responding officer, first on scene in this case, is that right?
Yes, ma'am.
And then you already mentioned you were not the lead detective in this case, right?
Correct.
So it wouldn't have been your call what evidence to collect and what you yourself did, right?
Correct.
And it would have been your job to decide what kind of test to do on a piece of evidence, right?
Correct.
The lead detective would do that.
Correct.
For instance, what test to perform on a firearm that's connected, right?
Correct.
Do you have been the one to collect blood samples, for instance?
No.
And you haven't done fingerprinting?
No.
So your job was pretty narrow on this particular case, is that fair?
Yes,
And you did everything you were
yes.
Any redirect?
No redirect, Judge.
Okay.
Thank you.
Any questions for Investigator Coffin? I see a few. Take your time, write them down. So far, you have pretty legible handwriting. Thank you. Thank you. All right, attorneys, please. Investigator Coffin, one clarifying question and then two things about that night. You are an investigator now. Were you an investigator back in April of 2022?
No, I was a senior police officer.
Okay, and so this was your beat patrol shift and you got the call from dispatch saying person shot, go to that address.
Correct.
Okay. Did you write down the names of people you interacted with at the scene? I don't mean colleagues, but if you interacted with any civilians, witnesses, did you write any of that down?
No.
Who would have been responsible for jotting down the names of either who called 911 or who was standing with the deceased?
Initially, it would have been whoever got the crime scene log, but ultimately it would have been the lead investigator.
Okay, not you.
No.
All right. Did you ever figure out if you were interacting with the person who originally called 911 that resulted in you being dispatched?
No.
Do you know where, at some point you had a gun, your service weapon, but someone gave you a firearm. Do you know where that came from?
One of the females handed me the weapon. It was near the body, but I'm not sure.
Okay. And the female who handed you the weapon, was that one of the two who you said was I think your word was frantic, whatever adjective you used, it was one of the two?
Yes.
Okay. And did that person say anything about where the gun came from or anything about the gun to you?
I don't remember.
All right. Mr. Rao, do you have follow-up for Investigator Coffin?
I don't, Judge.
Ms. Feely?
No.
All right. Thank you, sir, for your time. Next witness.
State would call crime scene tech Sharon Davis.
Swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth. go ahead and have a seat.
Sharon Davis, SHARON, Davis, DAVIS.
Good afternoon. Investigative, how are you today?
I'm fine, but I'm a crime scene technician. It's okay.
He wants to promote you.
I do.
Ms. Davis, how long have you been a crime scene tech?
4 years.
And in all 4 years, have that been with the Atlanta Police Department?
Yes, sir.
Prior to that, what were you doing?
Well, I was in Atlanta's Police Academy. So it was just a few months before that. But prior to that, I did administrative work in different businesses. So I've only worked for the city for 5 years. Mhm.
4 of those years, that's been as a crime scene tech?
Correct.
And so would you mind explaining to the jurors what a crime scene tech is and what are the sort of things that you do with the Atlanta Police Department in that capacity?
Okay, so as a crime scene technician, I respond to calls that an officer on his own, they will raise us through the radio. I have my radio on and ask us to come to a call. You can respond to something as simple as a stolen vehicle to something as complex as 3 people murdered. And while on the scene, you will, especially the more major calls, rapes, homicides, aggravated assaults, stabbings, you're going through the scene and you're looking for things that are of evidentiary value.
At the time that you arrive on scenes, whatever sort of scene that you arrive on, be it a vehicle theft, all the way up to a murder, do you always know what evidentiary value, if any, a piece of evidence may have to the case that you are collecting evidence for?
Yes, and the reason I say yes, from the time that I've been doing it, I walk around off duty looking on the ground because I'm so used to looking for something that's of evidentiary value.
Okay. Do you always, I'm sorry, did I cut you off?
No, sir.
You cut me off, but that's all right.
That's
It's really all right. We were starting at the same time. Are there are you assigned to a specific zone, or you could be zone 6 this morning and zone 2 in the afternoon?
Correct.
Okay, so you're sort of at central command and you're going where the investigators or sergeants or someone say, hey, we need a crime scene tech.
When a officer who is the first one on the scene gets there, they raise us. So you could go to zone 1 at one point, and then you can get a call later to zone 6, and then you can get a call to zone 2. So we go around the entire city, and the airport is also a part of it. That's called zone 7.
Thank you.
Gotcha.
Sorry.
No, you're fine, Judge. I appreciate it. Okay, so Ms. Davis, you've how many crime scenes would you say you responded to during the course of your 4-year career with the Atlanta Police Department?
Too many.
I understand. I get the feeling.
Too many major ones on top of that, but a lot.
Okay. So suffice it to say, the case that you're here to testify for, that would not have been the first homicide scene that you responded to.
No, it was not.
Okay. So I'd like to turn your attention to that evening of April 30th, up into the morning hours of May 1st,
Yes.
2022. Did you respond to 537 Sunset Avenue, Northwest Atlanta, Georgia?
Yes.
Okay. And what was the reason that you responded to that location?
There was a homicide there.
Okay. And when crime scene techs are called in, how do you arrive on scene?
I drive it up in my crime scene vehicle.
Okay. Is it just you by yourself or someone else? Or are there other individuals assisting you?
This particular day, my supervisor was with me, and there was another crime scene technician.
Okay. Were you working a specific shift at the time, or were you on call, or
No, I worked this specific shift. I worked what's called morning watch, and I start work at 11 at night, and I worked until 7 in the morning.
And as far as you can recollect, when did you receive the call to arrive at the location we previously discussed?
It was very early in my shift, so about 11:30-ish.
When arriving on scene, were there other members of the Atlanta Police Department already on scene?
Yes.
Okay. And when arriving on scene, and I'm just talking about in general, not the specific crime scene, what are the sort of things that you do in preparation to investigate a particular scene to collect any items of evidentiary value that you might believe they have?
Okay, so when I get there, I let radio know that I've arrived on the scene. And then I ask an officer to give me a walkthrough, and they will take you through the scene and walk you through and tell you some of the things that they pointed out. And we work in tandem because there's times, again, my eyes are like so trained. I'm like, oh, there's something. But in general, you're given a walkthrough through the entire scene.
And would that have been consistent with how things went on the, I guess, morning of May 1st when you arrived on scene?
Yes.
Okay. And do you remember who the officer was that you did the walkthrough with?
I don't remember.
But would it be fair to say that you did do a walkthrough of the scene before you started collecting items?
Yes, I don't know if it was with him or with the homicide investigator.
Okay. When you arrive on scenes, do you typically simply take direction from, I guess, the investigators on scene or officers on scene, or do you conduct an analysis of things that you yourself might think could be items of evidentiary value?
It's together. So I will point out something that I've seen and that and ask them, can I take it?
Okay.
So it's their direction along with my input.
Okay. Now, I'd like to first at least maybe skip ahead to the items of evidence that you ultimately did collect, and then we'll collectively go through some of the other things that you did before you created a log. So with respect to the items that you did collect, do you remember what specific items you collected for this particular case?
I collected shell casings.
Okay. Do you remember how many shell casings?
I believe they were 8.
Okay. Would it refresh your recollection if you had a chance to look at your crime scene tech report?
I looked at it. It was 40. It was 840 S&W.
Okay. And so would that be the shell casings that you recovered from the scene?
Yes.
Okay.
40 is the caliber. The S&W is Smith & Wesson.
Okay. And we'll explain what a shell casing is, but I just want to make sure that we have an understanding of all the items that you collected. So in addition to those 840 caliber shell casings that you recovered, did you recover a firearm in this case?
I recovered a firearm that was behind a sofa, I believe.
Okay.
Somewhere tucked in the corner. I recovered projectiles underneath the victim once the ME removed him. And then across the hall, the apartment across from there, I recovered a projectile from there.
Okay. So those are some of the things that you did collect in this particular case. So prior to collecting those particular items, what sort of things did you do on the scene to determine what even to collect at the time?
I saw them, so I know that I need to take shell casings. I don't leave them there.
Do you immediately pick up pieces of evidence?
No.
Okay.
No.
So
I come into the room and I photograph the scene. So if I came in here, I would start photographing and then I would do the entire room because you're trying to get what's called in situ. That's what they teach us in our basic photography class. And that just means that the scene is as it was. And then I go through and I photograph the scene. And then when I see evidence, I take 3 photos and then of that particular item, I finish my scene. scene, then I go and I put placards and I take 3 more photos of that item and the overall of the whole scene with the marker numbers.
Okay, so you first take photographs of the scene as is, you
Yes.
then proceed to identify pieces of evidence, place placards on them,
Yes.
take photographs of those placards, and then ultimately you conclude with
Recovery.
actually recovering those pieces of items. Would that be an accurate statement?
Correct.
Okay. Now, in this particular case, did you take photographs of the crime scene in the manner that you just explained to the jury?
Yes, I did.
Okay. I'm going to show you what I have, what's already been pre-marked for identification purposes as State's Exhibits 12 through 99. I believe State's Exhibit 24 has already been admitted, as well as State's Exhibits 118 through 122. Did you already have a chance to review the photographs?
Yes.
In this case?
Yes, sir.
And are they a fair and accurate depiction of the crime scene as you observed it, both as is with the placards that you ultimately put on and the placards that you ultimately put on near the items of evidence?
Yes, sir.
Okay. Your Honor, at this time, the state would seek to admit State's Exhibits 12 through 99, as well as 118 through 122.
Okay, and 24 is already in, but those two ranges, any objection to admitting those photos, Ms. Feely?
No.
They're all admitted.
So we're going to take a look at some of the crime scene photos that you took in this particular case. All right. Ms. Davis, would this be the location that you responded to in reference to your investigation?
Yes, sir.
Okay. And I'm showing State's Exhibit 11. Now, prior to, in a situation like this, or in a scene like this, do you also take photographs of, I guess, immediate or adjacent areas, or is it common for you to do that in order to get an orientation of the location?
Yes.
Okay. And State's Exhibit 12, would that be an example of that as well?
Yes.
Okay. Move on to State's Exhibit 13. So in State's Exhibit 11, looking at the overarching building, would this be to the right of State's Exhibit 11?
11? This is photo 13. What was 11?
I'm sorry, what's being shown to you right now is State's Exhibit 11. Would this be to the right of State's Exhibit 13? Would that be to the right of State's Exhibit 11? So it's.
Yes,
Okay.
the street, I'm just trying to orient
Yes, ma'am.
myself because the apartment was close to the street. I think that was Sunset. So to
Gotcha.
the left was the street and yes, to the right was this building.
Gotcha. So that's State's Exhibit 13. And State's Exhibit 14, if we look back at State's Exhibit 13, we can go back real quick. State's Exhibit 13, you see sort of an archway, if that's even the proper term, in the middle of the photograph. And if you go on to State's Exhibit 14, would that be a different angle of what we see on State's Exhibit 13?
Yes.
Okay.
This 14 is more the backside of the building.
Uh-huh.
So it was just a different angle.
Gotcha. So as we look on to State's Exhibit 20, would this be a close-up of the stairways that we saw previously on State's Exhibit 11?
Yes, so this is what I would call overall leading. I'm trying to show by the photos where I'm going. So I'm going up the stairs to the apartment on the left.
Gotcha. State's Exhibit 24. When going up the steps, was this the scene as you observed it when you arriving?
Yes.
Okay. Now, in your report, you indicated that you marked the body as exhibit marker number 1.
Yes.
Why do you typically do that?
That's something that homicide likes. So it's just something that I do now.
Okay. As we transition to State's Exhibit.
What do you want? You should tell him what number you want next rather than him randomly pick one and then you talk about it.
So as we transition to State's Exhibit 25, and actually it may, if I may, actually. The shell casings that you observed and collected in this particular case, do you recall where exactly it is, or would you mind telling the jury where it is that you found those shell casings?
So this photo that you have up here, when you first walked in and behind the door by the dishwasher, there was a shell casing. There were shell casings in the living room. There was a shell casing on the couch. That's the one that's in the kitchen. I believe that's a dishwasher.
Okay.
There was some in the living room and there was one on the couch.
All the shell casings that you recovered at this scene, were they found inside the apartment, or were they found, were some of them also found outside?
All shell casings were recovered from the inside.
Okay. And so as we go to State's Exhibit 41, when we previously saw State's Exhibit 11 and any close-ups thereof, we saw a staircase. With State's Exhibit 41, what we're looking at, is that the same staircase that?
Yes.
Okay. And to the right on State's Exhibit 41, would that be the apartment where you recovered the shell casings in this case?
Yes.
Okay. So as we transition to the photographs inside the apartment, start with State's Exhibit 48. So as I'm standing, or as if we were standing on that landing, if we were at the incident location, would this be the room that you entered into to collect those shell casings?
Yes.
Okay, and I'm showing what's been admitted as State's Exhibit 48. State's Exhibit 50, please. So while in State's Exhibit 50, while previously having looked at State's Exhibit 48 and looking through that door, State's Exhibit 50, would this be what we would have been looking at?
Yes.
Okay. And this would just be another angle?
Yes.
Okay. Now, as we draw our attention to State's Exhibit 51, You indicated that you observed a shell casing, or you collected shell casing, State's Exhibit 51. Do you see a shell casing in this particular case,
Yes.
in this photograph? Would you mind, so the screen is interactive. I think if you press on it, you should have the option to
If you touch it once, there should be a little pencil icon in the lower left-hand corner. So tap it and then look in the lower left-hand corner, tap that pencil, and that empowers your finger to now be able to draw on the screen.
And so State's Exhibit 53. Is that a close-up of State's Exhibit 51?
Yes.
Okay, and
So that's what's called a mid-range. 54 is more of a close-up.
okay, I'm gonna show you 54. So 52 through 54, State's Exhibits 52 through 54, they all, would it be fair to say they all accurately depict the same thing, just at different ranges?
Yes.
Okay. State's Exhibit 60, please. Is this, what is State's Exhibit 60 meant to depict?
The shell casings on the floor.
Okay. And State's Exhibit 61, would that be a close-up of State's Exhibit 60?
What is going on with this computer?
Can you go to 61?
He's trying.
Okay.
We just constantly have technical difficulties,
And
unfortunately.
what's 62?
I should be banned from the computer.
Okay, so that 61 is a close-up.
Okay. 61 and 60 are essentially depictions of the same piece of evidence, but at different angles. Would that be accurate?
Yes.
Okay. And once we get it up and running, I will show you what's been pre-marked or what's been admitted as States 63 and 64. Okay. So I believe what's being shown right now is, okay, so now it's 63.
That's a mid-range.
Okay.
And then 64 was the close-up.
And States Exhibit 65.
That's a close-up.
Now, you previously indicated that you recovered a firearm in the case. Where did you recover that firearm?
Behind this couch.
Okay, so I'm gonna show you show you States Exhibit 59.
Mhm.
I must stay on mine.
Yeah, me too. All right, so State's Exhibit 59. So previously, we had seen photographs from the landing looking inside the apartment. So if I were to walk, if I were to open the door and I were to go just directly straight, would this be the area that I'd be walking through?
Yes.
Okay. And so in State's Exhibit 59, I know it's really dark. Can you see the couch from which you recovered the firearm in this case?
Yes.
Okay, and can you circle the general area for this, for the jury on State's Exhibit 59 to show
Half
them?
or circle?
Circle, please.
A circle, but nothing came up.
So you may have to renew your power because I think they took images off the screen and put them back on. So if you tap the screen, does the little circle with a pencil in the lower left-hand corner come up again?
Yes.
So do that. Sorry about that, but they went out of the software and came back in.
Okay.
There you go.
All right. So that would, is that the general area or the area that you're circling? Is that where the couch generally is?
Yes.
Okay, so I'm going to show you what State's Exhibit 69.
So is the couch that was against that far brick wall, it's actually bright red and it was dark?
So, I'm sorry, that's 67.
This couch was to the left. That black couch was to the front, like the way that he explained it. When you walked into the apartment, you went through a little kitchen and then you went into a living room and there was a black couch up against the window and there was a red couch up against the wall.
Okay, now we see a black couch. Okay.
I apologize. I meant to say 67. So on State's Exhibit 67, is that the couch that we saw you circle in the previous exhibit?
Yes.
Okay. If you can you tell the jurors, did you recover an item of evidence from this particular couch that you can see on this exhibit?
I recovered the firearm that was on under it.
Okay. Can you circle for the jurors the firearm that you recovered? Okay, thank you. And just for the record, there's I think 2 circles on State's Exhibit 67. The smaller circle, would that be the gun that you ultimately recovered?
Yes. For whatever reason, the circle is staying there from when I circled the couch where it was.
Right, it'll stay on because this is actually one giant photo for the state that they're scrolling through, but you can erase, if you tap the screen, a little eraser, but what you'll actually do is you erase in reverse order. So it'll make your little one go away first, but that's okay.
Okay.
If you're going to be asked to annotate more things, I'll have you erase all those.
Okay.
Thank you.
Thank you. So as going to now State's Exhibit 69, what did you collect on State's Exhibit, or what was the significance of State's Exhibit 69?
The shell casing on the red couch.
Okay. And where was the red couch positioned in relation to the black couch?
The black couch was here and the red couch was here.
So if I was sitting on the black couch right now, where would I need to look in order to see the
To
black
the
couch?
right.
To the right. And was it adjacent? Was it at like a 90-degree angle or something else as far as its position in relation to the black couch?
It was an angle like this. So the black couch up against the wall, the red couch, and there could have been a table right there. I don't remember.
Okay. I'm going to show you State's Exhibit 70. 71 and 72 as well. Would 70, once you're reviewing, once you're finished reviewing them, 70, 71, and 72, are they essentially depictions of the same thing but at different angles or
Yes.
different ranges?
Different ranges.
And what is State's Exhibit 72 that's depicted in State's Exhibit 70 and 71?
A 40 caliber shell casing.
I'm going to show you State's Exhibit 76 and 77. Seventy 76 and 77, do they both depict the same things but at different ranges?
I haven't seen it yet.
Oh, I apologize.
And I can't see the number on the bottom of the photo that, okay, 76.
So now I'm showing you
Yes.
76.
Okay.
And then in looking at the next photograph, which would be State's Exhibit 77, would they be a depiction of the same thing but at different ranges?
Yes.
And what is State's Exhibit 77 that's depicted in State's Exhibit
A
76?
40 caliber shell casing.
Now transitioning to, at that point in time, as you have taken all the video, or excuse me, photographs that we've discussed thus far, at that point in time, had you done any sort of evidence marking or collecting any sort of pieces of evidence?
No, not yet.
Okay. Was the next step to place placards on those pieces of evidence that you deem to be important?
Yes.
Okay. So State's Exhibit 80, evidence placard 1 and 2. What are State's exhibits, or excuse me, evidence placards 1 and 2 that's depicted on State's Exhibits 85?
Number 1 was the deceased victim, and number 2 is the cell phone next to his right hand.
Okay. And State's Exhibit 88. What is that? What is State's Exhibit 88, evidence placard 3?
Keys.
Okay. And do you know whose keys that they belong to, or what was the reason for you to collect those keys?
I was told by Investigator Barry she wanted those keys. I don't know through her conversation if someone said that those keys belong. Okay, sorry.
Right, that's okay. We stopped at the right spot.
Okay.
So did Investigator Barry said, please make a picture of those.
Yeah, she wanted those collected, so
Okay.
yes.
Okay. And that was the reason for you collecting them, is that correct? Okay. So State's Exhibit 89, we see a number of evidence placards, 4, 5, 6, and 7. What are they meant to, what are placards 4 through 7?
40 caliber Smith & Wesson shell casings.
And would those be consistent with the shell casings that we saw in previous exhibits that I guess we'll describe as the as-is photos?
Yes.
Okay. And placards 4 through 7 depicted on State's Exhibit 89. If I were on the landing walking to the apartment, would I be walking straight and then seeing placards 4 through 7? If I
Yeah.
walk straight through that kitchen,
Yes.
would that be where placards 4 through 7 would be?
Yes.
Okay.
Is basically the transition point from kitchen to the living room with the black couch and the red couch, if you're looking down, which it
Yes.
sounds like you always are, it's the end of the kind of whitish linoleum, and then you get to,
The hardwood floor,
Got it.
yes.
And as we transition to State's Exhibit 92. What evidence marker do we see there?
9,
And is that, what is 9 meant to indicate?
the shell casing.
Evidence placard number, excuse me, State's Exhibit 93. What do we see on State's Exhibit 93?
Marker number 11 intended to mark the firearm that was underneath the black couch.
when you collect a firearm, do you figure out what kind it is, or that's not your job? You simply say, I got a gun and it's called number 11, as opposed to it's a 380 or it's an AR-15.
So after I do my photographs and then I'm ready, because I'm a civilian, I get an officer to clear the firearm. They pick it up, they clear it, I put it in a gun box. And while it's in the gun box with the marker, that's when I then take more photos. I photograph the inscription, the serial number, and the caliber.
And when I think it's a term I used previously, when you say clear the firearm, what are you trying to convey to the jury?
They're making it safe.
Okay. And is that by making it safe, do they take any sort of bullets out of the firearm and out of the barrel of the firearm?
Yes, so when they're racking it, clearing it, one may pop out that was in the chamber.
Mhm.
And so you'll have the one that was in the chamber. And then if there were casings in the magazine.
Were you present when the gun was cleared?
Yes,
And did anything come out of the chamber of the firearm when it was cleared safe?
I think, I'm not sure.
Okay.
I have to look back at.
Would it refresh your recollection if you had a chance to look at your report?
I don't think that anything was in it. I'm looking at my report and I do not indicate that there were anything else in there.
Okay, so there was no bullets inside the gun at the time that you recovered it?
Correct.
All right. So as we transition to State's Exhibit 94, evidence placard 12, what is that meant to convey?
The .40 caliber shell casing. And that was discovered last when the door closed at one point when I was trying to photograph items, because the numbers are supposed to go in some type of sequential order. So the 1 and the 2 were outside. And then when I went inside, you had the 3, which were the keys, and then 4, 5, 6. And the firearm under the couch is 11. This is 12. If it had been seen sooner, it would have been number 3.
So as you go in and do your look around through the apartment, and as you're exiting back out the same way you came in,
I noticed that shell casing.
okay, and that's evidence placard 12, which is depicted on State's Exhibit 94, is that
Yes.
correct?
Correct.
So as you're making your way back out, we'll transition to State's Exhibit 97. Evidence placards 13 and 14, what are they meant to depict?
The projectiles that were found underneath the victim. So at this point, the ME had been there. They did their assessment. I don't touch the body. I don't touch the body, period. But then when the ME comes, they come, they assess, they show you where defects are. They rolled him over. Once he was rolled over, we noticed the projectiles.
Gotcha. And I'd like to just previously go back because I wanted to explain the difference between a projectile and a shell casing
Yes.
to the jury. So as we go to State's Exhibit 96, is that an example of a shell casing?
Yes.
Okay. And do you know what the difference is between, based on your training, knowledge, and experience as a crime scene tech, what the difference is between a projectile and a shell casing?
It's a whole casing, if you will, and it has ejected from the right of the firearm. The projectiles usually hit something hard or bone or cement, and it just becomes it's more hard and lumpy. It's not a covering like a blanket, if you will.
Gotcha. So State's Exhibit 96, that's a shell casing that would have separated when the gun is fired. Is that an accurate statement? Okay. And as we transition back to State's Exhibit 98 and do in 99, which would be I guess in your words, would State's Exhibit 99, would that be a close-up of State's Exhibit 98?
Yes.
Okay. And evidence placards 13 and 14 that are depicted in that exhibit, what are they meant to be?
They're projectiles.
Okay. Now, did you have a chance to go into a different apartment other than the one that we previously looked into?
Yes.
Okay. And that apartment, if we go to State's Exhibit 11, please. So the apartment that we've been discussing about at length, if I were to go up these steps, would I have to make a right or a left to get into that apartment?
Right. That we've been discussing at length, or where the projectile?
The one that we've previously been
You
discussing.
would go to the left.
So go to the left.
Yes.
Now, the projectile that we'll discuss in State's Exhibit 88, was that found in the apartment across from the one that we've been talking to?
Yes.
Okay, we've been talking about. So on State's Exhibit 11, if we go up those steps, we would make a right. Is that correct?
Correct.
Okay. So going to State's Exhibit 118. Would that be the projectile that you recovered from the scene or from that other apartment?
Yes, sir.
Okay. Now, going back to the landing briefly. On State's Exhibit 43. Was this the door, or excuse me, I'm sorry, before I get into that, State's Exhibit 43, what is that meant to depict?
The defects in the door.
Okay, and the door, was that in the apartment where you recovered the gun from, or was that the apartment that you recovered the projectile from?
The one that I recovered the firearm and the shell casings.
Okay. And on State's Exhibit This would be the exterior of the door, is that correct? Okay.
Correct.
And on the exterior of the door, we see you labeling multiple different areas, A, B, C, D, E, F, G, H, right?
Yes.
What was the reason for you doing that?
To notate the defects in the door.
So there's no letter C. Did it fall off? You don't like the letter C?
I have a feeling that it must have fallen when
Okay.
I was photographing. So yes, I like the letter C.
Oop,
Okay.
there it is. He made it back. So you started from the top, the highest defect, got an A, you went all the way down to H, wherever it ended.
Yes.
And there is a C, it looks like we can see, but I guess at some point it popped off.
Mm-hmm.
And as we look at State's Exhibit 52, is that the same door that we've been previously discussed in the previous exhibit? Okay.
Yes.
And I'm looking at State's Exhibit 51. Is that the same door that we previously discussed in the recent exhibits?
Yes.
And did you see any thing of note or observe anything of note at the time to make you take this particular picture?
Just to note the defects.
Okay. And this would be the interior of the door?
Yes.
Or, okay.
The interior door.
Now, we've talked about one particular firearm that you collected into evidence. Did you also have a chance to collect another firearm or take pictures of another firearm?
I took photos of another firearm that had been recovered.
And I'd like to show you State's Exhibits 121 and 122. What was the reason that you took a photograph of State's Exhibit, of the gun depicted in State's Exhibit 121 and 122?
To make notation of it, it was what's called a chain of custody issue. So it was removed from the original scene and given to the officer. So I then come in and photograph it just to have no notation of it.
I'm going to show you what's been pre-marked for identification purposes. State's Exhibit 164. State's Exhibit 164, would that be what's depicted on State's Exhibit 121 that we're looking at right now?
I can say yes, but I only photographed that one, so.
Can you go to State's Exhibit 122? All right. What model is depicted on State's Exhibit 122?
Can we scroll down some? Because it should be down here. Just like, it's a .40 caliber.
Okay. And what are the other things that are indicated?
The Glock is the manufacturer, and then the 22 Gen 4 is the model number.
I'm gonna have you read what you see in that same general area on 122, State's Exhibit 164.
Glock. G22, it's a 40 caliber. It had a laser and a magazine with 8 rounds and and they were 40 caliber ammo.
And would you need your glasses to read this portion?
No, it's a Glock 22 Gen 4 Austria, and .40 is the caliber.
Now, in addition to taking photographs of these items, did you actually collect the shell casings, projectile, and the firearm recovered from that first apartment?
Yes.
Okay. We'll approach you with what's been pre-marked for identification purposes of State's Exhibit 161, 162, and 163. You have a chance to just quickly look at those and let me know when you're done.
Am I opening it or just looking at the envelope?
Just looking at the envelopes.
Okay.
You recognize those exhibits?
Yes.
How do you recognize those exhibits?
My handwriting.
And so when you collect exhibits, or excuse me, items of evidence and mark them, is there a specific technique that you and members of your profession use to identify items of evidence later on?
I'm sorry, can you repeat that?
Certainly. So in instances where you are asked to identify that these are the items that you've collected at this particular scene, is there something that you do in order for you to recall that this is what you picked up on that day?
So once the shell casings are picked up, and just like the firearm, again, I'm looking at it to determine what caliber the shell casing is, and the homicide investigator, they need to know as well. So we look on the scene for what's called the head stamp, and the head stamp will tell me what type of shell casing it is.
But after you collect those and throw them in what looks like a paper bag.
No, it's little envelopes in here, what's called bullet bags. So each casing has its own house.
Okay, but then you put all those houses in a larger hotel or whatever we want to call that.
Yes.
What do you do to that brown bag, if anything, so that it's been a year and some months that you know we're talking about the work you did? Is there something, you autograph it? Do you put your fingerprint on it? How do we know that that bag in front of you is the result of your efforts of photographing and collecting and putting in little envelopes?
My initials are on the bag. And so when we collect the shell casings, and I come back to the office and we actually do more work, we put them in a super glue chamber, and you're looking for fingerprints. Then after that, it goes to the ballistics lab. So this was then sent to the ballistic lab for them to conduct ballistics on it.
So conducting ballistics would not be something that you yourself would have done?
No.
Right? Okay. And as you indicated previously, I believe to Judge McBurney, you sign off with your initials to indicate that these are the items of evidence
Yes.
Collected from that particular scene. Right?
Correct.
And does it provide an incident location as to where those items of evidence were collected on all three of those state's exhibits?
Yes. 537 Sunset Avenue, 537 Sunset Avenue, 537 Sunset. I wrote street on here, but it's Sunset Avenue.
Okay. Do they all share the same APD case number?
Yes, they do.
And Your Honor, at this time, are they in, from your observations, are they in a fair and accurate depiction, or are they, have they been tampered with in any way, shape, or form that you recall since your collection?
Yes.
Okay.
I mean, not in a bad way, but I don't have green tape. And so this, you can tell, went to the ballistics lab, then they opened it and then retaped it. I have red tape.
Okay. So that would be consistent with transitioning or sending those items of evidence to a different agency for
No,
processing?
it's within Atlanta. It's upstairs from us.
Okay.
It's the
But
crime lab
sending it to a different
department.
for their analysis?
Yes.
Okay. Your Honor, at this time, the state would seek to admit state's exhibits 160.
163.
162 and 163.
All right. Any objection? Just those three, not, I don't know if 164 is up there, the box.
No, Judge, it's, I believe it's. No.
That's 163?
Yes.
Okay.
So it's 161 through 163.
All right. Any objection, Ms. Feely, to the admission of 161 through 163?
No.
They're admitted.
So wouldn't mind putting on this gloves. We'll start with 163.
Bless you.
Would you mind removing the firearm from the box? Would you mind displaying it to the jury?
Don't point it at them, but you
Yes, I
can.
won't. That's
right,
why I'm looking like
right,
which
except
way.
this,
Like
there we
this?
go. Yeah,
Okay.
you can point it at him.
That's fine. Lots of people.
Or down.
Yep.
Okay, and would this be the item, the firearm that you recovered from the box?
Yes.
Or from the couch?
Yes. Yes.
And put in mind opening up state's exhibit 161. If you wouldn't mind,
taking them out.
for lack of a better word, dumping the contents. So I noticed that exhibit number 161 has multiple little baggies inside. How many baggies does it have?
8.
When collecting shell casings, is it typically the normal practice to separate those shell casings into individual baggies?
Yes.
Okay. And just for the jury's edification, if you wouldn't mind just opening up at least one of them and displaying the shell casing.
So on the envelope, I also write 12 marker numbers. I put the marker number, the date it was collected, the time that it was collected, the address, and where I recovered it from. This is marker number 12, and it says recovered from kitchen floor behind door.
This would be the shell casing where we saw the yellow card with the big 12 on it.
Yes. And then while my eyes have even grown accustomed to, I can tell the size of shell casings from a distance. You can tell 40s, they're big compared to 9s. I need something new to do. You want to touch it with no glove? Okay.
Okay.
This would be the 40 caliber shell casing.
Yes.
With Evans 5 or 12, correct?
And then showing the head stamp might help. They could see caliber. Gotta get a little closer.
And this will all be in evidence. You'll have it in the jury room to look at. I don't know that the gun necessarily goes back there. I don't, got a head shake on that one, but the projectiles will go back there if they're things you want to look at, and the shell casings.
And state's exhibit.
Wait, are you gonna tape this back?
That's its home.
That's his what?
That's its house.
I don't want him to escape from his house, so it needs to be taped back.
So with respect to state's exhibit 162, would you, what is state's exhibit 162?
The projectiles.
Would you mind opening 162? How many little baggies are in state's exhibit 162?
3.
That'd be consistent with the 3 projectiles recovered from.
Yes.
So this time I'm gonna ask if you could open up all of them,
Mm-hmm.
and once you're done, just let me know, we'll just place them on my.
I'm sorry, do what?
Once you're done, just let me know and place them on my hand.
On your
Just ask
hand?
for
Okay.
permission to publish the jury.
Okay.
You can use the overhead projector if you want. You're also welcome just to hold them in your hand and wander, whatever's easier. Actually, you guys touching the overhead projector, I don't even know what'll happen.
We missed that. Well, that'd be great for the photo.
That's how it used to be back in the old days.
Yeah, no, I'm pretty sure if you go, there's a side, nope, to the side. Does that open and is there, it should slide out. It works really well. If I may have to do something from this end, but turn it on, please, and let's see. I think I have paper. So is there a green? No, let's see. Yeah, no, I have to do something from here. Podium. I click on share content, camera. Is that thing on?
Appears to be, the red light just went off.
All right, hold on. All right, try putting something on it. Like your hand. There, it works.
Perfect. Interesting.
Anything to get Mr. Abate off scrolling through those pictures.
I am happy enough.
Man, we haven't used that in a little while.
That's 13.
You got 14 as well?
Yes.
You're gonna know which goes in which bag when you put them back?
Yes.
Okay. So those were recovered from underneath the victim.
You got 13.
Yes.
So what, the first thing that I've dropped down, that would be what was recovered from evidence placard 13.
Yes. And that was 14.
14. Okay.
Then you need to, there's like a zoom and focus button. I think I can do that, but I'm gonna let you try first, so it's a little less fuzzy.
Yes.
Now that's unfortunate. So you jostled it in some way. Try the,
Let me turn it back on.
yeah, on is probably good. All right, hold on. It's on?
I have a blue light.
I don't know if that means it's on. Okay. If I can figure it out again, I'll let you know.
Yes, sir.
It's there briefly.
Make sure they go back in the same.
13 was the smaller one.
That's why. So I'm both helpful. And the last projectile?
This one came from the apartment across the hall.
So the specific projectile I'm holding in my hand and publishing to the jury, that came from the other apartment?
Yes.
Now, after responding to the scene, doing the initial walkthrough, taking the photographs of the incident location, and ultimately collecting the items of evidence, some of which we've displayed to the jury, did that conclude your involvement in this case?
Yes.
So I'm going to show you what we'll eventually have marked as State's Exhibit 166. Now we had skipped over a couple of evidence placards, placards number 8 and 10. Did you see that on State's 166?
I do.
And is that a fair and accurate depiction of evidence placards 8, 8 and 10?
Yes. 8 through 10.
8 through 10. Your Honor, at this time, the state would seek to admit State's 166 and evidence.
Have you had a chance to see it, Ms. Feely? Any objection?
No.
Admitted.
You could say 8 through 10.
Yes, ma'am.
So I know during the course of our examination, we skipped over a couple of placards, placards number 8 through 10. I'm going to quickly have or shortly have 166 displayed.
Okay.
There we go.
I didn't want to say anything, but I was like, oh, I know I
Don't
put
worry.
an 8 out there.
We got it. With respect to, I know we only saw photographs of placards and relating to 6 shell casings. So evidence placards 8 and 10, what are they meant to denote?
8 through 10.
Or excuse me, 8 and 10, I apologize.
8 and 10?
8, 9, and
Because I have a 9, 8 through 10.
Correct. So I know we've already discussed evidence placard 9
Okay, I'm
previously.
sorry.
So
8
evidence
and 10.
placard 8 and 10, what are they meant to convey?
The 40 caliber shell casings.
Okay. And those shell casings next to evidence placards 8 and 10, you collected those as well in addition to the other shell casings we previously looked at, right?
Yes.
Okay. Thank you, Ms. Davis. I appreciate your time.
You're welcome.
Ms. Feely, do you have questions for Crime Scene Tech Davis?
So you told us about your role in this particular case, right?
Yes, ma'am.
You took all the pictures we just looked at
Yes, ma'am.
and you collected evidence that we looked at.
Yes, ma'am.
And you created a log of what you did.
Yes, ma'am.
So that's your portion of the case. Is that fair?
Yes.
And it's not up to you to determine what testing is done on that evidence, right?
Correct.
You wouldn't be the one to do the ballistics, for instance.
No.
You wouldn't do the DNA testing.
If they asked, then we would do touch DNA on the firearm, but that's at the direction of the investigator.
So you did not collect DNA in this case?
No.
And if
then I would just recover it and it's sent to the GBI.
That was my next question. You wouldn't do the actual DNA testing. And if you had collected blood samples, you wouldn't do the testing on those, right?
I would just collect it and it would go to GBI.
And I think you mentioned you take fingerprints, but you don't do the fingerprint analysis. Is that right?
Correct.
And you mentioned at the very beginning, when you get to the scene, you're not the first person there.
No, I'm not.
And the scene is already secured by the time you get there.
Yes.
And that's to preserve evidence.
Evidence. And to preserve me as well, because I'm a civilian. So the scene is made safe for me to come in.
And collect the evidence that you did in this case.
Yes.
And to protect the integrity of the investigation.
Correct.
Right. And when you found the firearm under the couch, you took a picture before anyone touched it. Is that right?
Correct.
And you didn't touch any of the shell casings or anything like that. Is that right? Before you photographed them?
Correct.
And so it's fair to say it would not be best practices for someone not related to the police to remove a firearm from a body, right?
Correct.
And if there had been one there, you would have photographed it, right?
Yes.
But in this particular case, you learned that there was in fact a second firearm.
Yes.
Because you in fact photographed it.
Correct.
Where it was. Is that right?
Correct.
But we can't tell now where that firearm was located near the body, right?
No.
Whether it was in somebody's hand.
Right. I can't because it was in the vehicle. The first responding officer who it was given to can attest to that. I saw it in a patrol vehicle.
I'm not criticizing your role at all. You did what you're part of the case as thoroughly as you've been trained to do it, right?
Correct.
Thank you.
Any redirect?
Just briefly, Judge. I do mean brief. So with respect to the other handgun that you took a photograph of, but was not actually at the scene when you arrived, obviously you had a chance to take a photograph of it. Did you know where that firearm came from?
I think they said that. I don't know where, honestly. It came from someone. I don't know who. My apologies.
No, that's okay.
It was really, really crazy out there. So that I don't remember where it came from, other than it was in the patrol vehicle.
But it was in the patrol vehicle for you to take a photograph.
Correct.
No further questions.
Anything else, Ms. Feely? Any juror questions for Ms. Davis? I see a few. We'll take those. We're going to be taking our afternoon break after we finish with Crime Scene Tech Davis, so hang in there.
Way to do it, even if you do it, because you can't do it with JPEGs, because you have to put the evidence sticker on.
Thank you.
When it's on there, you get to control what, it's impossible to do.
Try not to write on the back of the cards, please. With an infinite supply.
We didn't do that. Everything else. It's not good for us. It's not our fault.
All right, lawyers, please.
Yes.
All right, Ms. Davis.
Yes.
Do you use a flash when you take your photos?
I do.
Do you decide when the flash goes off, or the brains of the camera decide?
Of the camera decides.
All right.
That was indoors. You didn't necessarily need a flash, but you'd have a flash. It's called an external flash. So it goes on the top of your camera. And then sometimes if it's not giving you enough light, I use a flashlight and I like aim it somewhere so the camera, you'll hear it like it'll give this soft little beep and it's telling me that it's sensed enough light.
Do you go in areas, and I don't mean like open a drawer, but walk around in this apartment, for example, that officers don't take you to take pictures?
No.
So if there was a door that was closed in the apartment and no officer or detective opened it, you're not going to open it to see, hey, is there a shell casing or a body or something in there?
No. Unless beforehand they said what they were looking for in the search warrant. So then because I want to work efficiently. I don't want to have to come back to the scene because they discovered something else.
Okay.
So yes, if the search warrant said what they were looking for, then I might open the door.
Okay. Was there a search warrant in place for this apartment you were looking through?
No.
Okay. The apartment where you took most of your pictures, the one that had the 8 shell casings in it.
Yes.
There's one door that went to the outside. You took pictures of that. Do you know if there were any other exits, doors that went to the outside for that apartment, the one with the 8 shell casings?
If I can recall, I feel like there was another door somewhere. I feel like the apartment had 2 doors.
Okay. You took pictures of keys. I think that was placard number 3.
Yes.
Did you ever find out whose keys they were?
No, because they were given to the investigator.
Okay. Did you ever find out what the keys were for?
No.
Do you know who found the gun that was sticking out from the edge of the black sofa?
I saw it.
Okay. Did you then draw that bring that to the attention of either the lead detective or another officer?
Yes, I did.
Okay. And then that person told you to collect it?
Yes.
Did you collect every projectile that you or others were able to find?
Yes.
Is it common that you find more shell casings than projectiles?
Yes.
Why is that, if you know?
Well, when they're ejecting, but the projectiles is when it hits something, and sometimes they could get stuck in a wall, but it is common to get more shell casings than projectiles.
Okay. But is there a 1-to-1 ratio? If we were just in a firing range and I fired 5 times, is there a 1-to-1 ratio of shell casings, and downrange there would be 5 projectiles?
There would be shell casings all around the foot of where the shooter was.
Sure.
So that's where they were. Further down, I don't know that they could travel that far to hit something.
I didn't ask the question well, I apologize. If a gun is fired 5 times, should there be somewhere 5 shell casings as well as 5 projectiles? Or sometimes there's just a shell casing and no bullet comes out the front of the gun. Does that make sense, my question?
Yes. I don't know how to answer that, not sounding like an expert.
You can sound however you want. My question is real simple. If there are 5 cartridges in a gun and I fire all 5, and it's the kind of gun where the shell casings eject, should there be 5 shell casings somewhere around me when I fired it? And if all I'm doing is firing into that wall right there, should there be 5 projectiles in that wall?
I don't know.
Okay, not knowing is okay too.
I'm sorry.
That's all right. If there had been a projectile inside the deceased and he got carried away, would that be one reason why there were fewer projectiles collected at the scene than shell casings?
Yes.
Were all 8 of the shell casings that you photographed and numbered found inside the apartment that had the door with all the little lettered stickers on it?
Yes.
Do you have any knowledge so that you could talk about what happens when a gun is fired and the shell casing ejects, where it goes in terms of how close to where the gun is fired? And if that's not your area, just say, that's not my area.
It's not my area.
Okay.
It's scientific, but it's not my area. It's gravity is going to pull it down. And if I'm here and I'm shooting, you're not going to find shell casings up there unless there's another shooter up there shooting back at me. If I'm here and I'm shooting, it's going to pop out to the right and gravity is going to pull it down. And so it's going to be in a nice proximity. But let's say if I'm walking, then yes, you're going to find a trail of shell casings.
Got it. Or if you're standing right at the edge of a cliff and you shoot, it could be 1,000 feet away because it falls off the cliff.
Correct.
All right. Do you recall in any of the photos you took any what looked like bloody footprints?
Yes.
Were you able to find out whose footprints those were?
I did not, and honestly, the date of the scene, because it was so bad out there, I just noticed those footprints and I was like, wow, it looks like somebody's feet were outside. They ran inside and then ran back. That's just observation. I just noticed it today.
Okay. But who the somebody is, you don't know.
Whose shoes those were.
Okay. Do you know how many cartridges, call them bullets, the gun that you found under the couch could hold?
I don't know if the magazine would hold 12. I'm not certain.
Okay. And do you know if there was any evidence that the other gun, the one you took a picture of that was in the back of the police officer's car, if there's any evidence that that gun had been fired?
I don't know that it had been fired. You can tell from the picture that there was blood on the gun. And then the shell casing that was sitting out there was as a result of it being made safe, but I don't know anything else about that. And you could see that there were shell casings in the magazine still. There were rounds in the magazine.
Okay. Mr. Rao, do you have any follow-up for Ms. Davis?
Yes, Judge. So you indicated during some of your responses to the questions that, the shell casings, I guess if I'm to understand you correctly, they would typically be found near the firearm that's being discharged. Would that be an accurate statement?
It would, well, the accurate statement would be, it would be near the shooter because you could toss the firearm as you're running or if you're trying to hide it, but it's going to be in a proximity of where you are.
Okay, correct. Unless environmental factors were to take effect, would that be an accurate statement, such as me picking up the shell casing or kicking it as I'm walking or other scenarios? Okay.
Correct.
And then with respect to the shell casings that were found in this particular case, all of those 8 shell casings, were they found inside the apartment? They were found inside the apartment.
Yes, they were.
Okay. Did you find any shell casings near the deceased victim's body?
No.
Okay. I have no further questions, Your Honor.
Ms. Feely, anything else for Ms. Davis?
So you're also aware that there was a firearm removed from that same location, right?
Yes.
Thank you.
That's what I photographed in the patrol vehicle. Okay.
All right. Thank you, ma'am, for your time.
so much.
You can leave all, it looks like an arts and crafts scene up there. You leave it
Looks so messy.
right where it is.
Well,
Thank you.
take the bags back and I'll take that report.
Great.
Thank you.
All right, thank you. Ladies and gentlemen, we're going to take our afternoon break now. We'll try to get you back here a little before 3:45, so about 10-minute, a little more than 10-minute break. Reminder, please don't talk about the case or do any outside research while you're back in the jury room. Feel free to use that hallway as well if you just want to do some strolling, and we'll get you back here soon. Thank you. And remember, no one owns any of those seats. Hello?
Prosecutors.
Oh, I don't know. Let's wait for a second. We'll talk about it. Ms. Feely, anything we need to talk about before we break or when we get back?
No, our monitor's working, so thank you.
Good, not a problem. Let me know. Mr. Abate, anything before we break?
No, Your Honor.
I trust that your advocate is working with the family so that at some point you're going to play the video. I just want family members to know when it's going to be a particularly difficult time so they can. I notice people coming in and out, which is great. It's been working real smoothly. I just don't want anyone to be surprised by something coming up on the screen.
Yeah, I had warned the family about the graphic photos of So I'll do the same thing before I do the video.
Okay, thank you. I'll be back in about 10 minutes. Thanks.
The camera, did you want their device on the prosecutor? It's blank, that's what.
It's blank because they closed it.
Okay.
I'm fine with that. Their device wasn't connected at all, so they couldn't see. We were using the overhead camera, which is working again. And they couldn't see it because their device wasn't connected. And I couldn't, it wouldn't let me through the little, whatever this device controller thing, it gave me that do not enter sign. But you fixed it, so they're in. So as for now, we're good. Yeah. And then Karen, your suddenly got small. Did you?
I didn't put it back on full screen because it just keeps going off.
Okay.
And back on. Yeah.
I mean, it's on right now, so that's good.
Now, but I was put it on full screen. And he could. Usually you sign out. Yeah, he did it remotely to get it going, but then I had to go back. Oh, okay. Okay. Yeah. I don't know, but it's kind of weird. It's like a dosing machine.
Well, not the motorcycle. Someone will be available.
Her last concern is that she doesn't. She's very curious. And texting her, there's a comment section about what people are looking for. And I made sure that there's no if she can come in maybe before the jury doesn't ask the judge, that just feel a little better.
Well, I mean, I'll ask them.
All right, I'm just gonna jump back. Like, what do you need me to do to besides this to like cover to 5 people? This is yeah.
Yeah, I mean, I'm not saying it's stretch. What she is. And then
last one, she yes, she still consistent. She told me that she did pull out, separated from she said that. And she just
she was her gesture was clear on.
But I went back into it again.
So she said she's not sure.
You know, she said she didn't, she did not know that it was separated from her body. Many times, I know that.
Yeah, I was kind of there. She said
she doesn't remember. She says no, beforehand, but it's both. We can't actually do this part.
There, it's a disaster. Yeah. What is it? Yeah, so no, warning that because there's no natural transitions. It's like I don't know, like as soon as I'm in the kitchen. So they're probably confused. It's all hard. Yeah.
Okay,
Can we do that? Use that. For demonstrative purposes. There, we could look at the No, person who doesn't, it's. No, person who never goes back and does it. So.
Yeah.
I would take the other words and then I would tell us three, would like be three done. Because the machines.
Real time. Then I'll be upset.
I will. Well, this one, you said.
You leaving straight? Yeah. You're going straight through, I know where that place is. I'm straight.
So I Tuesday last week.
Thank you.
We traveled on last Friday and just
Oh, you mean the break?
Because I don't know how to say that. Because I think, oh my God. So I did say that.
They wouldn't. So tomorrow would be. Do you want me to go ahead and bring her in? These are the colors. Figure it out. I'm not good with these. So you do it.
Well, can you give me the, someone said.
Okay.
I still got all those big bags of clothes. I had leave.
Okay.
I sent several emails, but they keep changing people.
Yeah, is that true?
Yeah, I'm running out of space.
Yes, ma'am, I'll get it. When did he say the break was? What time did he say?
She said 20 minutes?
Yeah.
I'm not feeling that.
Alright. It's 49, 15, 60. Because let me show you something. I had some, I always feel like I had done individual. But how do you navigate individual? Yeah, this is. You can't pray, you can pray over them.
Did you pray over? So these are the ones you want?
It's the ones that
Okay.
Let's close it all like that.
He asked, probably when it stops talking to us, or it starts doing statements. So I think I have it for you guys, but. So that's fine. Double check.
Yeah. Yeah. I think straight this got that. She did go like that. She said she was done. Yeah. I mean. Well, I guess. Perfect.
It's just the one. So you have to click out. Got it in portfolio. Some portfolio. Ended. Different. This is not. I mean, that's responses.
Correct. Welcome to order, man. See.
Hey,
Hello,
no, you were allowed in here for this case.
I'm coming through, hang out with Miss Stuckey for a little bit.
Okay, good. The next witness is, oh yeah, you need to be cleaning that up. Tape. Wow. You have a roll of tape? I can go get one. I'll go get one. Anyway, my question was, will we get through, I didn't ask it, the next witness today, do you think? Or we should at least get started and see where we get?
Yeah, we need to get started with her.
Okay, we'll do that. I'm gonna go get tape, but maybe you can do the craft work there and we'll bring the, I'm assuming the jurors are ready?
Yes.
Okay, I'm gonna get tape. Kind you want?
That's fine.
Okay.
Well, I appreciate it.
All right, Ms. Feely, are you ready for the jurors to come back? All right, Mr. Hiles, can we bring the jurors in?
Yes, sir.
Deputy Gordon?
Your Honor, before the jurors come in.
We're gonna have to go pretty quickly because they're coming.
She's got real concerns about the.
All right, the jurors.
I can have that camera on instead.
Yeah,
Yeah,
me.
okay. I mean, it'll still be audio.
Okay.
Okay.
There's a president of the county for.
Welcome back, ladies and gentlemen. Looks like you mixed like some of these faces I don't even recognize. Who are you? You've been far away the whole time. We are gonna continue on. Ooh, are those your scissors? Okay. Okay.
don't need them right there. We're gonna fill up the rest of the afternoon with another state's witness, I think. Mr. Hiles, if you'll call the state's next witness.
The state calls, Ms. Stuckey.
Just wait for us for a second.
Sure, Ms. Feely?
You,
Yeah, yeah, but I wanted to have a little more due process. Do you care whether she's? Okay, so that's on you.
Yeah.
Okay. Is that all it was?
yes,
Okay.
Okay. Before we see the raise right here. Swear affirm that the testimony you will give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please go ahead and have a seat. Take and spell your name for the record.
Nivea Stuckey,
Spell
Can you spell your name, please?
Niviha
And the last name?
Stuckey.
Thank you, Ms. Stuckey. And if you could be a little closer to the microphone, so that everyone can hear you. When you're ready, Mr. Hiles.
Good afternoon, Ms. Stuckey. How are you?
Hey.
All right, Ms. Stuckey, I'm gonna go ahead and direct you to the April 30th, 2022, okay? Do you recall that date?
Yeah,
Okay. Where were you living at that time?
537 Sunset.
Okay. And was that your apartment?
Yes.
Okay. What apartment number was yours?
2, sorry.
Apartment 2?
Yeah,
Okay. And was the lease on that apartment, was that in your name?
yes.
Okay. Were you the only person on that lease?
Me and my grandson and my daughter.
Okay. On that date, who was defendant Jason Hall to you?
My boyfriend.
Okay. And how long had y'all been dating at that point?
7 years.
7 years. Okay. And was he at your apartment on the night of the evening of April 30th, 2022?
Yeah,
Okay. And were you expecting company on that date?
yes.
Who were you expecting?
My daughter.
Okay. And were you expecting your daughter to bring anybody with her?
Yeah, my granddaughter.
Okay. And how old was your granddaughter?
I don't know at the time. I mean,
How old is she now?
she's 4.
Okay. I won't ask you to do math.
Okay.
And why was she bringing her over that evening, your granddaughter?
To play with my grandson, which is her cousin.
Okay.
And to go to, I was taking them to the aquarium the next day.
Okay. And your grandson, or cousin, are you the primary custodian of him?
Yes.
Okay. And so they were going to spend the night and you were going to go to the aquarium the next day?
Mm-hmm.
All right. And do you remember when your daughter actually came over?
I don't remember the time per se, but
Okay.
I remember when, yeah.
Okay. And do you remember that when she was on her way, did she give you a call to let you know she was on the way?
I believe so.
Okay. And did she also send you a text when she had arrived?
I believe so. I don't remember.
It's okay. Okay. And do you remember showing those phone call and timestamp to Detective Barry at some point later
I
that
probably
evening?
did. I was going through a lot that day. Like,
Understood. Okay. All right. When she arrived, where did you meet her?
I went outside.
You went outside? Okay. And did you go to the car she arrived in?
Mhm.
Okay.
So, I'm sorry, Ms. Stuckey, when you're answering questions, your answer is whatever it is, yes, no, maybe, I don't remember. But I'll need you, and more importantly, the court reporter needs you to say yes or no rather than because she can't guess if that was a or a So whatever your answer is, make sure you verbalize it. Okay.
Okay.
Thank you.
Okay. Who all was in the car when you went out to meet your daughter?
My daughter, Corey, and my granddaughter was in the back.
Okay. And who was Corey?
Corey is my daughter's boyfriend.
Okay. And how long had you known Corey personally?
I didn't really know Corey. I just met him a couple times through her, but I never really sat and talked to him a lot or anything like that. I just know him to be her. He came over my house like twice, but that was like to bring her or something.
Okay.
But you recognize it, like if he walked in the door, you're like, hey, that's my daughter's boyfriend, Corey.
Yeah, I would know. Yeah.
All right. And when you got down to the car, was your daughter already out of the car?
No.
No? Okay. When you started talking to your daughter, do you remember if she said anything?
No, she just said because we was arguing and that she was gonna take my granddaughter back home. And I was like, we was just arguing. I had my dog, so I was about to walk my dog.
Okay. I want to step back just a little bit. Your daughter mentioned that she overheard an argument. Is that correct?
Yeah, our apartment's small. You're gonna hear anyway.
Okay.
You're gonna hear anything anybody say in there.
Okay. And when you said we were arguing, who is we?
Me and Jason.
Okay. And do you remember what you were arguing about?
About the remote control to the TV.
Okay. How long had that been going on?
I don't know.
Well, 6 hours, 6 minutes.
I mean, I don't know.
Okay. You just don't recall?
I don't know how long we was arguing about a remote. I mean, she probably came up while we was just arguing about the remote. I don't know.
Okay. And when you say you're arguing over the remote, do you mean you're arguing over what to watch on the?
Yeah, because he likes to watch one thing and I don't like to watch it. So I wanted to watch something else. So basically that's what we was arguing over.
Okay. And when your daughter got there, you said she told you that she didn't want to leave the grandbaby.
She was just going to go home because we was arguing.
Okay. And did she say she was going to return?
She said she would have brought her back the next day.
Stop. Ask your question again.
Well, I said, did your daughter say she would return the next day with your child?
Okay. And the objection to that is hearsay.
But I don't think the witness is going to testify next as to the same conversation. And it's to show, it's kind of a foundational question to show effect on the listener as to what's happening, what happens after this incident.
Are you offering whatever the answer might be about whether Ms. Scott was coming back the next morning for the truth of the matter asserted or for some other reason?
I'm offering it for effect on the listener.
Okay, I'll allow it. You can ask the question again.
Okay. And so at that point, did your daughter say that she would just take your granddaughter and come back the next day? Okay.
Is that a yes or a no?
Yes, I'm sorry.
That's okay.
And at that point, did you attempt to get your granddaughter to stay the night?
I mean, not anymore. After she said it, I was just mad and I was gonna walk my dog outside.
Okay.
That's it.
Okay. Did you sit down there and then keep talking with your daughter?
Yeah, because she wanted me to go in the house and I was telling her I was going to walk my dog. I wasn't going in the house. I was going to walk my dog.
Okay.
But she kept insisting for me to go in the house. So
Okay. Do you recall how long this conversation went on?
no, no, sir.
Okay. At what point, or did you end up going back to the house?
When Corey got out the car.
Okay. So was Corey next to your next to your daughter during this whole conversation?
He was in the passenger side of the car.
Okay. And your daughter was driving?
Mm-hmm. And
Okay.
my granddaughter was in the back.
Okay. So he was present for the entirety of your conversation
Yes.
with your daughter?
Yes.
Okay. Do you recall if Corey said anything when he got out of the car?
He him and my daughter, when he was trying to get out, I told my daughter that they could go ahead and go because I'm good. I was living in that same apartment for 5 or 6 years, so I know where I'm at. Like y'all don't have to stand there and watch me go in the house.
Right.
That was my conversation with them. And I guess he wanted to get out just because he heard the arguing, probably, most likely. And that's why he walked me upstairs.
Okay. Did Corey offer to walk you upstairs?
Yeah.
Okay. Did you want the assistance?
No.
Okay. But Corey did walk you upstairs, correct?
No, sir.
Okay. And once you got upstairs, did you go inside?
Yeah.
Okay. I'm going to show you what's already been admitted as State's Exhibit 49. It should pop up on your screen right in front of you. Okay. I know it's kind of dark. Do you recognize this?
Yes.
Okay. Was that your apartment?
Yes.
Okay. And if you walked straight to the back of that picture, all the way to the back wall, what's along that back wall?
I can't see.
Okay. Do you remember what was along that?
A window.
Okay. Did you have any? I'm going to go to show you next what's been already admitted as State's Exhibit 62. Okay. Would that be if you walked in a straight line through the door, would that be the back wall that was in the last picture?
Yeah.
Okay. All right. Did Corey, when he walked you up the steps, did Corey actually come inside with you?
Yes.
Okay. And was Defendant Hall, was he inside the apartment when y'all walked in?
Yes.
Okay. And where was Defendant Hall, where was he seated when you and Corey walked in?
He was sitting on that couch, the red couch.
The red couch?
Mm-hmm.
Yes. You said red couch?
Yes.
Okay. Was there anybody else in the apartment at that time?
No.
Okay. Where was your daughter and granddaughter?
Outside in the car.
Okay. Now, when Corey came in, was there an exchange between Corey and Defendant Hall?
Well, Jason spoke. He didn't speak back, so Jason got up to actually speak to him. I guess you know how they give each other dap or whatever. So I guess he tried to do that, and he pushed him.
Okay. So I know it's you know who you're talking about, but using pronouns, who pushed who? Will you use their
Corey
names?
pushed Jason.
Okay. Now, what type of push? Did he shove him to the ground?
No.
Okay. Was it?
No, basically, no, it wasn't a shove to the ground. It was just a push.
Was it a push of a handshake away? Is that what it
Yeah.
was? Okay. So after Corey pushed the handshake away, what happened next?
Corey reached for his gun and pulled his gun.
Okay.
And when he pulled his gun, I tried to push them back.
Okay. Were you able to separate the two of
Yeah.
them?
I
Okay.
got Corey back, like pushed him out to the door.
Okay. So I'm going to stop there. I want to get back just a little bit. You said Corey pulled his gun. Did he ever point it at anybody?
I don't know about the pointing part. I mean, but he did pull his gun out.
Okay.
But I don't know about pointing.
Okay. So when you're saying you pushed him out, will you please go back to State's Exhibit 49? Okay. So would you have started pushing Corey through the kitchen area there?
Yeah.
Okay. Did you have to use a lot of force, or were you just kind of guiding him out the door?
Guiding him out, pushing him, pushing him.
Okay. And at any time, were you afraid of what Corey was going to do to you?
At that time, I wasn't thinking of none of that. I'm just thinking to get them apart. So, I mean, no, I wasn't thinking of that.
Okay.
When you were pushing Corey, did he have the gun in his hand or he already put it away?
I don't remember. He had to if he pulled it out. I don't remember putting it back in, but
all right. Now, as you were pushing him out the door, could you see Corey out the door? Could you see what Jason was doing?
no.
Okay. Okay. Did you even have your eyes turned in that direction?
To be honest, I don't remember that. It was a lot.
Okay.
Uh-uh.
And as you were getting him to the door, do you remember seeing your daughter?
I don't remember.
Okay. And what's your daughter's name? I'm not sure I asked you that.
Nirvana.
Okay. What's her last name?
Scott.
Okay. Now, did you ever get Corey out the door?
You just asked me that question.
I'm
I mean, if I
Okay.
kind of pushed him towards the door, I mean, he was out the door.
Okay.
Did you have to push him out or you got him in that direction and he's like, all right, I'm leaving?
I had to push. I pushed him out, basically.
Okay.
All right. Was Corey ever trying to fight you to get back in the house?
Oh, no.
No? Okay.
Mm-mm.
So he was,
When you were pushing him, were you pushing on his belly and he's facing towards that black couch, or were you pushing on his back and he had his back?
He was going towards the door. We was going towards the doorway.
Okay, so you were pushing on his back,
Yeah, to
saying,
the
keep
door.
going to the door, keep
Yeah,
going.
to the doorway. Not pushing on his back. I was pushing him. He was in front, and I was
Right.
pushing him that way.
Right?
Yeah.
But if he's walking towards the door and you're behind him,
I'm walking him towards the door. That's what I'm trying to tell you. I'm walking him towards the door.
right, but you keep putting your hands up like this. Is he in
Yeah,
front of
see,
you
that's
or
why I didn't
behind
want
you?
to do this, because this is something that is too much for my brain right now.
Okay, well, listen to my question. Was he in front of you or behind you as you were helping him get to the door?
I was in front of him.
You were in front of him?
Mhm.
Okay.
okay. And all right. Once he was outside, did you close the door?
The door was closed.
Okay, you closed the door.
Mhm.
All right. What happened after you closed the door?
All I know is I just heard the gunshot.
Okay. You just heard gunshots.
Mhm.
Okay. Do you remember where those gunshots were coming from?
From the house.
From the house?
Mhm.
Okay. How many? Do you recall?
I don't remember that.
Okay. Did you ever, so they were coming from inside the house, out the house?
Yeah.
Okay. Were there any gunshots that were coming from outside into the house?
No.
No? Okay. After the gunshots, what happened next? What did you do?
I opened the door and I seen him laying on the ground, so I ran to him and held him, and I don't know. It's
Once he was on the ground, was he ever able to get back up? No.
he was on the ground.
So he was never able to come back inside. Okay.
I know you shook your head. That's a no?
No.
Okay.
Okay. Now, at this time, were there other people that came outside in and around Corey directly
Yeah,
after?
but I don't know them. I don't know who it was. I don't know none of them.
Okay. But was there more than one person walking back and forth in that area?
I don't remember.
Okay, that's okay. Now, what was Defendant Hall doing at this time?
I know he came outside, and then he went back in the house, and I don't know what happened after that. I didn't follow him to find out where he went, or none of that.
Okay. Okay. Did anybody else? Where was your daughter after you opened the door?
She was I think she was on the steps. I think she came by too. I mean, she was with me when Corey was on the ground.
Yeah. Yeah. Okay. Did you call 911?
I don't know if I called 911 one time.
Okay. All right. Now I'm going to circle back around a few times. Do you remember talking to Detective Barry after the incident?
Yeah, but I don't remember everything.
Okay. Do you remember telling Detective Barry, no, Corey did not point a gun at Jason?
I never told her that.
Okay. Okay. Do you remember telling Detective Barry that you saw the gun come off of his waist, but not pointed at Jason?
I don't remember.
Okay. And do you remember telling Detective Barry that you were just screaming at Jason that you didn't have to shoot him? No?
No.
You don't remember?
Nope.
Okay.
Is that something that happened?
What?
Did you say to Mr.
I don't
Hall?
remember it. I don't remember.
Okay.
I don't remember.
So you're not saying you didn't say it, you're saying, I
I'm
don't
saying
remember.
I don't remember.
Okay. I heard your words.
Now, had you ever had any confrontations with Corey before this? Anything?
No.
Okay. Everything always civil?
Yeah, he never did anything. He was sweet. He never said anything bad or anything wrong or anything I heard he did, but
okay. Do you recall, what did Defendant Hall do after the shooting happened?
I don't know. I don't know what you're trying to get at.
I'm just asking. Did he stay?
I don't know. I wasn't worried about Mr. Hall.
Okay.
So I don't know. I wasn't trying to find out where Mr. Hall was or anything.
Okay.
I was worried about my daughter and Corey laying on the ground. I wasn't trying to see where Mr. Hall went or what he did.
Okay. Do you remember if he remained on scene?
Who?
Do you remember if Mr. Defendant Hall, did he stay?
I didn't even know none of that. I don't know.
Okay. Okay.
Well, did you ever see him again after this happened? Mr. Hall, did you ever see him again?
No, but Miss Berry we had called him but what I'm trying to tell y'all is that wasn't my concern to try to find out, like I wasn't running to try to find out where Jason was.
I understand. My question was just, did you ever see him again after
No.
Mr. Blunt got shot?
No.
No?
No.
Will you go to State's Exhibit 50, please? Now, is that the view through the kitchen of where you would have pushed Corey out the door?
That's not my house. That is not my house.
Sorry. Let's see. You go back to 49. Okay. Is that your house?
Yeah.
Okay. So is that that's the view through where you would have pushed him through the door?
Yeah.
Okay. Can you point out where you were standing when the shots were fired?
That's hard for me to do because I really can't tell you where I was standing.
Okay.
Well, there are 8 bullet holes in the door, so I guess you weren't standing in front of the door.
Of course. So
Okay.
I don't know.
You don't know beyond other than that.
I don't know.
Okay. Do you recall how quickly from shutting the door to when the shots rang out?
No.
Okay. All right. I want us to go back to the conversation you were having with your daughter when she first pulled up. Okay. And I believe you stated that Corey was present for that conversation.
He was outside in the car.
Okay. And so during that,
Can you, if you don't need the picture, can you take it down? Is that all right?
Yes.
Thanks. It's just easier for me to see what's going on. Let me interrupt for 1 second. Did your machine turn off again? Okay, thank you. Keep going. I'll get it fixed. We can press on. Just let me know next time that happens. Thanks.
So were you describing to your daughter about the argument that you were having with defendant Hall?
I don't remember.
You don't remember? Okay. Do you ever recall talking in front of them about an incident where Mr. Hall sliced your tires?
No.
No? Okay. Do you know, just have an idea of how long between when your daughter first pulled up and the shooting? Do you have an idea of how long that was?
Say the question again.
From the time that your daughter arrived until the time that Corey was shot and killed, do you have an idea of that time frame?
No?
No.
Okay. Do you remember going back to your conversation with Detective Barry? Do you remember telling Detective Barry that your lease was going to expire in May of that year?
No.
You don't remember?
No.
Okay. Do you remember telling Detective Barry that you planned on leaving Defendant Hall once your lease expired?
I probably did. I don't remember.
Okay. And do you remember telling Detective Barry that you had wanted to leave Defendant Hall on multiple prior occasions?
No.
No, you don't recall saying that? Okay. And then when you were describing why you were hanging out, why you didn't want to go back into your apartment, do you recall telling Detective Barry that, I didn't want to go back in my apartment because I just needed a minute to be outside after the argument?
You had to walk my dog, yes.
Okay. And was that just to cool your head, cool off?
To walk my dog.
Okay.
When you arguing with somebody, you don't want to go straight back in there and look at them again. I mean, I wanted to walk my dog. I do that all the time.
Okay. Okay. That's all the questions for now.
Okay. Ms. Feely, do you have questions for Ms. Stuckey?
fair to say this argument over the remote was not like World War III, right?
No.
It was not, and you mentioned that they're very thin walls so people could hear.
Yes.
Right? And you could hear other people arguing as well.
Yes.
And so you went out to walk your dog and you knew that your daughter was.
My
gonna be out
daughter
there.
was out there.
And it's fair to say that Mr. Hall and Mr. Blunt weren't friends. They didn't know each other, right?
No.
And they weren't enemies either. 'Cause
No.
They didn't know each other. Thank you. All right, so talking about the incident itself, you did not need somebody with a gun to come protect you from this remote argument. Is that fair?
I mean, no, I didn't know. To be honest, I didn't know any of that was gonna happen the way it did.
And it happened
Else,
really-
I wouldn't. I wish I would just never had my daughter to come over there in the first place.
And it happened really fast, right?
Yeah, really fast.
So Corey comes up and again, does not know Mr. Hall. Is that right? But comes in his apartment anyway.
Yes.
And even though Mr. Hall doesn't know him very well, Mr. Hall stands up from the red couch, right?
Mhm.
And he tries to shake
Yes.
Mr. Blunt's hand. Is that right?
Yes.
And Mr. Blunt, who is in Mr. Hall's home, you said pushes the handshake away. Is that right?
Yes.
And I want to clarify, Mr. Hall was there most of the time with you, right?
Yes.
You were in a relationship. So this was Mr. Hall's home as well.
Yeah.
So, and I think I want to make sure I have it clear. Mr. Blunt, after pushing Mr. Hall, pulls out a gun. Is that right?
Yeah.
And you don't remember if he pointed it, right? But
You need to answer out loud.
No.
But it's fair to say that Mr. Hall and Mr. Blunt were very close to each other
Yes.
because he had just pushed his
Yeah.
handshake away. So maybe from this machine, he pulled out his gun like this and he was face to face with Mr. Hall.
Yes.
And then after he pulls out his firearm, Mr. Hall at that point does not have a firearm. Is that right?
I didn't see one at that time.
And so you described you were pushing to separate them. Is that right?
Yes.
And I want to make sure I have it clear. You were pushing like his chest, right? He was backing up.
Yeah.
Whose chest were you pushing?
Corey's.
Okay. And was this back by the red and black couches, or are we in the kitchen? Where did this face?
In the kitchen.
In the kitchen.
So he's still facing Mr. Hall as you're pushing him towards the door.
Yeah.
So the last time that Mr. Hall saw Mr. Blunt, he had the firearm in his hand and you were pushing him out the door.
I was pushing him out the door.
And you said you didn't remember him putting the gun back, right?
No, I don't. It's a lot I don't remember.
But you definitely saw him pull it out, right?
Yeah.
And you and Miss Scott went to tend to Mr. Blunt after.
Yes.
And would it surprise you to know that there was not a firearm when police arrived around Mr. Blunt?
You said what?
Would it surprise you to know that when the police arrived, there was not a firearm with Mr. Blunt?
Would I be surprised? I don't know. I don't know how to. If it wasn't there, it wasn't there.
Understood. But you and Miss Scott were the only two that were tending to him at first, right?
Yes.
And you didn't take the gun?
No.
Thank you.
Mr. Hiles, any redirect of Ms. Stuckey?
I did. So Ms. Stuckey, that was your apartment, correct?
Yes.
You're the only one on the lease, correct?
So yes, you need to answer the questions again. You're not going to leave till you answer all the questions.
Yes.
So just get through it.
And do you remember in your interview with Detective Barry, telling Detective Barry that Defendant Hall had a separate address in East Point that was where he lived?
No, that's where he used to live at. That was another address for him if they wanted to. That's the address that he have on his paperwork. It's a mailing address and all of that. That's all that I know.
Okay.
And when the family was trying to jump at me, that's what I had to give them that address too. So
I'm gonna show you a video.
What exhibit are we working off of?
Exhibit 123.
See, this is what I'm saying. See, I was threatened before, and for
So,
me to
so
be on
stop
live,
talking, stop
for
talking.
me be
If,
on
if there,
live,
if there's something we need to talk about outside the presence
I
of the
did
jury,
ask
we
them
can
to
do that.
let me do that with you
Okay, okay,
before.
stop. Are we able to get the video up or not?
It's playing, but not on the computer, on the screen.
I've shared my screen, Your Honor, but for whatever reason, it's not displaying on.
Okay. Well, why don't we take a 5-minute break for the jurors while you work on that, and then I'm gonna chat real briefly with Ms. Stuckey.
All right, jurors.
You okay?
Thank you.
All right, tell me your concern, Ms. Stuckey.
My concern is that I was threatened for my life. They kicked my door in. They put stuff all around, so I'm scared. I'm hearing the noise out there, so it's scaring me. I have a grandson. I had nothing to do with what happened in that house that day. So for them to be sitting here and I'm scared for my life.
Okay, I appreciate your concern. I really
I told
do.
them to tell you that I really didn't even want to be in here.
But and in fact, that was shared. It's not an optional thing. I think you can understand why everyone is taking real seriously the fact that someone was shot and killed.
Yeah.
And a jury needs to decide.
But I also need to decide how I'm going to live when people threatening my life.
Well, and there ought to be some resources that are made available to help you with that. I think Mr. Hiles can talk with you about that afterwards. Already taken some steps so that you're not on the camera, et cetera. When you're done, I'll make sure you get out of here before anyone else leaves the courtroom, and the DA's office can make sure you get safely out of here, okay? So I don't think this is easy. I get that. But I think you get how important it is that a jury hears from people who were there when it happened. And they are hanging on your word because you were in the room when this happened, okay? All right. How are we doing with technical stuff?
I'm gonna attempt to do it if I can.
All right, Ms. Feely.
Yeah, so this was the one where I do object to one portion of the video is not being relevant, it's extremely inflammatory, it's just after the fact, everybody's screaming. So we are asking the court to exclude that portion of the state's exhibit, and they're very short clips, so the court.
Would one of the people who's screaming be Ms. Stuckey, so it will go to her state of mind at the time? I don't know who's, maybe we saw it during the immunity hearing, but.
You have both Ms. Stuckey and Ms. Scott being the one who was screaming, and Ms. Scott's going to be testifying directly after this. No, I can definitely go to her state of mind.
Okay, all right. Why don't we play it real quickly so I can see it and.
That's the first. It's in clips from the Ring camera. That's the first clip, and then
So this would be the clip, Judge, where you hear the screaming.
Okay. While you're trying to get it to come up, Ms. Feely, I'm going to overrule your objection. I do think that it is relevant to state of mind. I think there are a host of questions that could be asked of either Ms. Scott or Ms. Stuckey that are relevant to how they processed it, that would affect then their interaction with Detective Barry, et cetera. There's no question it's prejudicial, but I also think I find that it's highly probative to some of the things that have come up just now in Ms. Stuckey's testimony about not remembering. And this would show, I think, one reason why she might not be remembering because of the trauma of what happened and how she was processing it. How are we doing with the defense machine? He just left. Okay. How are we doing with getting those videos up? How did you get one up but not others?
We're playing it the exact same way.
We have to exit out. There's 4 clips, and every time we want to play another clip, we have to exit out.
Okay. How many do you want to play with Ms. Stuckey? All 4? As long as you figure out how to do it. I just don't want the jury sitting here while you labor through it.
I think we would have to exit out of the Zoom every time we finish with one video and restart. I think that
Okay.
should be fine.
So do one now so I can see how long that process takes, please. Any idea why that keeps dropping off and how I can make it come back on?
So it might be the access. I need to take a picture of it and send it to county IT.
Okay.
If that's acting up, then you're gonna have connection issues.
Okay. Please take a picture. We're on hold right now. They're having their own technical issues, so.
Playing clip number 2. Or screen. Or screen. So both Mr. Abate and myself tried it on our own separate computers, and for whatever reason, despite clicking the share screen and playing the video, it's not populating on the other screens.
So let's come up with a workaround because I don't want Ms. Stuckey to have to come back tomorrow. So we need to figure this one out. Go for it. Plug it in the big screen. Do you need anything else, or did you get the picture of what you needed, or?
I got the picture. Should I?
You think you can help them?
Maybe.
Great, offer it up. We won't call you down here normally if they can't play something, but we're just trying to play a couple videos and it wasn't sharing well. So you need to know it'll only play on that screen when you do that. It won't come on any of the other screens. So Ms. Stuckey's not gonna be able to see it. Unless, I mean, she can turn and look, but while you're trying, well, let's see. You wanna take a quick break? Or are you good? Go for it. Do you have it on a thumb drive that I can try from this? Or it's just on the?
You're hardwired into the, it's not
We'll
wired.
see. Or it'll completely corrupt my device. Where are the USB ports on this? Are they on the bottom? Are they here?
They're on the bottom on the right side.
Okay.
Sorry, left side.
Left side? Boom. Where would I find it? Jason Hall exhibits.
Go to Jason Hall.
Jason Hall, yeah.
And then all the way on the bottom.
Surveillance video. There they are. All right, let's see what happens. And you want to play, well, I'll just see if I can get one to work. So that one worked.
Are you good, bro? Yo, good. You said that we put this on me, bro.
The what?
When you play, do you have a blank?
That one worked. I can see it on there. You can't see it?
It's a blank. It's the same screen we had when we were sharing. It's all blank.
You could hear it.
We could hear it, but it's all blank.
Are you good, bro? Yo, good. You said that we put this on me, bro.
Hold on. Let me try something different. Worked. I can see it on there. You can't see it?
It's a blank. It's the same screen we. Blank.
You could hear it.
We could hear it, but it's all blank.
Are you good, bro?
You guys really should have figured this out in advance, but let me see if I can. One other.
It worked on. Yeah.
I practiced on the Zoom for an hour.
Same screen we.
You could hear it.
We could hear it, but it's all
I don't
blank.
understand what's playing. You guys really should have figured this out in advance, but let me see if I can.
Judge, I think it's like an overall, like, yeah.
Practice on the Zoom for an hour.
So do you see nothing on your screen?
You could hear it. You could hear it, but it's all
You see the video now? Okay. You guys really should. Do you see a video now?
No, sir.
See nothing on your screen? All right, hold on. I can do one at a time. It'll work, but you got it. You can't just say number 2. I need to know which one it is you want to play. How many do you want to play for Ms. Stuckey? All of them?
Yes.
Okay. Is there a particular order in which you want to play them?
1, 2, 3, 4.
They're not numbered that way.
I'd have to look, Your Honor.
They're in order. The first one.
So the way they're listed here?
It should be the way.
So here would be the first one. They're not numbered that way.
I'd have to look, Your Honor.
So the way they're listed here? You see it would be on the screen. Is that the first one? Okay, so I'll play them in the order they're listed. I'm gonna need to figure out how my voice won't come across. I'll just be quiet. But I think we can do that. All right. Anything else before we bring the jurors back out here? When Ms. Stuckey is done testifying, can someone get her out of the courtroom and out of the building without her having to interact with anyone else?
There will be an investigator present.
Okay, here in the courtroom, not right outside, but great, there's an investigator right there. Excellent. Ms. Feely, anything before we bring the jurors back in? Okay, don't bring them in quite yet. I'll make sure this is gonna work.
Screen went out too.
The big screen went out?
You can see the Vizio above your head, though.
Tough day for Zoom. We really need to have the IT folks just live here with us. I don't want to do it without that big screen. It probably got jacked up from trying to plug into it. Is there anything on the screen? My face. That's not what they need to see. Ms. Hansberry, can you get IT back down here, please? Thank you. So what we're gonna need to do is play, the videos are short, we'll play them all the way through a video, and then you can ask questions. I don't wanna try pausing and you ask questions, so video 1 we'll play through, you have whatever questions you have. And video 2, I'll play all 4, you can ask in between, that'll give me a chance to get the next one up, but we're not gonna pause any of them. I'm not confident that that would work. So I tried adding it and it wouldn't find it.
Yeah. It's fine. Connection's fine.
Is there any way we can run an ether? Would it help to run an Ethernet cable to the computer that we're connecting with?
For this one?
Or for any of our laptops that, yeah, 'cause I think it's the Wi-Fi when we're trying to, it's transmitting over Zoom, the connection.
I just figure out how to plug it back in to Zoom rooms. And then Adejuan and I can have a discussion later about why 8D is so plagued.
That 2 weeks.
He's on? Excellent. Can you stay here until 5 o'clock? Because we have to play these videos, and if it breaks down, I need it fixed.
I can, but I need to step out and take a couple phone calls.
Do that, but you'll be like close enough that if he pokes his head out, you're nearby. Excellent, thank you. All right, I think we've got video number one queued up. Do you need to talk about anything else before we bring the jury back in, Mr. Hiles?
Do not.
Ms. Feely, you okay for the jury? All right, Ms. Stuckey, you still with us?
Yes.
All right, let's bring the jurors in, please. Do you need water? You're good.
All rise for the jury. Mr. President, time for.
Thank you, Deputy Gordon. Everyone can be seated. Folks, I want to apologize on behalf of Fulton County Technology, but most of that break was driven by that big screen stopping working and some issues getting the system to talk to the videos. I think we're going to be able to play the exhibits, the videos that the state wants to play from states 123. Do you have any questions of Ms. Stuckey before we play the first video?
No, Your Honor.
Okay, let's see if this works. I think we're going to be able to play the exhibits, the videos that the state wants to play from states 123. Do you have any questions of Ms. Stuckey before we play the first video?
No, Your Honor.
Okay, let's see if this works. I think we're going to be able to play the exhibits, the videos that the state wants to play from states 123. Do you have any questions of Ms. Stuckey before we play the first? Apart from my voice running over that, do you have any questions of Ms. Stuckey now that we've seen video one?
Yes. Ms. Stuckey, that video, could you tell where that camera was positioned in relation to your house?
I think it was pointing this way.
Okay.
Because that's a guy that stayed across the hall from me.
Okay, so it's not your camera.
No.
Ms. Stuckey, that video.
Sorry, I was just trying to put it back on the screen. Do you have any idea, technical person, why the last 10 seconds of what was spoken in court is playing over the video as we play it? I don't either.
Still need someone's device, basically, the IS. That's very odd.
That's Zoom in this courtroom. Okay, I'm going to be quiet for a few seconds and then we'll play video two and see what happens.
Okay, and once it's done playing, can I leave it on the screen just so I can have her point?
Sure, we'll see what I have no idea what's going to happen.
Ms. Stuckey, which door on the screen is your door?
By that rail.
Okay. Is it, you said by the rail, was that the one where the red mop was leaning up against?
Yes.
Okay. And every shot that you heard, was the door closed?
The door was closed.
Okay. And when you closed that door, were you personally afraid that Corey was going to shoot through that door at you?
I wasn't thinking about him shooting me through the door. That wasn't on my mind.
Okay. Were you?
I wasn't thinking about him shooting me through the door. That wasn't on my mind.
Okay.
Is that him downstairs?
That man that came here and put a pistol on me, bro.
Is that him downstairs?
No, he just came here and put a pistol on me,
Who
bro.
is that?
Were you?
I wasn't thinking about him shooting me through the door.
You just stay on the screen.
Okay. Okay. At any point in those videos, do you ever see a gun fall or a gun in Corey's hand?
In the video?
Yeah.
I mean, it was grainy. I can't really see what's going on right now.
Okay.
I just see myself.
Okay. And did you see at the very end, the man that was coming in and out of your apartment? Could you tell who that was?
Jason.
Okay. Did he have dreadlocks at that time?
Yes.
Okay. And
Were you the person with the blonde hair?
Yes.
Okay.
Okay. And do you see Jason in court today?
Yes.
Okay. Where is he sitting and who is he sitting next to?
Oh, right there.
Okay. What is he wearing?
A blue suit.
Okay.
Are you good, bro? Y'all good? He just came here and put a pistol on me, bro.
You have questions about this video? Do
Yeah. Just gonna let it cycle through the.
you want me to leave it up?
Are you good, bro? Y'all good? He just came here and put a pistol.
I'm gonna take it down.
Let's take it down. I
I
don't
have no
think we can-
idea what's happening with the audio.
We'll have to.
That's for tonight.
Yeah. Okay. And you just identified Jason, and was Jason the one that was shooting through that door?
Yeah. Yes, sir.
Okay. And do you recall telling Detective Barry that you felt like the bullets were going by your head?
I don't remember.
Okay. I don't have any other questions, Your Honor.
Ms. Feely, do you have any recross for Ms. Stuckey? All right. Members of the jury, do any of you have questions for Ms. Stuckey? We're going to handle those now. I know we're getting close to 5, but I'd like to finish up so Ms. Stuckey can go and not need to come back tomorrow. So thank you for your patience. Thank you, sir. All right, we'll be right back. You all can be at ease for a moment. Where's All right, Ms. Stuckey, a few more questions. There were keys on the stove in your apartment, and if you want to see a picture of them, we can get the picture up. You know the keys I'm talking about, or do you want to see a picture of them? All right, can you guys make a picture of the keys happen? While they're pulling that up, after Corey, Mr. Blunt, I'm gonna call him Mr. Blunt, but that's Corey. After Mr. Blunt was outside the apartment and the door was closed, did he ever knock or try to open the door to get back in before the shooting started?
No.
No? Okay. Or yell anything through the door before the shooting started?
If he did, I don't remember.
Okay. We heard a little bit about an address in East Point that is associated with Mr. Hall. My question is, was he living 24/7, 365 with you at the Sunset address? Or that is a place where he would be sometimes when?
He lived there.
Okay, that's home for him. That was home for him.
He was living at 22, but he moved from 2210. He was using that as a mailing address.
Okay, 2210
Because
is whatever the East Point address
Yeah,
was.
he was
Okay,
rebuilding it, so he moved out.
okay, and moved in with you. All right. When you and Mr. Hall were having that argument that night about the remote, were you both indoors when it was happening or were you out on that landing?
We was indoors.
Okay, would the windows have been open?
All of the windows was open. It was hot.
Okay.
And I didn't have air. They were supposed to come fix my air.
All right, so people could hear what was going
You can hear
on.
anything in those apartments. I be hearing people downstairs, across the hall. You can
Okay.
hear anything. It's the walls are thin.
Okay, and the windows were open, so
All the windows. And see, my grandson room would be the room that you can hear everything if he was parked out there, and that's what he was parked at.
okay, so it didn't surprise you that your daughter and
me.
Mr. Blunt had heard the argument
It
that
didn't
was going on?
surprise
Okay. Do we have that picture yet?
Yes.
Okay, great.
And that's not one.
Look at that. So those keys were labeled number 3 by the crime scene technician. Any idea whose keys those are or were?
Those look like Jason keys.
Okay, and they would have been keys to,
His truck.
okay. Thank you. You can take that down. Did your daughter come upstairs initially with you and Mr. Blunt? Or only, we saw her on the
Mr.
video?
Blunt.
Only Mr. Blunt came with you?
Upstairs with me.
Okay. And then at some point, I guess your daughter decided to come up because we see her in one of those videos. Okay. Do you recall if Mr. Hall was saying anything while you were trying to get Mr. Blunt out the door?
No,
No, you don't recall, or he was not saying anything?
I don't remember.
You don't remember? Okay. Did you ever see Mr. Hall with the gun or a gun when those shots were being fired?
I didn't see him with a gun.
Okay. I asked you this before, I'm gonna ask it again because it stuck with some of the jurors as well. So you're trying to get Mr. Blunt out of the apartment. I just get these two people apart.
Right.
When you're trying to get him out that door, is he facing you or facing away from you?
He facing me.
So he is looking in the direction of Mr. Hall
Yes.
and you are trying to get him. Okay. So if you were touching him, and it's not an issue if you were, your hands would have been on his chest or his belly,
Yeah.
not on his back.
No.
Okay, so he's looking that way. If the door is behind me, and then you get him out, how does the door close?
I don't know if I closed it, but I would say I closed it.
Okay, regardless, it got closed.
Yeah.
Did you know as you were walking upstairs with Mr. Blunt that he had a gun?
No.
You saw Mr. Hall, obviously, when all this happened, and we saw a little bit on a video that he was still around. After that time, did you see Mr. Hall again in May of
No.
2022?
No.
Okay. Have you seen Mr. Hall, other than being involved with these court proceedings since that time?
No.
Do you recall anything Mr. Hall would have said during this back and forth, the jawing that he and Mr. Blunt were having?
No.
Did you know that Mr. Hall had a gun in your apartment?
No.
Was that your gun?
No.
Did you have a gun in the apartment? So whatever gun was found, there's a gun found.
Yeah, it is.
Okay, but you didn't know that he had brought that into your household?
No.
That night, April 30th of 2022, had you been drinking anything that would make it hard for you to remember what was going on? Anything else you'd put in your system that would make it hard to remember what was going on?
No, sir.
We've seen a whole lot about the door that the bullets went through. Was there another door that led out of your apartment? So if someone wanted to leave and not have to deal with Mr. Blunt anymore, they could get out a different door and leave the apartment?
Front door.
You call it your front door?
Yeah.
Is that the one that leads down and then it's like a little awning above,
Yeah.
a metal awning?
It's brown. The stairs are brown.
Okay. And that's,
Where y'all see the kitchen at in that black chair, there's a door.
okay.
right there.
And that door goes out of your
It goes-
apartment
It goes out of my.
and ultimately outdoors.
Outdoors.
Okay. Did you and Mr. Hall tend to argue a lot, or was what happened that night you guys arguing over the
We
remote
were
something
together
unique?
for almost 8 years, so we're gonna argue.
Okay. But was the nature's the wrong word, but maybe the volume of your voice and his and the way you were going back and forth that night, was that a uniquely loud argument or was it pretty typical for you guys?
Pretty typical.
Okay. And did your daughter, Miss Scott, know that you and Mr. Hall sometimes would argue, or would this have been the first time she ever heard someone talking to you like that?
She knows.
Okay. Did you and Mr. Blunt talk about anything as you guys were heading up the stairs to get you back in your apartment?
No, I don't remember us talking about anything.
Okay. Mr. Hiles, do you have any questions for Ms. Stuckey based on those questions?
I do. Pull up State's Exhibit 62. So the red couch, that's where you said the defendant Hall was sitting when this confrontation took place, correct?
Yes.
Okay. And you see the black couch on the back?
Yes.
Did you? Oh, Zoom shut down.
I just looked at the clock. I mean, Zoom's still going. I can see Mr. Hiles, but Zoom may have kicked them out.
Okay, there
Zoom's
we go.
been not
So
friendly today.
The black couch in the back, did you ever put any firearms underneath that couch after the incident happened?
No.
Okay. Did you ever handle any firearms the night of the incident?
No.
Okay. Now, would this have been the area that Mr. Defendant Hall was standing while he was shooting towards the kitchen door?
I don't know.
Okay.
I can't tell you that. I don't know.
Okay. How far would it be to the kitchen door from here, though?
Like right here. My apartment is tiny.
Okay.
But if we're using this courtroom, if you are standing in front of that red and black couch looking towards your back door, how far away is the back door? Is it as far as where Mr. Hiles is? Is it closer? Is it further?
Probably a little bit closer to where he is.
Okay, from where those couches are to be at your back door.
Yeah, my back door is where the kitchen where he was shot at.
Okay.
And is the door, remember the question that was just asked of you by the judge of, is there another door that if there's an altercation you could have exited out of?
There's a door, yes.
Where is that door?
Right by that brown,
Now, is it to the, if you're looking at the picture, can you point to the door on the big screen? Okay. Okay, and that door would have gone out of the
front door.
Okay, and you can leave out of that and get away from an altercation.
Yeah.
Okay. And have you were asked if you'd seen Mr. Hall. Have you spoken with Mr. Hall on the telephone since this?
I've spoken with him.
Okay, how often do you speak with him?
Not much.
Okay. When was the last time that you spoke with him?
Yeah.
Okay, you don't get to agree or disagree with the objection. What's the relevance of the last time Ms. Stuckey spoke with Mr. Hall?
I mean, I think it would go to bias, but I can.
No, you can answer. When's the last time you and Mr. Hall spoke on the phone?
I believe yesterday.
Okay. So the answer was yesterday.
Yesterday.
Yes.
And what's your phone number?
Well, hold on. Yeah. Why don't you just give us the last 4 digits of your phone number?
Yes.
8810.
Okay. And is Mr. Hall behind you when he shoots?
He had to be.
Okay. And prior to police getting there, is Mr. Hall the only person who went in and out of your spot that you see in the video?
Yes.
Okay. And was he continuously going in and
I
out?
don't know. I don't know.
Okay. All right. I don't have any other questions.
All right. If you take the picture down, we'll see if Ms. Feely has any other questions.
Said that Miss Scott didn't come upstairs with you, right?
No.
And in the video, it shows Miss Scott she was not on the landing when this happened, right?
No.
So if the government said that she was pulling Mr. Blunt's hand and she was up on the landing with him, that would be incorrect. Fair?
I didn't see it, so I can't say I seen it.
That's a fair answer. So you did not see on the video Miss Scott on the landing, but prior to the shooting?
You talking about in the video? I wasn't paying attention to that.
Okay. Fair enough. Thank you.
All right. Ladies and gentlemen, we are done for the day. I appreciate you all staying a little late. Tomorrow, we'd like to start as close to 9 as we can get all 14 of you here. If you run into any delays, please call my chamber's number. Someone will be here. We'll answer. And if we need to get Deputy Gordon in the sheriff's helicopter to extract you, we'll do that. Please, tonight, when you go home, don't talk about the proceedings today with family members or friends. Again, well-meaning people are going to say, hey, let me tell you how you need to understand what you heard. Don't go into those kinds of details. Clearly, no outside research. You're doing a great job. If you've got questions, you clearly know how to ask them, and please limit it to that. Enjoy your evening. Think about other things. We'll see you at 9 in the morning. Any logistical questions from anyone? Don't take your notepads home. Leave them on the table in there. And if we're running low on any supplies, let Deputy Gordon know and we'll try to restock. Thank you so much.
All rise reserved.
All right. I just want to let them get out of here. I want you to go now. Who is going to be walking with Miss Stuckey? All right. You go with that funny looking guy. Okay. Mr. Abate, Mr. Hiles, anything we need to cover before we pause for the day?
Only, Your Honor, I guess I'll bring to everyone's attention now, based on, I know, based on the testimony and what I understand the argument's going to be, because Mr. Jarvis can't be present, we're gonna probably bring in somebody from the GBI, Julie Riley, to talk about shell casings, ballistics. They're not on the witness list, so I want to make everyone aware, but we're gonna have somebody who can at least substitute, not his actual conclusions, but talk about generally shell casings, what happens when a gun is fired, where shell casings go, what happens to projectile, things of that nature. Because I think that's gonna be some glaring questions as it relates to the jurors as they continue.
So I'm clear, and thank you for flagging that. It's Ms. Riley.
I gotta make some calls tonight.
Whomever, but the GBI person is going to offer zero expert testimony linked to some evidentiary analysis. It would be what I call an educational expert, like an Anique Whitmore coming in saying, here's how forensic interviews work. This is someone who could explain that a cartridge has a bullet and a shell casing, and if you shoot a gun 4 times, there'll be 4 shell casings and 4 projectiles. And this type of gun, the shell casing ejects to the right and to the rear. It's that type of, I know about these things because this is my line of work, as opposed to specifically in this case, I can tell you this cartridge, this shell casing came from this gun.
She will, that's correct. There'll be no testimony about what shell casing came from what gun, as it relates to this case, just an educational background. And to answer a question that you asked of crime scene tech Davis, that yes, 4 shell casings, 4 projectiles, but the shell casings are much easier to locate because the projectiles are traveling at hundreds of thousands of miles in velocity, and you have no idea where they're going.
Okay. Ms. Feely, I'm gonna let you, well, hold on. Anything else, Mr. Abate or Mr. Hiles, that we need?
What's gonna, are you gonna,
I just need one person talking, Mr. Hiles.
or my biggest concern is the video issues, based off her testimony and what I know would be coming. We're gonna have to be able to queue up videos, and we've worked together and practiced this, going to actual timestamps. We've got them all mapped out.
You're talking about the 4 videos that we struggled with today.
Not just the 4 videos. I believe there's probably some, I know there's gonna be some videos that will be used to, for impeachment purposes, and.
These would be videos of statements that were given?
Yes.
Okay.
And, I know that Mr. Body and I have gone through and put the timestamps out. When we do it in real time in our office, we don't have this lag, and
right.
If we need to secure another video monitor.
So for the latter category, where it is a static, here's a person on a screen in an interview, I think if you commandeer this one, that'll work out all right. For the others where it was a pretty dynamic scene, I think it was important that the defense be able to see it on their screen, and I needed to be able to see it, et cetera. So for the 4 little Ring camera videos, we're going to continue to run into an issue that IT needs to help us with. If you can get a tech person here who can get one of your machines to talk directly to, we call it the gallery thing, that's how you can do, if Ms. Stuckey gave a recorded statement, or Ms. Scott, or something with Mr. Hall, I'm okay with you doing that, even though it'll only be on one screen. Because really it's the audio that you're wanting to share. The jurors will be able to see it, but Ms. Feely's not at a disadvantage if she doesn't have a bird's eye view of seeing what's on the screen, because it's the words that are spoken.
The 4 Ring camera videos will be much more important towards Ms. Scott, because even in the way we saw them today, you didn't see them in real time, and there was even a lag when they played and they jumped.
Okay, well, I can try to get our IT people here early tomorrow. You guys can certainly come in before 9. I get here real early and try to get things not necessarily queued up, because your next witness may have nothing to do with videos, but we can at least figure out if there's a workaround to what, through no fault of the DA's office, was a real balky setup today. I was having some weird voiceover over these videos, and I had nothing to do with them. So we need a better approach than what happened today, and I need to get you your jump drive back. So I'm happy to reach out to IT to say, you need to get down here and help out. I have seen your IT get you guys hooked up to that. And if you want to, now that the defense has seen, I know they'd seen them before, but those 4 videos, if you can get a smooth way to run all your video stuff through the gallery, I'm willing to default to that for the video. And I mean, assuming the audio works with it.
Would you have a problem if I brought, I'm sorry, would you have a problem if I brought our Mondo board, the one that we used during MacGyver, which it works, it's touchscreen, it's easy.
You just want to get in here early enough tomorrow that we can find a place to put it so that we know jurors can see it, and there's a way, at least Ms. Feely could see it, but she may say, I want Mr. Hall to be able to see it as well. And it's tricky if the Mondo board won't talk to the system, but maybe there's a way to get it to talk to Zoom rooms. But I'm open to any approach that will make the video stuff work better. I apologize that we don't have a good system here. I don't know if we went 2 courtrooms down, if it wouldn't work better, but this is where we're stuck for the trial.
I think it's 8-4.
I guess you'll just need to get here a little early tomorrow so we can work out some of that technology, especially if your first witness is someone with whom you're going to want to use it.
I'll probably get here like I did this morning around 5:36. So can I get, what time was the earliest you get here?
I get here at a little before 8. So I could get you in here by then. But if you want to get in earlier, that would depend on when the deputies get here. I know he doesn't get here at 5:30 or 6.
I'll get to late.
Okay. All right. Anything else from the state side?
No, Jay.
What about using Mr. Hall's immunity testimony? Is that going to happen tomorrow? And so do we need to navigate how redactions would work?
If it happened tomorrow, it would be later in the day after lunch.
Okay. Ms. Feely, have you had a chance, your team had a chance to identify the areas of concern? I understand there's an overarching objection, but since some of it's coming in, the parts that you think, talking about Puerto Rico, things like that, have you identified those topics? Great. That's part of the team. Excellent. And does that mean you found timestamps or?
Timestamps and pages and lines of the transcript, Judge.
Excellent. And you've pushed that across to the state's team?
Not yet, I certainly can.
Okay, please do. And then actually include me in that because I may be able to rule just from looking at that. No, that's going to come in. They don't need to worry about it. But other parts I've said, you're going to need to figure out how to jump past it. And you may have already decided you're playing different segments than the ones that involve Puerto Rico. You may want to home in. You mentioned that there's a reenactment that you may want to show. That's not going to involve Puerto Rico. So that would be fine.
Where are we with the video versus our request for transcript or audio?
So other than the fact that Mr. Hall is not dressed in civilian clothes, I don't have an issue with the video. I don't see a basis to prevent one side or the other from playing the video. That's the most complete presentation. You don't run the risk of someone putting the wrong emphasis on words that could make testimony worse for Mr. Hall by raising a voice or this or that. It's actually what was said. Audio to me would be the natural default to get around the jail clothing. I forgot that there were reenactments. I don't know how germane they are yet, but I could understand why the state would want to use that. It may be that they want to use that after your client testifies, should he choose to testify, knowing that I'll let them play it even if he doesn't testify. And then we wouldn't need to worry quite so much about it. But clearly, if Mr. Hall testifies at trial and reenacts something, and it's fundamentally different from how he reenacted before, we have to play the video. And I tell the jury to disregard what he was wearing. That's not significant to the trial that's going on. But I'm not likely to preclude the state from using video if they can point to parts where it's important to show what was happening on the screen. If they choose not to, and maybe in their case in chief, they just need parts where it's Mr. Hall kind of static at the stand, then audio is fine. It's still his words. And so whatever inflections were used were his inflections and not an actor playing his role. And so then I'd say, let's do audio. But I don't know where the state is on how much they want to play through witness X during their case in chief. Okay.
Just so I'm clear, if I choose to make it easier, let's say, to not use the immunity testimony during my case in chief and wait, to see if the defense puts up a case. If they choose to, just rest, put up no evidence, the court will allow me to reopen evidence and just go ahead and play it.
Well, yes to the first question, you can reopen evidence, but the Puerto Rico evidence probably still wouldn't come in, and you'd still need to explain to me why the jury would need to be able to see it rather than hear it. But I want to reassure you, if you decide you're just going to hold off on playing any of it until you see what happens with the defense presentation, if there is no presentation, I will let you reopen evidence, because this witness, Mr. Hall, is not available, and you don't have to guess. Just as you can't make him testify, the defense can't make you gamble, was he going to take the stand or not, about whether you could use a piece of evidence that is otherwise admissible. And I've held that his immunity hearing testimony is otherwise admissible. It's not hearsay. There are just some parts of it that are more problematic, to include the fact that he's walking around in a jail outfit, and I don't know, he may have had shackles on and things like that. And that's prejudicial. I don't know that it's a 403 issue. The courts have held that just the jail outfit, that's not going to hit a 403 level concern. It will be simpler if you wait to see if he testifies, because you then, whether you play it during cross-examination or as rebuttal, it's much more directly a response to inconsistencies between the two, if there are inconsistencies. But I'm not requiring you to do that, but I'll certainly let you reopen.
I'm leaning towards that, because technology and us don't seem to be great.
Well, in AD, right.
My last question is, previously, when we've done this in the past, we've used testimony from the immunity hearing. You referenced earlier about authentication and a witness that you put it through. previously, there's no witness that you put it through. It's either played or read straight into the record. It's like if a witness was to die, you don't have, you just reenact what the witness and the lawyer said or did during this time.
No, that's a fair point. I was thinking more of that model of a statement Mr. Hall gave to law enforcement. You'd need to have to get in that video, you need that foundation. But this, I would be the one laying the foundation. Yes, I had a hearing and Mr. Hall was here and he was represented. I don't need to do that. So it is something where I would need to introduce it, in a sense, explain to the jurors that there was another proceeding in connection with this trial. I wouldn't call it the immunity hearing or anything like that, but there was another proceeding at which Mr. Hall testified, and some of that testimony is going to come in now through whatever format we agree on. So no, you don't need I don't know who that witness would be. So that's a good question.
I wasn't sure if you were going to bring in a senior judge to sit when we asked you.
Yeah, no, not this time.
Nothing further from the state.
Okay, Ms. Feely, number one, I think you had some objections you wanted to get on the record to a couple of the questions. It ended up being very, very mild, but questions from the jurors about prior difficulties between Mr. Hall and Ms. Stuckey. And you may not care now that you heard what the testimony was, but I don't want to preclude you from perfecting the record.
Yeah, that all was just, we objected because the answer, in our opinion, would call for prior difficulties, evidence that.
Okay, and I think what the record was yes, we've argued before, but we've known each other for 7 years, so of course we argued, but you're objecting to that question that, hey, had you all argued before? Okay, anything else you want to get into the record now?
Yeah.
Okay, you've got clothes for Mr. Hall tomorrow? All right. Then we'll all get together a little before 9 just to see if there are any issues. I'll be here by 8, and so I'm happy to get in here and power things up or whatever you need. Just let me know.
Yes, sir.
Okay?
Thank you.
Thank you, everyone. And I just want to thank the folks. This was a real difficult day with what was coming up. The victim advocate has done a great job of letting you know when things were coming. The way you came in and out of court was perfect. And so feel free to exit and enter in the very same way. I appreciate how you're processing this. I know it's not easy. These are awful videos. Okay? Thank you.